All right, and I am broadcasting from the house this morning. One of my sons had to get tested for COVID, so we all had tested, and we're kind of quarantined for right now, at least until the results come back. Southwest Stage Funding versus Raul Longoria.
Good morning, Your Honor. Cheyenne Zokai here on behalf of plaintiff.
Give me just a moment. Okay. All right, and how long to hear this matter?
2 to 3 minutes at the most. Yeah, it's a motion for default.
Okay, I'll mark you number 1. All right. In the Atascosa County cases, San Miguel versus Peeler.
Yes, Your Honor, we have 2 motions to exclude expert witnesses today, and the Peeler's estimate is that it will take about 1 hour, maybe 1.5 if it goes long, Your Honor.
Okay.
Your Honor, this is Taylor Holcomb for San Miguel, and that sounds right to us.
All right. Do you want to, let me call the Karnes County docket, and then we'll find out how long that I'll excuse you for. Give me just a moment. Actually, I'm at the Wilson County docket. And still on Atascosa, in the matter of the marriage of Rebecca and Eusebio Gonzalez.
Judge, the attorney called this morning, Megan Harkin's office. They filed an agreed order, and it's e-filed.
Excellent. All right, let me get the Wilson County open. First copy I had was corrupted. Let's see if this one will work. Yes. All right. 15-6-359, in the interest of PRS, a child. I saw Ms. Senkowitz.
Yes, Judge. Yes, Judge. If we could have a short reset, we're finalizing an agreement, maybe a week or 2.
Okay. Is anyone on the other side?
No, he's pro se, Judge.
All right. Well, sometimes they show up. Okay.
I've been texting with him this morning, and so I told him I'd ask for a short recess. He's trying to arrange some funding to pay off a loan.
Okay. Ms. Riley, what day did I set a Wilson County case for next week? Yesterday?
Well, I've got cases set on the 8th and the 10th, both on Wilson County.
Both in Wilson.
Either one of those dates are available.
All right. So 8 or the 10th. How is that?
How about let's do the 10th, Judge?
Okay. All right. We'll mark it down 12/10. If you will just send me a text, or not a text, pardon me, a chat message that has the number, just in the interest of PRS and the date it's going to, I'll appreciate it, and that will serve as your reset form.
Okay, I'll do it, Judge.
All right.
I didn't see it. I mean, I see where people all the applications.
Okay, 16-9-529, in the interest of the Miller children.
Your Honor, that's my motion. I see opposing. Our amicus attorney is announcing in Bexar County. So, but we will need, or we are requesting that the court speak with the child over at the amicus attorney's office. So we might need a ruling on that while we're waiting for the amicus.
Okay, you mean through Zoom?
Yes, it would have to be through Zoom, but my client is requesting that not only would the amicus attorney be present on Zoom, but be in the presence of the child at her office.
Your Honor, we would need a hearing on that motion to confer with the child because the child is under 12, and this is a motion to modify on temporary orders. And the statute says the child should be 12 or older.
And the statute actually says that it's discretionary if the child is under 12.
Okay. All right, how long to hear all of this? An hour?
I would say an hour. And then plus if the court grants the motion to speak to the child.
Okay. Thank you. The matter of the marriage of Megan and Anthony Anderson.
Case was dropped to Judge.
All right. Matter of the marriage of Elizabeth and Roberto Sanchez.
Judge, we're going to mediate that case this Friday, so we're going to drop that sitting for now.
All right, reset on request. In the matter of the marriage of Mirabel Palacios and Justin Fish.
That's just an order, Your Honor. We just, I believe we dropped that. It should be, we'll get a new date for entry of order. It's already been proven up.
There was a final decree of divorce e-file, Judge, according to Jennifer.
Oh, okay.
Copies office, yes.
Yes, and I can forward that to your queue, Judge.
Okay, that sounds good.
Thank you.
In the matter of the marriage of Alec and Caitlin Lerma.
Your Honor, we filed an agreed order yesterday. The only question I have is opposing counsel signed it like with a typed signature, and I just wanted to make sure that's acceptable for your court.
I don't care. I think Mark may authenticate as his signature until we get into a dispute about whether somebody did sign it or not. It doesn't matter to me.
And
Okay.
Judge, that is already in your queue.
Okay, I will look at that shortly.
Okay, thank you so much, Your Honor.
You're excused. All right, in the matter of the marriage of Kimberly and Joe Johnson.
Judge, I submitted an agreed temporary order to the, I e-filed that this morning.
Okay, I will sign it when it gets to my queue.
Okay, thank you, Your Honor.
Matter of the marriage of Ginger and William Schreiber.
Your Honor, you can drop that one. I believe the parties may be attempting to reconcile.
Okay. All right, anyone else told to be here today? Your case was not called.
Yes, Your Honor. And Mr. Cedillos is petitioner. Move it.
Okay, in what county?
It's in Wilson County, Your Honor.
All right, let me go back and see if I skipped something.
We checked it earlier this morning, Your Honor, and I think the district clerk said we had a Rule 11 to set it for today.
Okay, what's the number?
It's CVW 200681.
Okay. And what style?
In the matter of the marriage of Cheryl Howard Owen and Dennis Dean Owen.
Okay. And what do we need to hear this morning?
Well, it's temporary orders, Your Honor, but what I'd like to confer with Mr. Trevino.
Okay.
We'll need a breakout room.
All right. Let me make Ms. Riley the host. So she'll do the breakout rooms. Okay. Anyone else told to be here or appear this morning, your case was not called? All right. Still seems to be several people I haven't heard from, but okay. All right. Wendy Valdez, Kim Johnson, they're part of one of the family law cases?
Yes, Your Honor. They're in the Owens case.
Okay. All right, then. I'll let the attorneys who need to confer. If you need a breakout room, please get in touch with Ms. Riley, and I'll ask the Peeler attorneys. Let me ask you to come back at 11:15. We'll
Yes,
try
Your
and
Honor.
start right then.
Thank you, Your Honor.
Mr. Cedillo and Mr. Trevino, I assigned you out of breakout room 1.
All right, and hold on, Southwest States. Let me sign on to Frio County.
Ms. Riley, can you assign Wendy Valdez to the breakout room with Mr. Trevino, please?
I think there are 2 screens that say Wendy Valdez. So.
Yes, sir. It's my father on one and I'm on the other.
So both of them go?
Yes, please.
Okay, I'll sign you out of breakout room 1. Should get something at the bottom of your computer to accept the assignment to breakout room 1. All right, Mr. Zokai.
Yes, Your Honor.
All right, I looked at the return of service. This was substituted service, and the order on substituted service said that if it was served not personally. It needed to be both posted and sent first-class mail. And the return only reflects that it was posted, not that it was sent first-class mail.
I don't have a first class or certified mail receipt either, Your Honor.
And not certified, but just first-class mail. I think won't pick things up.
Would you like us to reset the hearing then, Your Honor? Till we get
Yes,
that-
if you want to go ahead and mail that out and I guess set it for next month.
Absolutely, that works.
Okay. All right. I'll see you then. Thank you.
Thank you so much, Your Honor. Have a good day.
All right. I do not see the district clerk from Frio County this morning. So,
You want me to call over there, Judge?
no, that's okay. I'm going to send this to Ms. Cruz and then. All right, Ms. Cruz, you need to get the Romero temporary orders. I've signed them and sent them back to you.
Thank you, Judge. I am getting them right now.
Thank you. If you'll get that to the clerk.
Yes, sir. I will e-file that right now.
Oh, they're right here. Okay, and I just sent the Frio County District Clerk's Office a copy of the signed temporary orders in Romero.
Okay, thank you, Your Honor.
All right, and in the matter of the Miller children, can someone post to me in chat a copy of whatever the live pleadings are? I can motion to modify it looks like.
I will attempt to do that. Let me see what I
If
can
you'll
do.
just go to my name in chat, you should have to the right of where you select who you're in chat.
I got it.
A little
It says file.
Yeah,
Okay,
right.
got it. Thank you, Judge. Let me pull it up.
Give me just a minute to work on the lights. I don't know if it's better or worse.
Okay, Judge, I posted the two. We have an application for temporary orders. It is an application to change custody on temporary orders. There's an affidavit attached. And then we also have asked the court to speak to the child, and I filed that motion as well.
Okay, Ms. Tapia, is there a response or a counter motion?
Your Honor, we just filed our answer. Our response is the child is 10. Under the statute, they're asking to switch primary, who has exclusive right to designate the residence of the child in 156.006. Section B3 says the child is at least 12 years of age, and it will express to the court. And again, we would be, the child's not 12, he's 10 years old. And I think the statute's pretty clear that the child needs to be 12 years old to be able to confer.
And Judge, I think what's happening is that opposing counsel is not looking at the reason. We understand that the child is not 12. If we had the child that was 12 and was expressing to the court that he wanted to change possession, which he will, that there are some very concerning things going over at Mom's house. But under the statute, the 12-year-old expressing to the court that he wants to live with the other parent is only one of the reasons that the court can change custody on temporary orders. We would like the court to confer with the child because a lot of the evidence of the very, very concerning things that are going on over at Mom's house are also coming from the child, and the child has expressed these things to the amicus attorney as well, but we would like the court to speak to the child. And back to my original point, changing custody on temporary orders while a suit for modification is pending, the court may not render a temporary order and changing custody unless the order is necessary because the child's present circumstances would significantly impair the child's physical health or emotional development. And that is what we are alleging today. The other statute about conferring with the child in chambers is not tied to this particular statute. It's a separate statute on its own. And so if the court would talk to the child, we believe that that would go to the best interest of the child in this case. And it's very clear that the court does have the discretion to speak to the child in chambers. I think that my client feels very strongly that it's very important for this child to be able to tell this court what's going on. We have alleged drug use in the house. We have, just a very dangerous atmosphere there. We have the child being basically bullied and stuck in his room when mom goes and works overnight, so that and the older children are basically left to drink and do drugs, and the child is left in the house with that atmosphere.
This line of
okay, and I'll give me a chance to look at to read the affidavit, and we'll get started here in a few minutes. Let's call it 9:40. I need to return a couple of emails too.
Okay, thank you, Your Honor.
Thanks, Judge.
Andy, are you on still?
Are you asking Andy Cedillo?
Yes, sir.
Well, he already came back from the breakout room. Apparently, well, I'll wait till he gets on. I don't know if he can hear us.
Hey, Andy. Well, it was actually on the Johnson case. I don't have that order in e-file.
Okay, I thought. All right.
So if you'll just e-file it when you get a chance, and then I can send it to the judge.
The Rule 11? The Rule 11?
Let me look in the file, but I didn't see it.
Well, not yesterday.
No, Andy, I don't have a Rule 11 or agreed temporary orders in e-file or in the file.
For Johnson?
Correct, for Johnson.
Okay. But you don't have, do you have a Rule 11 on the Owen divorce? Victoria, do you have a Rule 11 on the Owen divorce?
Yes, I have a Rule 11 resetting it to today's date.
Okay.
But I thought you had answered to the judge that there was agreed temporary orders on Johnson in e-file.
Yeah, there are temporary orders, agreed temporary orders on Johnson.
Okay, but we don't have them yet.
Okay.
Thank you.
All right. Thanks.
Okay, and is there an announcement in the matter of the marriage of Owen?
That would be Mr. Cedillo's motion, Andy.
You're muted, Mr. Cedillos. Still muted.
Okay, we're gonna need a hearing, Your Honor. And we have a, Miss Owen had a stroke several years ago, and her daughter's gonna translate, so to speak. She can write, but she can't verbalize. I spoke to Mr. Trevino about this, and he's okay with the daughter translating.
Okay.
So long as they're both under oath, Your Honor, I don't have a problem.
Okay, I'll swear the translator in.
Well, no, not a translator.
Well, if she's translating the writing, I'll swear her in as translator since.
Yes, Your Honor.
Okay. All right. Miss, and how long do you expect your hearing will take?
An hour, I think.
An hour.
We'll try to make it as brief as possible, Your Honor.
Okay. Mr. Riley, if you would contact the, just send a blast email to the attorneys on the Peeler case and tell them that we'll make it 1 o'clock so they can go to lunch.
1 o'clock?
Yes, ma'am.
Yes, sir, I will.
Okay. All right. So, and I'm sorry, I only have one monitor here at the house, so I've got to keep clicking back and forth. On the Miller case.
Yes, Your Honor. And I think we have the amicus attorney here as well.
Okay. And who is that? Diane Martinez?
Yes, yes, sir.
Okay. All right. And what witnesses are you expecting?
Your Honor, I have my client, and then we have possibly one very short witness.
And I have, go ahead, I'm sorry.
No, go ahead, Jennifer, I'm sorry.
I have my client and then her 2 older sons, Your Honor.
Okay, all right. And Mr. Miller's name is?
Matthew Miller.
In Your Honor, I have a bit, I'm also scheduled for a temporary orders in County Court at Law in Atascosa at 10:30, which shouldn't take more than 45 minutes. There's only one witness on each side.
Okay, well.
But I've already let the court know.
Contact him and let him know that you're going to be over here.
Yes, I did, Your Honor.
All right, so, and the respondent, Ms. Tapia, your client is?
Is Jennifer Munoz.
And your other witnesses' names are?
Derek Miller and Dawson Miller.
Okay, and where are the Derek and Dawson Miller?
Dawson Miller is here in my office along with Jennifer Munoz's mother, and Derek Miller will be calling in, Your Honor.
Okay, and M. Mill is Matthew Miller?
Yes, that's him.
All right, Mr. Miller, will you start your video? Okay, I'm going to ask Matthew Miller, Jennifer Munoz, and the other Miller son who's present to all raise their right hands.
Let me get them on to our other Zoom camera, Your Honor, please.
All right, go ahead. All right. And where is Diane Martinez?
Your Honor, I just texted her. She said that she's just finishing up in Bear County, and I
Oh,
thought
okay,
she
okay,
was
I'm
here.
sorry.
I thought that she was here too, but I think she said that I just misconstrued what she said, but she said she's headed over in just a few minutes.
All right. All right. I thought we were ready to go on this one.
I mean, we can get started. I know that I know that she wants to express her opinion to the court. I don't think she has a problem with us necessarily just getting barely started on it.
Okay, let me go ahead and swear the witnesses in.
And for some reason, our other thing is not joining in. It's just, but they're going to come in here in my office.
Oh, it joined in.
Oh, it did? Okay.
Yeah, I could see everybody in there.
Oh.
Renamed it, says Pena and Tapia. Can you see it?
Mm-hmm. Okay. Well, he says it's joined. You can check. I'm not showing it though.
I'm asking to unmute.
Is it joined?
Yes.
It did.
Okay, and who do we have there? Jennifer Munoz and who else?
And Dawson Miller, Your Honor.
Okay. All right, well, Matthew Miller, Jennifer Munoz, and Dawson Miller, raise your right hand. All right, and somebody else is connected. Is that Derek?
He was connected.
Yes, Your Honor.
All right, and I can't see Dawson.
Dawson can stand over here.
You can bring your chair.
All right, and you're Derek Miller?
I'm Dawson Miller.
Okay, I'm talking to the one that says iPhone. You in the baseball cap. Can you hear me?
Derek?
Derek Miller, can you hear me? Now it says connecting to audio again. All right, Derek Miller, can you hear me? Derek Miller, can you hear me? Can you hear me? All right, his last chance. Can you hear me or not, Derek Miller? Okay, I'm putting him in a breakout into the waiting room. All right. Matthew, Jennifer, Dawson, please raise your right hands. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Yes. All right, all three of them said yes. Put your hands down. All right, go ahead, Ms. Duke.
Your Honor, I'd like to call Matthew Miller as our first witness.
Okay, and we had, all right, go ahead.
Okay,
And
Mr.
I'm sorry,
Miller.
give me just a moment. I've got to take care of something.
Sure.
I'm right here trying to. I can't. I know. What are they doing? Who's just talking? He's trying to start. Okay. I'll cross-examine Matthew. Okay.
All right, go ahead, ma'am.
Okay, thank you, Your Honor. Mr. Miller, can you state your name for the record?
Yeah, Matthew Dean Miller,
Okay, and Mr. Miller, how many children do you have?
3.
And what are their names?
Derek Miller, Dawson Miller, and Dean Miller,
Okay, and how old are Derek and Dawson?
21 and 18.
And how old is Dean?
10, he turns 11 in February.
Okay, and when did you and Jennifer get divorced?
It started back in the fall of 2016 and was finalized later in the year in 2017.
Okay, and can you tell the court what your current possession schedule is with Dean?
With Dean, I believe the term is expanded modified, which is Thursday through Sunday on my weekends and Wednesday after school through Friday morning when it's not my weekend.
Okay, and so you have basically a little bit more than an expanded standard possession order, is that right?
Correct. I just don't remember what the official term is.
Okay, and in fact, the number of days that you have a year is almost 50% of the time, is that right?
Yes, because it's first, third, and fifth weekends. So I don't know what the exact split is, but it's pretty close to 50-50.
All right. Now, can you tell the court, you filed a motion to modify asking for primary custody of Dean, and we filed this a few months ago. Can you tell the court exactly why you thought it was important to file at that time?
Just basically for the well-being of Dean. He's become very vocal about how just unhappy he is over at mom's, how lonely he is, scared at times, being shut in his room when there's extracurricular activities going on with the older brothers. So it basically just came down to Dean just sharing, what he was scared of, what he was worried about, and being intimidated and being bullied. And Dean's really the one that came forward and just said, I'd rather live with, you, Dad, and just where I feel safe and loved and just treated right.
Okay, and we have Diane Martinez, who is the amicus attorney in this case, right?
Yes, ma'am.
And she had spoken to the child and spoken to you guys and everything, and thoroughly investigated this case. Is that right?
Yes, she asked or required that I bring Dean on 2 visits and that Jennifer brought Dean on 2 visits. And then she has spoken with Dean on the phone via Zoom also. So she spent pretty considerable time with him.
Okay. And is it after she did that investigation, did she express some serious concerns about what was going on over at mom's?
Yes, she did.
Okay. Is it from our previous hearings and from us all talking, is it your understanding that Diane feels that the child would be better at your house?
All right, Ms. Martinez is coming into the meeting right now.
Okay. May I just ask a question? I know Diane has several hearings this morning, and so I didn't know if the court would oblige her to be able to kind of give her opinion very quickly in case she needs to cut out.
I'm here, Judge. I just resolved my last hearing.
Oh, okay, good.
All right, so you've missed about 5 minutes of the introduction of Ms. Duke's examination of her client, Matthew Miller. Matthew Miller, Jennifer Munoz, and Derek Miller have all been sworn in.
Okay, thank you, Judge.
Go ahead.
Should I proceed? Okay. Now, Matthew, at that point, after Diane expressed some concerns about the situation, did we file this motion for this application for temporary orders requesting the court to bring Dean and have him stay primarily with you?
Yes, ma'am.
Okay. And we also asked for some drug testing. Is that right?
Yes, unfortunately, I wasn't allowed to go back as far as I wanted, but yes, we did.
Okay, and I'll get to that. But first of all, has there been some serious problems under mom's care of your two older sons as far as drug use?
Well, when Dawson was still in my possession, he did test positive for drug use. So it was continuing, I guess, to go on over at mom's house. And my older son, Derek, wrecked his truck and called me back in May, I believe. I don't remember the exact date, but I went and I got his truck taken care of and got him helped out.
Mr. Miller, hold on. All right, I thought I admitted only Ms. Martinez, but I see Dawson Miller is back. Mr. Miller, will you unmute your phone? Can you hear me?
Are you speaking to me?
Is your name Dawson Miller?
Negative, sorry.
Okay.
All right.
Hello.
What is your name? You in the hat. What's your name?
Donald Lingerfeld.
Your Honor, that's one of my witnesses, actually. I'm sorry, I've never laid eyes on him before. I've just spoken to him on the phone.
Mr. Lingerfeld, will you remove your hat? Lingerfelt, or is there a D in there as well?
The first, what you just said was correct. Lingerfelt.
All right, please mute your phone. Go ahead, Ms. Duke.
Okay, Mr. Miller, we were discussing the issues with drug use with your kids. Now, you said that was it Dawson that tested positive when you gave him a drug test?
Yes, ma'am.
Okay, and Dawson was what, 17 at that time?
Yes, ma'am. He had just turned 17.
Okay, and what measures did you take after he failed this drug test?
Well, that evening we discussed that, you know, he wasn't telling me the truth. And then after the test, which was, you know, pretty black and white, he admitted doing drug use, you know, doing marijuana, lying to me. And we just spoke that evening and said there was going to be consequences. It was a long, emotional night. And I said, you know, his truck was going to be taken away for a little bit, but in the morning we would talk about further consequences. And the next morning he left and went to mom's and never came back.
Okay. Is it your understanding that there was a much more permissive attitude at mom's after you threatened this punishment?
Oh, absolutely.
Okay. Let's talk about Derek. Now, Derek is on probation, is he not?
Yes, I believe he is.
Okay. What situation did he get caught up in that caused him to be convicted of a crime?
There was some hazing incident in Lavernia, including athletes and minor athletes, and he was charged with a hazing crime.
Okay, and he is currently on probation in Wilson County?
I believe it's in Wilson County. I'm not sure if it's Wilson or Bear.
Okay, now you've spoken to Dean. Has he let you know that these drug issues with your two older sons have gotten any better?
Well, just over the summer, Dean said it was very frequent to have 8, 9 boys over, and he was made to go in his room at 9 o'clock and keep the door shut. And sometimes he would come out and use the bathroom, and said there was drinking and vaping, and he smelled some funny things, but you know, he's 10 years old. He doesn't know exactly what they're doing.
Okay, so at this point, where was mom?
I have no idea. He would say that she was either in the room with him, or, I mean, I don't know. That's the best he told me was that, you know, she was in the room or gone. I don't know.
Okay. Has mom ever, do you have suspicions that mom might be using drugs?
I have no idea. I know she has in the past, but I have no idea currently.
Okay. Now we asked the court to drug test your ex-wife, your two older sons, and only two of them went to go get the test. Is that right?
Correct.
Okay. Now you went in and you paid for 5 months of testing, which would have gone back prior to when we actually filed the suit and everybody was able to try to clean up their act, right?
That's exactly right.
Okay. And then when they took the test, they didn't take that 5-month test, did they?
They actually refused. The testing facility called me and said that they refused to go back further than 90 days.
All right. All right, Mr. Pena, I didn't see that you had appeared instead of Ms. Tapia. Ms. Duke?
Okay, I acknowledged.
All right, I'll sustain the objection.
Okay, Judge. Now, you did get results back from these drug tests, didn't you?
Yes. Yes.
Okay.
I did.
Did they go back? Did they go back 5 months?
No, they only went back 3 months, which was after they were served. Yeah, after Jennifer was served papers.
Okay. Now, can you tell the court exactly why? Well, first of all, let me ask you this: are you aware that your older son has been doing cocaine?
Yeah, after he wrecked his truck and he called me, I was very concerned because it was at 9 o'clock in the morning, going about 60 miles an hour through a ranch, and totaled his vehicle. And, he turned to me right away to come help him. And I did, but I had some serious concerns about, that type of an accident at that time in the morning, where you and I would drive 15 miles an hour on a gravel road through a ranch with heavy trees. And I just had some concerns. And so we met in the Lavernia City Park, and that's when he said that he had been doing cocaine for quite a while, pretty heavy partying.
All right, hold on, sir. All right, Mr. Pena?
Objection, Your Honor, hearsay.
Your Honor, I would say that is goes directly to his immediate state of mind, which makes it not hearsay.
Mr. Pena?
Your Honor, it's still hearsay. It's self-serving, and we will hear from Derek shortly in terms of what took place that particular night.
Your Honor, I would say that under Rule of Evidence 803, that this is either a present sense impression under 803.1, which are excluded against the rule against hearsay, or an excited utterance.
I'll overrule the objection. Go ahead.
Okay. So at that time, your son told you that he had been doing cocaine before he smashed his truck in a very dangerous way?
Yes, he said he had been doing it for quite a while, since last fall.
Okay. You've already told the court that your son Derek actually tested positive on a test for drugs. Is that right?
Not Derek, Dawson.
Dawson, I'm sorry, names mixed up. Derek, cocaine, truck. Dawson, he tested positive for a drug test at your house before he went to live with mom, correct?
Yes, ma'am.
Okay. Now, did Jennifer know about these things?
Yes, she did. I made her aware, and she said that she was taking him to church to speak with their youth pastor. Okay.
And even though these events were going on, did Jennifer continue to leave y'all's 10-year-old son alone with your older sons?
Well, I can't imagine that she would let just large groups of boys come over and party in their apartment.
Mr. Pena, are you objecting?
Yes, Your Honor. Objection, speculation.
That's fine, Judge. Let me rephrase.
Clarify.
Okay. Mr. Miller, just listen to my question and make sure you answer just that question, okay? We'll get to the other part in a sec. Did Jennifer leave your son alone with these older boys?
I know for a fact that she has, because Dean would call me and say that mom was at work.
Objection, Your Honor.
Mom was not there.
All right.
Okay.
What about? Go ahead.
Okay. And Your Honor, this is yet another reason why we're asking the court to speak with the child. But Mr. Miller, Do you have concerns that parties are going on when mom is not home and the child is there?
Yes, Dean calls me and tells me when there's groups of boys there partying.
All right, sir, when there's an objection, you need to pause for the attorneys and the judge.
Oh, sorry.
Mr. Pena?
Again, Your Honor, speculation, objection.
All right, I believe the question was, does he have concerns? And I'll overrule that objection.
Okay, so Mr. Miller, the judge is allowing you to state whether you have concerns about parties being had over there, drug use, et cetera, while your child is left there with your older sons.
Yes, Dean tells me very specifically the names of the boys that are over there, what they're doing, and when he's told to go in his room.
Okay. Now, have you, the older boys have a friend. Mr. Lingerfelt is the father of one of these friends. Is that right?
Yes, ma'am.
Okay. Has Mr. Lingerfelt needed to set some boundaries about his son going over to Jennifer's house?
Are you asking me or Mr. Lingerfelt?
I'm asking you.
Yes, his son is not allowed to go over there any further.
Okay, and why?
I believe, I don't know all the details, but I know that he had a mattress over there and that he would stay over there frequently in the apartment. And from what Mr. Lingerfelt told me, he was doing drugs with Derek and/or Dawson.
Objection, Your Honor.
Frequently
Yes,
had a mattress.
Right, there's been an objection. Ms. Duke?
Your Honor, as far as the objection?
Yes.
Your Honor, I don't have, I'll ask him another question.
I'll sustain it, go ahead.
So, Mr. Miller, you are not the only parent that is having some concerns about Jennifer's house. Is that right?
Correct.
Okay. And this friend of Derek or Dawson's is not allowed to go over to her house any longer. Is that right?
Correct.
Okay. In addition to the drug problems and the dangers that all involves, what concerns do you have about Dean's mental health being primarily over at his mom's?
Mentally, Dean and I talk almost every day that he's with me about being bullied. He feels ganged up on by mom and brothers, intimidated, told that he's wrong, told that he's lying, told that he's being brainwashed, basically that he can't think for himself. He can't even get a haircut without being criticized. And my current wife and I called names constantly. Just the overall, the mental abuse and intimidation and bullying is what he, talks to me about frequently. And that, I just try and help him, work through it the best I can.
Okay. What about the permissiveness that goes on over at mom's? Do you worry that Dean may feel that this kind of behavior is perfectly okay?
Objection, Your Honor. It's leading and it's speculative.
I'll ask another question.
Sustain.
Mr. Miller, what issues do you have with mom's permissiveness regarding drugs and your younger son?
Well, it's not just drugs,
Objection,
it's drinking.
speculation.
Okay, Mr. Pena?
Objection, Your Honor. The cause for speculation.
Overruled.
Again, I asked what his concerns were.
I overrule the objection.
You can answer the question.
Yeah, absolutely. My concern is that when there's vaping, drinking, possible drug use in front of Dean, that absolutely that he sees that that's okay and allowed and it's illegal. Even drinking is illegal. And so I'm very concerned that Dean thinks that that's normal and okay.
Okay, and one last thing I want to touch on. Derek refused to take a drug test, didn't he?
I don't, yes, I believe so. I mean, I think Diane requested all three, and I don't know exactly what went on between y'all that I wasn't privy to, but I know Derek was not tested.
Okay, and part of that reason because Jennifer said Derek's going to move out of here.
That's what I was told.
Okay, do you find that the timing is a little suspect on that?
Well, when you're asked to get a drug test and you move out, so that it's kind of what it looks like.
Okay, and in fact, we reached an agreement that Derek, or that you would get possession of the kids overnight when mom was working, because she was leaving the kids at home alone. Is that right?
That's correct.
And did Jennifer violate that?
She did. I know that she took Dean. I couldn't get a hold of Dean one night, and I happened to call his grandmother, Jennifer's mom, and Dean said he was dropped off over there instead of with me, which is what the court order said.
Okay. Do you feel that Dean, there's enough of a concern about Dean, both mentally and physically, that on a temporary order, the court should rule that Dean stays with you?
Absolutely, especially for his mental and emotional, safety.
Okay, I'll pass the witness.
Mr. Pena?
Thank you, Your Honor. Mr. Miller, my name is Renee Pena. How are you this morning?
Good. How are you, sir?
I'm good. Thank you. I want to start off where you, and I'm going to paraphrase you, were talking about your concern about drug use and alcohol use. Do you recall that?
Yes, sir.
Okay. So with regard to Dawson, did you at the age of 14 provide Dawson with alcohol?
No, sir.
Isn't it a fact that at the age of 14, you and he would drink together and you would allow him to become intoxicated?
Absolutely not.
Okay. So if Dawson testified to that, he would be lying. Is that correct?
Yes, to get drunk and drink with my permission, absolutely false.
Okay. So there was also another incident in which your older son, Derek, had been arrested. Do you recall that?
Yes, sir.
In Lavernia.
Yes, sir.
Okay. Did Jennifer call you about that arrest?
Yes.
Where were you at the time that you received that call?
I was in North Dakota visiting my mother.
Isn't it a fact that you were at the San Antonio airport when you received that call?
No, I believe I was on a layover in Dallas, from San Antonio to Dallas to Fargo, North Dakota. And I believe I was just about to board the plane in Dallas.
Isn't it a fact that you were actually going on a hunting trip when you received that call?
No, I was visiting my mother. That is not correct. You can't, the time of year that happens, sir, there is not hunting. That's in the springtime, and there's no hunting in the springtime that I do.
Okay, so you going, I believe, to Alaska would have been incorrect.
I've never been to Alaska in my life, sir.
All right, so let me ask you this. If you had received, and you said you did receive that call that Derek had just been arrested, wouldn't it have been prudent for you to come back to assist your son under those circumstances?
My stepfather was dying from ALS. It was one of my last times to see him before he died. I got on the phone with an attorney immediately and had that set up within 48 hours of that phone call upon my return back to San Antonio. And I secured the attorney. I paid for the attorney.
Okay. Well, I'm talking about your responsibilities as a dad. Did you not think it was important for you to immediately fly back to assist your son under that dire situation?
I did the best I could at that time, sir.
Do you think that would have affected his emotional, mental, and physical well-being?
That Sunday night, he came over and we spent about 4 hours together, sir, going
talking
over
about-
everything. And
Yeah, I'm talking about that particular day that you received the call.
yeah, I can't speculate for him how he felt.
Yeah. So, but you as the dad didn't think it was important enough for you to fly back home. Is that correct?
Over the weekend, I did the best that I could to set up legal counsel, met with Derek when I got back Sunday evening, and had the meeting with the attorney Monday. So yes, and I was in constant communication with Derek about everything that I was putting in place to help him.
All right. Now you were very involved with their sports. Is that correct? That by that I'm talking about Derek and Dawson.
Yes, sir.
Okay. So were you pretty tough on them after games that they played in terms of criticizing them?
No, I was their biggest fan. I coached both Derek and Dawson in baseball, football, basketball. Man, that was a passion we all had. And we have a lot of great memories and spent a ton of time together. Did I want them to always try and do their best? Absolutely. That's, I think, what a prudent dad and coach always wants their kids to try their hardest.
Were you ever emotionally or physically abusive of them?
I have never physically abused Derek or Dawson.
So these boys have had you in their life is what you basically testifying to. Is that correct?
Yes, sir.
And that you've been a good dad. That's what you're testifying to.
Yes, sir.
Then can you explain from your perspective how these boys allegedly have gone so badly if you were involved in their lives?
It's a free for all at mom's house, and that's why they both end up there. They're young men that want to do what they want. They don't want to be told what to do. They don't want direction. They don't want rules. They don't want responsibility. When I give them rules and responsibility, they end up at mom's because there are no rules. There is no responsibility. So it's hard for me to continue to mentor young men and keep them down the right path when they choose the path of least resistance.
So you were divorced in 2017, is that correct?
Yes, sir.
How old was Derek? How old were Derek and Dawson then?
3 years ago, roughly, what is that, 16 and 13, 17 and 14?
Well, one of your sons is actually 21. Is that right now?
Currently, yes.
And the other one is how old?
18.
18. So in 17, that would have been 3 years ago. Is that right?
Yeah. Yes, sir.
So the oldest would have been 18.
Yeah, but the proceedings started in 16 where we were legally separated and reached a agreed settlement in December of 16. So that's why I'm saying it's between that 18 and 15, 17 and 14.
So setting that aside, let's just arguably say that for 16 years, you were directly involved in the oldest life. Is that correct?
Yes.
And then you were involved with Dawson how long before the divorce?
His entire life.
His entire life. Okay. All right. Do you have in front of you a copy of your affidavit?
No, not right in front of me.
Okay. Would you bear with me for just a minute, half a minute?
Sure.
Thank you. At the end of the affidavit, you talk about, or that you think it's in the best interest of the children that you become the sole managing conservator of the children. Is that correct?
Correct.
And why is that?
For the emotional, physical, and mental well-being of Dean.
Okay. And do you think that there's any thought that you share in what has happened with your older two children?
I have no control when they're not in my presence. When they're in my presence, they had rules and responsibility. Now you see they've gone and they're with mom full time, and you see the results.
Right? When did they start having problems, Derek and Dawson?
I didn't notice anything with Dawson until towards the end of his, 17, being 17 years old. And that's why I got the test and self-performed a home drug test. And Derek, so that's when I started to notice Dawson was around 17. Derek got in some legal trouble when he was 17 that I helped him through. And I would say the drinking really became heavy when he was about 20 years old with mom, that I became aware of.
He's an adult, right?
Correct.
At 20.
That is correct.
Okay. And you keep referring to mom as being the reason for that.
Well,
Is
the
that
behavior is not tolerated in my presence, in my home.
Okay. What is the name of your current wife?
Desiree Daniel.
What does she do for a living?
She is a psychotherapist and has her own practice in Bernie.
In Bernie? Isn't it a fact that y'all want to move back to Bernie, Texas?
Absolutely not. That is not a fact. That is a incorrect statement, false, however you want to phrase it.
So you would not be against a geographic limitation to Wilson County, is that correct?
That is absolutely correct.
Okay. Do you know when Jennifer started working at night?
I believe approximately 2 months ago.
So this has been just recently. And how many times have you had Dean over the course of the last 2 months when Jennifer's working?
One time, because the other time he was, she did not follow the temporary order, did not let me know, never provided me a schedule from her work. And she took Dean to her grandparents instead of what the temporary order said, which was to bring him to me. So I had no clue because we were never given a schedule.
Okay. So as far as you know, you are alleging just one time, is that correct?
Yeah, but I would have no way of knowing. I've never been given a schedule.
Are you aware that Jennifer is only working part-time at night?
I've never been given her schedule.
Have you ever asked her about the schedule?
Yes.
And you're telling this court that she's not communicated with you at all?
I have never received a schedule.
You talked a little bit, quite a bit actually, about the illegal use of drugs and alcohol at what location?
All right, hold on, Mr. Pena. You were breaking up for a moment. I'm going to ask you to start over.
Yes, Your Honor. Can you hear me? Can you hear me, Your Honor?
Yes.
Okay. All right.
Yes.
You talked about essentially how there was a lot of drug use and alcohol use at Jennifer's house. Do you know what location that is?
I have the address. It's in an apartment in Lavernia.
So you don't know the address?
Well, not off the top of my head, but I have it. Yes, sir.
Okay. Have you ever made a report with the police officers in Lavernia regarding the safety of Dean?
Yes, I have.
Okay. And was there a welfare check?
Yes, there was.
Okay. And you had an opportunity to talk with a police officer after the welfare check, is that correct?
Yes, sir.
Did the police officer find anything wrong?
No, he couldn't get over there that evening, so he went the next afternoon. And, you know, of course, the older boys, he said, were asleep, and it was just Mom and Dean that he got to talk to, which he kind of expected going over there in the afternoon.
Okay, so no, your answer is no then.
No, I just, yeah, answered what he told me.
Okay. So the officer found nothing is my point.
Not at that time.
Okay. I'm going to take you back to your affidavit where you talk about, I'm going to quote you, I fear for Dean's physical health and emotional development in the possession of his mother. When you talk about his physical health, are you concerned about actual beatings, or what are you talking about?
He tells me that there's vaping and drinking going on a consistent basis. And with admitted drug use, there's no telling what can go on in that environment. I'm not alleging that he is abused, but in that kind of environment, it's kind of like dancing with the devil. It's just a matter of time.
So you're speculating.
Well, I don't think drinking and vaping indoors and partying, I don't think that's speculative. I think that's a legitimate concern.
Okay. Let me take you back to Mr. And forgive me if I don't pronounce this correctly. Lingfield, is that correct?
Lingerfeld.
Lingerfeld, okay. Particularly the young man. Are you aware that he has drug issues?
Who are you asking me about?
The young Lingerfeld.
His son?
Yes.
I did not know of any issues until Mr. Lingerfeld called me.
Okay. So the young Lingerfeld has drug issues, is your understanding. Is that correct?
He has conveyed to me through his son what his son told him he did with Derek and Dawson.
So the answer is yes?
Yes.
Okay. All right. Have you ever seen any physical marks, bruising, things of that nature on Dean?
No, sir.
So the physical health, in terms of actual violence, there's nothing there. Is that correct?
I can't see his lungs. Vaping is pretty dangerous indoors, so I can't see that damage if there is any, sir.
Have you taken Dean to get checked out?
No, I haven't.
Wouldn't that be a reasonable thing to do by a father?
It could be.
No, would it be or would it not be?
That's your opinion and my opinion. I mean, it could be, yeah.
I'm asking you a question. It's not an opinion.
To get him checked out, yes, would be, it's good to take him in to get his well-being checked.
And you said you didn't.
I have not taken him in.
Okay. In terms of the emotional development and has your current wife talked to Dean about that?
We talk to him frequently, just trying to, see how he's doing and just give him our best advice to help protect him.
Okay. And have you discussed Jennifer's role in all of this with Dean?
We have been very consistent from day one that Dean is to always respect his mother, not call her names. He can come to us and he can talk to us, but both Desiree and I take that very seriously, that he is always to respect his mom, not call her names, and we don't allow that.
Okay. So your testimony today is that there's no type of parent alienation against Jennifer. Is that correct?
We actually do not support that.
In terms of your discussions with your current wife, does she give you her opinion about the situation?
We just talk in general with Dean, just again, just to try and help him and just to help him cope while he's going through this.
Okay, and that's done in the presence of Dean.
Yes, he asks us very specific questions and brings certain things to our knowledge. So it's, prudent that we sit down and address it with him the best we can.
And that's you and your current wife.
Yes, sir.
So her practice is primarily in what area again?
Psychotherapy.
Can you tell us what that means?
I'm not an expert in psychotherapy, so please don't hold me accountable for that. But she frequently deals with troubled youth, kids who suffer from parents who are drug addicts, there's sexual abuse, children in divorce, even adults who are struggling in their life, secondary trauma from EMS workers to military. So pretty adults, children, the whole gamut, if you will. Again, I don't know the exact definition of it, but that's kind of what she deals with, trauma in people's lives on a daily basis.
Has she, without telling us exactly what she said, do you understand, has she ever indicated what a diagnosis or prognosis may be for Dean?
No, sir.
Bear with me for just a half a minute, sir. So earlier you talked about that there's no physical abuse by his two brothers against Dean. So that would be part of bullying, is that correct?
I think you can bully without physical abuse.
Well, yes, of course, but there's no physical evidence of that.
I've stated that I haven't seen any physical evidence.
Pass the witness, Your Honor.
May I, Your Honor?
Ms. Martinez?
I have a few questions.
Oh, I'm sorry, Diane. Go ahead.
Okay, Mr. Miller, what kind of things do you and your son do when he's in your possession?
We play basketball. We ordered a set of hunting books that I read as a child, so we read those at night. We go on, we do a lot of state parks. We go hiking, we go kayaking. He's my little hunting buddy. We turkey hunt together, dove hunt, deer hunt. We go camping. There's a lot of outdoor activities. And then when we're home, he just likes playing games and reading and just being part of the family.
Okay, do y'all have dinner as a family?
I'm sorry?
Do y'all have dinner together as a family when he's in your possession?
Every night we have dinner, yes.
Okay, do y'all go to church on Sunday as a family?
Yes, we do. Yes, we do.
Okay, at any time, do you ever leave him at home where you and your wife go do things without him or the other kiddos?
We never have.
Okay, I'll pass the witness, Your Honor.
Okay, just very quickly. Thank you, Judge. Just very quickly, Mr. Miller. As far as the kids and their behavior, do you think that they did fairly well before they decided to live full-time with mom?
Well, they were great students. They tried hard. They excelled in sports and athletics. Every teacher that I would talk to would compliment on how respectful they were and great young men, and they didn't break any laws that I knew of. I mean, it's just really When I talk to coaches in the community, they're just, just kind of disappointed in the way things have turned out, but it's out of my, when they're not with me, there's nothing I can do. They're always welcome in my home. As much as last week, I still text them how much I love them. I know this is hard for all of us, but I still reach out to them and text them. They're loved. We've offered Derek and Dawson numerous times to come back into our home and kind of get back on the right track, but I just can't do anything when they're not in my possession, or not willing to even come and spend some time with us.
Okay. And now you have asked for the court to interview.
We have a terrible echo all of a sudden. I'm not sure.
I'm not hearing it well.
All right, go ahead, Ms. Duke.
Okay. Hopefully that's not my fault. Mr. Miller, you've asked the court to speak to Dean, who is the only child that's under 18, in chambers with the court, which is allowed by, at least discretionary under the code. Is that right?
Yes, ma'am.
Okay, your understanding is that does not involve him coming into this courtroom and being subjected to some kind of cross-examination, correct?
That is absolutely correct.
Okay, and what are your feelings about Jennifer calling your other two children as witnesses in her own case against you?
I mean, they sure can. I mean, if, my boys and I have had a great relationship up until the day that she was served. Derek would come over and play basketball in my driveway. He'd come sit with me at night and we'd talk for hours. Dawson would come over. The day that Jennifer got served, they said they just turned their backs, and I don't know what's going on over there. I haven't done anything to them. I've welcomed them into my home, and still do. So the day that she got served was when everything changed, and they don't want anything to do with me. And I don't know what's being said. This is about Dean. They're both adults. They can make their own choices, but I was a very involved dad with them for their entire lives. It's funny, just back in May, not that long ago, right before they were served, Derek wrecked his truck. Who did he call? Immediately calls the first person he called to come help him. Dawson texted me on Father's Day, which is late June. Dawson texted me, man, Dad, have a great day. Love you. So I was involved in their lives, and I was trying to stay in touch with them so I could help them. They have no male mentor right now at all, and they're just lost. And things were trending positively, but as soon as Jennifer got served papers, I can't help but think that they were just turned against me, and now they don't want anything to do with me. But that's recent stuff. Father's Day and an accident. We're not going back that far, and I was involved with them, and they were reaching out to me, and everything changed when she got served.
Okay. Now I'm noticing that your son Dawson is sitting right next to your ex-wife, witnessing every bit of this court hearing. Do you think that is
Ms. Duke, I need to say that I said we're going to come back at 9:40. It's 10:40 now. So we need to get this. I've got another hearing behind this, and then a big hearing in Atascosa County. When they announce an hour and a half, that means 2.5 or 3.
I apologize, Judge. I often lose track of time. Let me, can I just ask a couple of very, very quick questions?
Yes.
Mr. Miller, very quickly, you said that Derek got into a car accident, which was very dangerous for him. Is that right?
Correct.
And are you concerned about those kinds of things happening that might physically harm Dean?
Yeah, that's a legitimate concern. Anytime there's multiple accidents.
Okay. And about the alienation, parental alienation, is that one of the main reasons that you are worried about Dean, is because that's going on at mom's house?
Yes, ma'am.
Okay, I'll pass the witness.
Mr. Pena?
2 quick questions, Your Honor. So with regard to the basketball, the hunting, the state parks, you get to do all the fun things with Dean, right?
No, we do homework every night. We read a set of very challenging books for him. It's not all, that's about that. We work out in the yard. He's got chores, he's got responsibilities with us. So that is an incorrect statement, sir.
So I'm glad you hit on school. Dean's doing very well in school. Is that correct?
Yes, sir.
If he was having all these emotional, mental issues, physical issues, you would think that that would affect him and his schoolwork.
He's a pretty amazing child that is able to decipher through that and still focus at school.
How about Jennifer being a pretty amazing mom?
That's not my opinion.
Okay. No further questions, Your Honor.
No question.
Okay. All right. All right. Ms. Duke?
Your Honor, I was going to call Mr. Lingerfeld for maybe 3 or 4 questions.
All right. All right, Mr. Lingerfeld, will you unmute your computer or your iPhone?
I'm here.
Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, Ms. Duke.
Thank you, Your Honor. Mr. Lingerfeld, can you state your name for the record?
Donald R. Lingerfelt, Jr.
And how are you familiar with Jennifer's household, with Derek and Dawson's mother's household?
Through my son.
Okay, and what is your son's name?
Trevor Lingerfelt.
All right, and was Trevor friends with Derek and Dawson?
Yes, he is. Yes, he was.
Did he get into some trouble over there?
Yes, he did.
What kind of trouble?
Well, he was arrested, and a lot of things happened in our household to where my wife and I had to intervene in his life and monitor him pretty closely to get him out of whatever he was doing, which he told us was drugs. And
Objection, Your Honor, hearsay.
Ms. Duke?
I'll ask a follow-up question, Your Honor.
Sustain. Go ahead.
Mr. Lingerfeld, under what circumstances did your child confess to you that he was using drugs?
upon my wife and myself direct questioning him, what he was doing.
Okay, and was this activity going on at Derek and Dawson's house over at Jennifer's?
Objection, Your Honor, involves hearsay.
Your Honor, I hate to be kind of a stickler about this, but is Ms. Tapia going to be doing the questioning of this witness? Because
Yes,
I'm getting two different people objecting.
Okay. All right. I heard Mr. Pena object on this one. And I'll
Oh, I'm sorry. I didn't hear him object previously. I thought.
I have not either.
Okay. Okay, just checking.
Go ahead.
Okay, so Mr. Lingerfeld, where was your son arrested?
From what I understand, in a neighborhood adjacent to their apartment.
Okay, to Jennifer's apartment?
That's correct.
Okay. What is your rule now about your son being able to go to Jennifer's house?
He's no longer allowed to associate with any of them.
I'll pass the witness.
Mr. Lingerfeld, thank you, Your Honor. Mr. Lingerfeld, does your son have any other friends he's not allowed to associate with currently?
Yes.
I'll pass the witness, Your Honor.
Ms. Martinez?
Few questions, Judge. Mr. Lingerfeld, what type of drugs was your son using?
Never asked him directly what it was, but from what I understand, it would have been cocaine.
Okay, nothing further, Your Honor.
Anything else for this witness?
No further questions.
All right, is he released?
I have nothing further, Your Honor.
Okay. All right, Ms. Lingerfeld, I appreciate you being here. Want to apologize for being short with you. I had been told that you were someone else, so when I kept asking for someone else to unmute or to do something, I understand what your confusion was and why you did not respond. So I appreciate you being here. You're released at this time. You're welcome to stay and watch. You're welcome to take off.
Thank you.
Go ahead.
Your Honor, just short of our motion to have the court speak with the child, and I'd like for Diane to have an opportunity to give her report to the court. We rest.
All right. I've looked at the law on that. Well, actually, let me hear from Ms. Martinez first.
Do you want me to do that now, Judge?
Yes.
Okay. I've had the opportunity to speak to Dean. He's a 10-year-old child on at least 6 occasions. He's very mature for his age, but is very shy and introverted. It takes a lot of time to get him to warm up. He certainly did warm up to me in my office, and obviously over the phone. I saw him with mom and dad and even with his brothers. He's very torn because he absolutely loves both parents like all kids do, but just feels very unsettled at mom's house. He doesn't feel like he gets the attention that he wants or needs at mom's house. And being a little brother of 2 other adult brothers is very hard for him. He feels ignored. He feels almost required to spend majority of his time in his room. He understands, he feels that his parents or his mom doesn't understand that he knows what's going on and why he's sent to his room often, but having to sneak over to get a glass of water or go to the bathroom while he's in his room for him is very sad and depressing, because he knows that he feels that one of the reasons he's asked to stay in his room is because he knows there's underage drinking and vaping in the common areas of the apartment. At his dad's house, he feels he gets more parental attention, more one-on-one. He's never asked to be removed and go to his room. He's never asked to not be part of the family. And then what made things worse is prior to this hearing, Dad did provide an affidavit for the court. And I didn't tell him about the affidavit, and I was hoping nobody would speak to him about it, but he contends that at his mom's household, he was questioned about the affidavit. So he was really worried that he'd be punished for the things that he relayed to me. And so that made him very sad and uncomfortable that mom and brothers were asking him about the things that were said in the affidavit. So that mom and dad live so close together that I didn't think that it would be really hard to transition this child to a different schedule, even if we're not changing the school because they live in the same school district. Certainly, I feel that he would be. It would be better for him to spend more time with dad. That's definitely what he's wanting to do, and basically switch the schedule. And I was trying to get the parents to try to do this under a temporary order to see how he does, to see if he's happier, less depressed, possibly get him some counseling to help him sort out all of the things that are going on since he's only 10 years old. He holds his own really well, but does appear to be very sad and depressed in the current situation. In regards to his grades, he's a very intelligent child, is able to keep his grades up, but mentally, he does not seem very healthy. He seems very sad. Even when he comes in with dad, he's very worried about what's going to happen next. What is my mom going to find out about? What am I telling you? He was really worried to talk to me the first time I met him because he didn't want his mom to know that he was unhappy there. But once the affidavit came out, he was very sad because he didn't think that he was going to be questioned about it. So I do believe, Judge, that it would be in his best interest to transition to his father's house under temporary orders. Obviously, if he does well there, my hope is that mom would allow him to remain there. I mean, I know that there's a jury demand that was made by mom, so we will have to try this case in the future at some point. But I think that it would be good for him to be able to spend more time at his father's home.
And do you have an opinion about whether it's just that the father should win is your opinion just that the father should win at the trial on the merits, or is it that the present situation is a threat to the child's mental or physical well-being?
I believe at this time, I would like to take this one step at a time. I think his present environment is harmful to him. And this is according to him, and also in speaking with Mr. Lingerfeld about what was going on and why his son's not allowed to be there as well. So the child has a lot to say and does not want to upset either parent, but he feels pretty desperate to try to be removed from the situation and live in a more positive environment at this time.
All right, Ms. Tapia?
As far as questions for Ms. Martinez, Your Honor?
Yes.
Ms. Martinez, in your meetings with,
Your Honor, I'm going to object to questioning Diane. I think under the code, it specifically says that she's not going to be a sworn witness in this case, largely in part because she has to have a level of trust with the child. So I would object to her being asked questions at this point.
All right, I did ask a question. Let Ms. Tapia get it out, and if you think there's something objectionable about a particular question, or if Ms. Martinez does, I'll consider that objection.
Okay.
It's not cross-examination, it's just asking questions for whatever difference that is.
I'm sorry, I'm trying to find this. Ms. Martinez, I'm just kind of concerned because you've testified that he's very sad, depressed, everything. But in your report that you sent us, you stated that he was very talkative and happy. And there's nothing in here that addresses anything that that he's depressed or sad or anything like that. This is the first time that we've learned anything with regard to him being depressed, sad, not mentally healthy.
That was because he did not want his mom to know that he was going to be telling me things that were happening in the household. Once the affidavit came out, I was surprised that he was questioned about it in mom's apartment. My hope was that when someone files an affidavit, no one speaks to the child about it. And he clearly was asked about it and questioned about it and made to feel like he wasn't telling the truth. And so that made him very unhappy and unsettled that he didn't know that was going to happen. And I think he felt unprotected. When we first met and a couple of times after, he's like, no one's going to know about the things we talk about. And I said, correct. I just need to know what's happening, why you feel the way you feel. Once the affidavit was filed, obviously mom's going to get a copy of it. But I did not, perhaps the party should have been admonished, but he was clearly aware of everything in the affidavit and was questioned by his brother and mom, according to him. That made him very upset because he thought, well, now I'm going to get in trouble. Everyone's mad at me. Just very worried about it, very stressed out about it.
So as far as timeline, I mean, you're saying that the affidavit came out, that the depression and sadness and mental health issues came out after the affidavit, or were you aware of stuff before the affidavit?
It came out mostly after the affidavit. Also, the fact that this case was reset, it was his understanding that things would have happened months ago, and here we are in December, and now he's hopeful that the judge will allow him to stay with Dad. And as this case has been reset or dragged out a bit, has also made him very stressed out and worried because he's still in the same environment.
And so how many times have you met with Dean?
In person 5 times, and we've spoke twice.
And when was the last time that you spoke with him?
We spoke on November the 4th, I believe.
In the last in-person visit?
I believe it was September the 30th.
And then the affidavit was filed in October, on October 8th, correct?
I believe so.
And so was the November 4th date the date after the affidavit that you spoke with him, or did you speak to him another time after the affidavit came out before November 4th?
Can you ask that again? Can you ask that question again?
Did you speak with him sometime between the affidavit coming out and the last phone call on November 4th?
We spoke on the 18th of October.
Okay. And so again, I mean, my concern is that October 18th, 11/4, excuse me. And I mean, this is the first time that, like I said, we've learned anything about him possibly being sad, depressed, or not very healthy mentally. Would you typically recommend something interim in between those times, because the case kept getting reset because of, I guess, there were things that went on with court and stuff that we got reset, but would there have been any recommendations for starting any counseling, any sort of interim orders that we could have possibly agreed on if there was an issue with him being sad and depressed, and if you're saying he's not healthy mentally?
Yes, I actually tried to get us to do some sort of agreement. I sent both of you letters about trying to resolve this, even if it's just a temporary order. I believe if you question both parents, I'm certain they'll tell you that he's worried and stressed out. If he does this with me when I'm not even a family member, I'm certain his mom and dad will tell you the same, that he's worried and stressed out in their household as well.
So, but our temporary orders were just for testing, and then just with regard to Mrs. Munoz's work schedule and visitation, we didn't have anything in there or discuss anything with regard to any sort of specified counseling or anything like that. Isn't that correct?
What are you asking me? Our temporary orders?
Right. And we had temporary orders back in late October, I believe it was October 30th. There was nothing there with regard to any sort of counseling or anything like that that would address any sadness or depression or anything like that. Is that correct?
Yes.
Okay. And how many times have you spoken with Ms. Munoz?
I believe she's had 2 1-hour visits in my office.
2 1 hour. And with Mr. Miller?
He has had the same 2 1-hour visits in my office.
Any phone calls with Mr. Miller?
No.
I'll pass the witness, Your Honor.
Your Honor, may I ask Diane just a couple, as a adversarial person. Diane, so do you believe that exposing the child to possible drug use and underage drinking could be a significant danger to the child's mental health?
Yes.
Do you believe that leaving the child alone with a couple of teenagers or young adults that are possibly drinking and using drugs, it could be a significant threat to his mental health?
Yes.
Do you believe that isolating him outside of his will, against his will, in a bedroom?
Ms. Duke, I'm going to cut you off because I have the same opinion on all of these issues, but I don't know if those things are going on. So
Okay.
if things are going on, then I share I know what Ms. Martinez's position is. I share her concerns. I don't know if those things are all, there's reason to be concerned about that.
Okay, then let me change the question real quick, if I may. Diane, or Ms. Martinez, do you have credible reason to believe that that drug use may be going on in the house?
Yes.
Why do you say that?
Just from speaking to the child and then speaking to Mr. Lingerfeld, who won't allow his son to be in that apartment any longer.
Okay, and what did Mr. Lingerfeld tell you that caused you great concern?
Just that his son was using drugs, was consuming alcohol in the Miller apartment, and he didn't want his son around it. His son asked him for help, so he's supporting him, getting him clean, getting him a criminal attorney, and trying to get him on the right path.
Okay, and is it your understanding that Mr. Lingerfeld's son was using drugs and spending a good amount of time at that apartment?
Yes.
Okay. Are you aware of whether Dean may have been exposed to that?
Yes.
Okay, and why do you say that?
He saw him in the apartment. Mr. Lingerfeld's son has been in the apartment numerous times. So he saw all these young people partying in the living room when he's coming in and out of his bedroom.
Okay, and do you feel like the kind of bullying or sharing information about this case with the child, to the extent that you've seen, could be a significant risk to the child's mental health?
Yes.
Okay. No more questions then for Diane.
Okay, all right.
Your Honor, if I could just do a couple follow-up questions.
Very quickly.
Thank you. Ms. Martinez, when you say that Dean is reporting partying, what is he speaking about? What does he understand as partying? What are you aware of?
That there is no one in the apartment at the time. This is before his brother turned 21 that's of age to be drinking alcohol. So you have a 17-year-old and a 20-year-old consuming alcohol in the living room and vaping. And
but Dean specifically described like alcohol. Does he know, vaping, he knows all of what that looks like and everything?
Absolutely. He knows when something smells funny. I don't know if he knows what marijuana smells like, but he said it smells funny in the living room. He knows what beer looks like. He knows what the labels look like. And he knows there's no adults in the living room. Either his mom's working or his mom's in her bedroom or working out at the gym. But they're underage drinkers and he knows it's not right.
And as you know, everybody's drug test came back negative, correct?
Mom and Dawson's, yes.
Correct. And Derek, he is on probation and gets tested regularly, correct?
I don't know anything about his probation.
Okay. But as far as Mom and Dawson, they came back negative?
Yes.
Okay. I'll pass the witness room.
Diane, is it your understanding that we asked for Derek to take a test and he refused to do it?
Correct.
Okay. Nothing further.
All right. What other witnesses? Are you
we have
at the residence of the mother?
I'm sorry, Your Honor.
Are we going to hear? I'm sorry. Are we going to hear from anyone at the residence of the mother?
Yes, Your Honor. We have our client and then her sons.
All right. Go ahead.
I'll call Jennifer Munoz.
Go ahead.
Thank you, Your Honor. Ms. Munoz, would you please state your name for the record?
Jennifer Susan Munoz.
And are you currently employed?
No, ma'am, not at the time.
Okay. And were you previously working?
Yes.
And where did you work previously?
Conley Memorial Hospital.
And what did you do at Conley?
The unit secretary on medical surge floor.
Okay. And what was your work schedule?
3 days a week, 7 p.m. to 7 a.m.
And the days that you would work, did you try to schedule those for the times that you did not have Dean in your possession?
Yes, I was able to schedule when Dean was with his dad.
Okay. And were there a couple of times that that was not possible?
Yes, there was.
How many occasions did that happen?
Maybe twice.
So 2 times?
Yes.
And when did you start working at Conley?
And the very end of September.
And when did you leave Conley?
The first week of November.
So you worked there for approximately 60 days? Less than 60 days?
Less.
Okay. And were you employed before Conley?
No.
And are you currently in any school?
I'm waiting to test at state for my second test for an esthetician on December the 9th.
For what?
Aesthetics, skincare.
Okay. Go ahead.
Okay, thank you, Your Honor. And are you currently you're currently on disability, is that correct?
Yes, ma'am.
And what is that for?
I have chronic lupus. I've had it for 14 years. I've been on disability for 14 years.
Okay. And was that part of the reason why you left Conley as well?
Yes, my lupus flared up and my doctor advised me that it wasn't a good idea for me to be working that shift.
Okay. What sort of symptoms does your lupus cause you to have?
Just a lot of severe fatigue, but a lot of joint pain and swelling.
Okay. And are you on medication for that?
Yes, every day.
Every day. And does the lupus or your medication interfere with your ability to parent, to be there for your children?
No, I don't think so. I don't let it stop me doing that. I mean, that's what I love. I take my medicine every day, but when it comes to that, I just fight through it. I do what I need to do.
Okay. And are you pretty active with your kids?
I am.
Okay. And what sorts of things do you do with Dean?
We're outside a lot. This past year, we didn't get to do a lot of the things we do just because of COVID. Every year we do Schlitterbahn season passes, zoo season passes, the San Antonio Aquarium. But this year it was more, we did go to the lake a couple times. We hung out with 3 of his friends from school 3 different times. He loves swimming, so we did a lot of that. And then, other than that, it's a lot of outside, a lot of basketball. That's his first choice is basketball. So we play basketball, we play tennis, soccer, we do it all.
And all of your boys have been pretty active in sports, is that correct?
Yes.
Okay. And is Dawson currently involved in sports right now?
He is.
And what is he involved with?
He plays basketball on the high school varsity team.
And isn't it the current Livonia policy that the boys get tested now for
Yes,
drugs?
it is.
And when did that start?
This school year.
Okay. And is that random testing or is that
it's random.
Okay. And to your knowledge, has Dawson been tested by the school yet this year?
Not yet.
Not yet. Okay. Okay. So there's currently allegations that there's partying, drinking, and drugs going on at your home. And where do you currently reside?
In Lavernia, 120 Villas Drive, apartment 327.
Okay. And is that a 3-bedroom, 2-bath?
Yes, it is.
Okay. And did you have to wait a while to get a 3-bedroom, 2-bath?
I did. I was on the waiting list for a year.
Okay. So now there's an allegation that on September 30th, when you were working, that Mr. Miller called to check on Dean, and was apparently there was partying going on that night. Do you recall that day, September 30th?
No, I don't.
Would it refresh your memory if that was the day that Dean went to the gym with his coach?
Oh, yes. Yes,
So-
his coach picked him up for practice that night.
Okay. And who dropped Dean off at the apartment?
His coach dropped him back off at home, made sure that he got inside. Dawson was waiting for him.
Okay. And when you checked on the boys, what to your knowledge, what was going on that evening at the apartment?
Nothing. There was one boy named Major there at the apartment with Derek, and Dean came in and they gave him, he had a snack and showered and went right to bed. I talked to him on the phone. I had Dawson call, or Dean used Dawson's phone to call his dad, and they FaceTime usually all the time. And, so he talked to him also right before he went to bed.
Okay. And do you think, based on the testimony you've heard and everything, if Mr. Miller thought that there was partying and drugs and drinking going on in the apartment, he would have just let that subside that evening?
No way. I believe that he would have went over there if he was worried about that.
Okay. So if Dean told Mr. Miller that there's partying going on in the apartment and people are doing drugs, there's no way that, in your opinion, Mr. Miller would have not done something about that.
Right.
Okay. And did you hear from Mr. Miller that evening?
No.
Did you hear from him the next day?
No, I did not.
Has Mr. Miller ever contacted you about any allegations of drugs and drinking going on in the apartment?
No.
Okay. Never before this suit was filed?
No.
Okay. And never since this suit was filed?
No.
Okay. Do you think if at any time he thought that there were drinking and drugs and partying going on at your place, that he would have done something about this?
I believe so.
He would have contacted you, do you think?
I think he would have contacted me.
Okay. And he's never contacted you about that at all?
He never has.
Okay. So other than the 45 days or plus so that you worked at the hospital, you're home all the time, is that correct?
Yes.
And it's been alleged that there's lackadaisical rules with regard to what's allowed and when you're around the boys versus when they're at their dad. Do you allow the boys to drink?
No, I do not.
Do you allow them to vape?
No, I do not.
Do you allow drugs in the apartment?
No.
Okay. Do you yourself do any drugs or vape or drink alcohol?
No, ma'am.
Okay. Does your medical condition, would that affect your medical condition?
Definitely.
Okay. And now with regard to Dean and his brothers, again, there's been testimony that he's being bullied by his brothers. How would you describe the relationship between Dean and Dawson and Derek?
It couldn't be any better. I mean, Dean is very, he has all our attention when we have him. I mean, we're constantly doing something. Right? We're either outside, the boys, their hobby is NFL and NBA trading cards. So they're constantly looking through those cards. I mean, Dean can't wait till Derek comes home so he can go, so he can trade with him or just go through them and look at them. Dawson, they get along really good. I've never seen any problem. They don't even do the picking on each other. They just get along so good. Whether they're outside throwing the football, that's usually what they do. If it's not basketball, they're outside throwing the football. But they get along really well.
Okay. And how would you describe the relationship that Mr. Miller has with Derek and Dawson?
They don't have a relationship right now. I do stay out of that. I don't want that for my boys. They're my boys. I want them to have their dad in their life. They need that. Whatever happened with them, it is unfortunate because it's really sad. They don't speak at all. They don't see each other at all. And so Dean only gets to see the boys when he comes to my home.
Okay. And then when Dean goes to his dad's and you try to have contact with him, what typically happens with regard to that?
If they're out of town, if they're hunting, I do not get to speak with him. If Dean is with their Matt's wife's side of the family, I do not get to speak to him. So if they go hunting, before he used to take them to the top of the hill when they would call it the top of the hill to call me. And that's where they get service. Now they don't do that anymore. Ever since he's been married, they don't call me anymore. When they go hunting, they leave on Friday. He's always getting taken out of school early on Fridays for hunting. I won't talk to him till he gets back to Lavernia on Sunday. Okay. It's like that every time.
And do you ever get text messages from Mr. Miller saying that Dean's old enough to choose where he wants to go?
Yes, I have a few messages saying he's old enough to make his own decisions and he doesn't have to come with me if he doesn't want to.
Okay. And when you say that the hunting trip and they're up on a hill, is that a specific place all the time or?
It's the same place. It's out in Ozona where they have the hunting lease, and they would never miss a night of calling me and letting me know that they were okay. They would go to the top of the hill, and that meant everything to me. And now I don't know if they're okay if Dean's okay from Friday to Sunday till he gets back. Nobody knows. We just can't get a hold of him.
Okay. And then also I wanted to go back to that, this allegation that you're often like asleep in your room with the door shut and have no idea what's going on. Is there any truth to any of that?
No. As a matter of fact, that's definitely not true. I'm not one to go take naps. I sleep when they sleep. And that's why I took that night position job, so I could sleep when they were in school. I was there to pick them up in the morning, or to take them to school in the morning, and there to pick them up from school. It's just no way. I'm very involved with them during the day.
Okay. And As far as like doing homework and everything like that, are you involved with them with regard to their assignments, getting those turned in?
Yes, very
Okay.
involved. They have really good grades. They've always had good grades.
Okay. And do you get them to school on time all the time, or?
I have always gotten them to school on time. They've never been late.
And before Mr. Miller got married last year, was he often tardy with the kids, missing assignments?
Yes, all the time. Dean would cry and tell me he had to
Objection,
send
hearsay.
his.
Ms. Tapia,
I'm sorry, Your Honor.
was it hearsay objection?
I would go to basically it's a present sense impression with regard. It's what she. Yeah, I would stick with present sense impression with regard to what was going on at the time.
I'll sustain the objection.
So when before that, I'll rephrase the question. Was Dean happy going over to Mr. Miller's before he got married?
No, he was very worried about that, mostly about being late to school, because he said that when he was
Objection,
always
hearsay.
tardy on a Monday.
Objection, hearsay.
I have the log from school.
Oh, okay, all right, hold on, man. All
You
right,
have to wait until.
Ms. Tapia,
Your Honor, I'll rephrase the question.
thank you.
So you said that he was very worried because he was concerned about being late. Is that correct?
Yes, ma'am.
Okay. Was he concerned about getting assignments turned in on time?
No, he was concerned because when he would arrive to school on Monday, they were
Objection,
already in.
lack of personal knowledge.
Your Honor, she would have personal knowledge.
I will
Sorry,
override
Your-
objection. Go ahead.
Thank you. So when he would arrive to school on Monday, he was concerned.
They were already starting their assignment. So he would come in and still had to put all his things away. So he was late in getting started, and his pencil talk in the morning is what they called it. And so he would set his alarm, his iPad. Dawson was there during that time when he was always tardy. And it was always when they got home after midnight on Sunday night from hunting, he was tardy to school on Monday morning.
Okay. And Dawson would be tardy too as well. Is that correct?
Yes.
Okay. Because at the time Dawson was still seeing his dad.
Yes.
Okay. And then with regard to, did Mr. Miller notify you when he did the home test on Dawson for drugs?
He did send me a message.
Okay. And what did you do?
I immediately contacted the church. I wanted him to speak with the youth pastor. We didn't get to do that. But I was just there for him. I spent a lot of time with him. I know he's on the right track. I'm proud of him. He's doing really good.
And what is your understanding of what Mr. Miller did for Dawson after this home test showed a positive?
They were very mean to him, Dawson said, and they took away his truck and sold it.
So it wasn't just taken away for a couple of months?
No, he sold it.
Okay. Did Mr. Miller contact you about getting any sort of counseling for Dawson?
No.
Okay. So other than him letting you know what had happened, it was left up to you to try to figure everything out.
Right.
Okay. And with regard to Derek, at the time that we entered into the temporary orders, it was your understanding that Derek was going to be moving out that day. Is that correct?
Yes.
And that was for a job in San Antonio.
I'm going to object to leaving.
Okay.
I'll overrule that in the interest of time, and we're an hour and 50 minutes into this, so go ahead. Ms. Tapia.
Thank you, Your Honor. I'll try to hurry up, Your Honor. And how old is Derek?
21.
Okay. And Derek is not a party to this suit, correct?
Right.
Okay. And Derek lives, where does Derek live?
He lives in San Antonio.
And he works in San Antonio?
Yes, he does.
Okay. And how is his relationship with Dean?
It's really good. Dean loves to visit him. When Derek comes home now, they're outside. Like I said, he constantly throwing the football, or Derek and Dean are really into the trading cards. So that's their big thing. And then they watch football together. They just get along really well.
Okay. And now Mr. Miller testified that that he and the boys have, that he's very involved in their sports, that he's the sports dad, coaching, everything like that. Have you seen Mr. Miller and his interaction with the boys with regard to their sports?
Yes.
And you've observed some things over the time that he's been involved with them that has disturbed you. Is that correct?
Yes.
And what sorts of things have you observed?
I'm going to object to relevance, and that I'm going to object to anything that happened before the last order in this case.
This would be since the divorce, Your Honor, in this.
I'll sustain the objection to anything that happened prior to the last order, the last formal order. Go ahead, Ms. Tapia.
Thank you, Your Honor. Go ahead and answer, Ms. Munoz, for anything that you've observed since the divorce with regard to how Mr. Miller interacts with the boys and with regard to sports, the things that you've seen.
When they don't play well, and they don't have a good game, they are just after the game, they will get in trouble. After the game, he has never once told them, great job. It's always, he stands there, and even their coaches know this. He stands there and tells them all the things that they did wrong, and they are just tired of that.
Okay, and when you say gets in trouble, what do you mean by getting in trouble?
Derek has been drug on the field by his helmet for not doing the play right.
Honor, I'm going to object again. Mike, Derek has not played football in 3 years. So I would like to make sure that Ms. Munoz tells the court when these things happened.
Okay, so for the last 3 years, it's been basketball. So that, the coaches, and so so after the game, he just criticizes their game and tells them all the things that they did wrong during the game. Never good job, just good job, leave it alone, just good job.
Is this in private or is it in front of everybody?
It's in front of everybody. I mean, the coaches know, they know this happened. The boys know this happened. That happens after every game.
Okay. So do you see, is Dean, in your opinion, is he sad?
Not at all. He is very happy. He's very social. Every teacher in school, everybody that we know knows Dean is the happiest kid, the most social kid. Yes, very advanced for his age, for only being 10, but he loves to talk to everybody. He has a lot of friends. He's just doing really well. You would never know that he is going through this right now because he's so happy.
Okay. Have you seen him sad with regard to anything that's going on?
No, I haven't seen him sad. I mean, I see him we're so busy all the time, and I just see him happy all the time.
Have you seen, in your opinion, is he depressed about anything?
I don't see that. I
Okay.
would have definitely done something about it if I were to see him sad. I would have.
And you've taken him to a counselor before, is that correct? Or a counselor at the school?
I did.
And what
The
was
school recommended that I did that.
What was that for?
Dean was crying. I got a phone call one day. His dad was on a hunting trip, a 10-day hunting trip, and he had no service. So he did not speak with the boys for 10 days. The school called me that Dean was crying in school and saying that he thought.
Objection, hearsay.
Oh, I have.
I'm not finding that that's for the truth of the matter asserted, so I'll rule that. Go ahead, ma'am.
Go ahead.
Me, Ms. Tapia?
Yes. Go
Okay.
ahead.
And so the school did contact me that he was crying, and they sent him to the school counselor, and the school counselor is the one that sent him to the counselor in Floresville Connections. And then he only went for just a short period of time because she said that he was.
Objection, hearsay.
Again, it would go to the truth of the matter asserted and her knowledge of it. It's counseling. It's for a diagnosis purposes and for.
Rule the objection. But
Go ahead.
I'm not disrespectful of the parties, but we do have supposed to have local rule of 1 hour for temporary orders. We're heading on for 2 right now. I know there's still more we need to hear from, and I've got another hearing behind this and then a very long hearing for Atascosa County. So if you
okay,
try
all
and
right.
get this, but just a few more questions.
All right, thank you, Your Honor. Go ahead.
On the same.
Yes,
about the counselor. Yes, and so I mean the school counselor that spoke with him when that happened, she's still there. I mean, so anyway, he went to the counselor in Floresville, and she ended up only seeing him for a short amount of time just because she said that he was so happy. There was no reason to see him. She did speak to me and Matt and Dean, and she just said that he was doing great. That when Dad came back, then Dean knew that he was fine, and there was no reason to see him.
Okay, and just for clarification, because I think there was an objection stated, the school called you because Dean was crying because he couldn't get a hold of his father. And what did Dean think was going on? That
he thought that his dad.
Is concerned. Let's move on.
Okay. Do you think it's in Dean's best interest, in his mental and physical well-being, that that he remain with you as the person who can designate his residence?
Absolutely. My kids come first. All I've done for my whole life is take care of these kids and put them first. And I will never go out of town when I can't get a hold of them and have no service. I don't care what happens. These kids will come first. I'm mom. I love them. I'll take care of them, and no matter what. And then they know that. All 3 of them know that.
And you are asking that the current orders that were issued under the decree remain the same, and the current visitation schedule remains the same, that everything remains the same. Is that correct?
Yes, please.
I'll pass the witness, Your Honor.
Ms. Munoz, why is your son sitting next to you listening to all this testimony?
I thought he was supposed to.
Your Honor, they wouldn't know anything about invoking any rule or anything like that, which nobody did.
Okay, I'm still just asking her why she wouldn't just send him in the other room instead of having him sit on the camera like this.
I wasn't told to. I didn't know what I was supposed to do. We don't know what to do.
Luke, I summoned Derek Miller so that he could be sworn in. So
Okay, is that Dawson or Derek sitting next to you?
I'm sorry, Dawson.
This is Dawson.
Dawson.
Okay.
Sorry, Dawson.
And he is your son that just turned 18, is that right?
Yes.
Okay. Did it cross your mind that you might want to put him into another room?
No.
Okay. And that's the same kind of attitude you have when you sit down with your son, Dean, and go through the court filing in this case, isn't it?
How did I know he's supposed to be in another room?
Okay. Answer the question that I'm asking, please. That's the same attitude that you have when you sit down with your son, Dean, and go through the entire court filing with him. Isn't that right?
No.
Okay. You did show him the affidavit, did you not?
I did not show him anything. I was concerned because the affidavit has on there that Dean's bullied. Dean sent to his room. None of that is true. That would never happen. I'm his mother. That would never happen. I take very good care of my children. I take a lot of pride in that.
Okay, so you talked to him about what was in the affidavit.
I asked him, Dean, is anybody ever mean to you? Has anybody ever bullied you? And he said no. Everything that I asked him in a way of just me asking him questions, he said no. No,
Okay.
Mom, that's not true.
Would it be strange then that he actually went and had actual knowledge of what was in that affidavit after talking to you?
No, I mean, I did go over the questions with him, but not telling him, hey, I have these papers, I just said.
Do you think that's in your do you think that's in your son's best interest?
Me making sure as his mother that nobody's hurting him and that nobody's bullying him? Because yes, I do have to make sure that that's not happening. That's not allowed. His brothers know that.
In fact, what was happening is that you were making sure of what he would say later on after he read the affidavit.
Dean knows.
Correct?
Hey, Dean knows you don't lie. You tell the truth, and he knows that none of that ever happened.
Okay, so he was telling the truth when he talked to Diane. Do you believe that?
About the stuff on the affidavit? No. I believe he's coached by his father.
Okay. Can you tell me why you thought, when you have a 10-year-old son and 2 teenage boys watching him, can you tell me why you thought it was a good idea to take the night shift?
I needed to take that job because I'm in this situation paying attorneys. I left Dean with them a couple of nights because I trust them. Every teacher they've ever had, every coach they've ever had loves them, will say nothing but positive things about them. And that's the truth. They're very respectful boys and they're good. I don't have any problems.
How much have you paid your attorneys?
Objection, Your Honor. I don't see the relevance that is.
Oh.
She just said that's why she had to take the job.
People take jobs.
I'll sustain the objection.
Okay. Have you asked for a jury trial in this case?
Have I? I believe so.
Okay. And did you pay your attorneys for the jury trial already or not?
Objection, Your Honor. I don't see what the relevance of this is with regard to temporary orders.
Your Honor, it has to do with.
We were trying to speed things along too.
All right. Let Ms. Duke speak.
Your Honor, it has to do with her saying that she's taking a job, she's changing her schedule for these kids to do these things legally. And I would like to know if she actually has the ability to do this or if she's just telling something that's not true.
I'll sustain the objection.
Okay. Ms. Tapia, Ms. Munoz, you knew that your children had both used drugs in the last year or so. Is that right?
No, I did not know that Derek, I have no knowledge of Derek doing drugs. I only know about Dawson from his father doing a home test back in November.
So you don't believe your kids are doing drugs?
At this moment, no, ma'am. We just had hair follicle tests. We were negative. He was negative.
Are you aware that your children have discussed how to avoid getting a positive drug test?
No, ma'am.
Okay. Are you aware that Derek told his father that he was using cocaine?
No.
Are you aware that Dawson tested positive for a drug test for marijuana?
last year, November, by his father, yes.
Okay. Are you interested in at all in finding out if any of these things are a problem before you take a night shift job and leave your 10-year-old son with these kids?
I am with them all the time. I am with them all the time. I'm very close to them. I'm
Okay.
in their
But
house.
you're not with them all the time. You're not with them from 7 p.m. to 7 a.m. in the morning, 3 nights a week.
I don't work there anymore. I haven't worked there for 3 weeks or 4 weeks.
Okay.
I don't know.
You quit that job because you knew it would look bad in this court hearing, didn't you?
I quit because I had to. I had medical. I have proof. My lupus flared up. I had to get on high dose steroids to calm my lupus down.
Okay.
That's the truth.
How many times have you gone to the gym in the last 3 weeks?
I don't have a membership at the gym.
How often do you work out every day?
I do walking around my apartment because that's my lupus. My doctor says I have to stay active with my lupus. I mean, everybody knows that it's chronic. It's a chronic illness. I can't.
Are you telling this court that you do not go to the gym under oath?
Absolutely. I don't go to the gym. I don't have a membership anywhere.
How much are you making right now for your disability?
$785. That's after they take out for my Medicare. It pays for my insurance.
What do you make before they take out the Medicare?
$970 maybe. $970
per month.
Right.
What's your rent?
Okay, where is this going, Ms.?
I'm wondering if this is, Your Honor, let me back up and maybe I can show you where I'm going with this.
Okay.
Ms. Munoz, you said that you had to get it took you a long time to get a 3-bedroom, 2-bath apartment. Is that right?
Right.
Okay. And before that, how many bedrooms did it have?
2-bedroom.
Okay. So where did Dean sleep?
He had a bed in my room.
Okay. So where did the boys sleep?
Together in Dawson,
Right.
one room.
The question I'm supposed to be looking at is whether the child's present circumstances are a danger to his physical or mental well-being. What does where they slept in a previous apartment have to do with that?
Your Honor, and I'll be happy to move on, but I guess my point is that if she's making $970 a month, I'd like to know what her expenses are to see if this is even something that she can sustain, because it doesn't seem like this is an apartment that she's going to be having for very long.
Your Honor, I believe she's been in it a while, and that again is.
Okay, I'm going to direct this. Please move on, Mr.
Okay, I will, Your Honor. Now, as far as Matt addressing the concerns that the significant concerns he has about your children's drug use, he has actually talked to you several times on Family Wizard about asking you to do something about this, right?
One time when he tested Dawson at home.
Okay, and when he asked you to please do something about this, you just took the child to church and nothing else, right?
I've been there for him, talking to him.
Did you ever test him again? Did you ever test him again?
I have home tested him twice and they were negative.
When was that?
Shortly after that, January, right after he was tested by his father in November. So then January, probably March, and never again since then.
Did you share those results with Dad?
No.
Do you have copies of those results right now?
No, it was thrown away. It was home tests, but
Okay.
we just took hair follicle tests.
Okay, so given that you have not shared any information with Dad about your supposed helping of the drug situation, don't you think it's reasonable that at some point he would file a suit to make sure that Dean is okay?
I don't know. Dean is very well taken care of. That's all I know. He's very well taken care of. His teachers say nothing but good things about him. I think that the school would know if something was wrong too, and they would reach out to me.
Are they aware that you work overnight?
The school?
Yes.
No, I don't work there anymore, but no, they weren't aware.
Are they aware that the boys had tested, or that Dawson had tested positive for drugs in the household?
No, I've
That's
spoke to
relevant.
Dawson's coach about it. Just because he knows that Dawson
Objection,
lives with
non-responsive.
I don't know. I'm sorry. What's the question?
Is Derek even supposed to be in San Antonio at this point, pursuant to his probation?
I don't know the rules on that. He's over there to be close to work.
Okay. Would it be fair to say that it's probable that he is not supposed to leave Wilson County?
Objection, Your Honor. Again, relevant, and Derek would be the person to ask about this, or even getting a copy of the terms, conditions of his probation.
All right, I'll sustain the objection.
What did who is Mr. Lingerfeld's son?
His name's Trevor. I don't really know. I mean,
how much did he stay at your house?
Not very often. It wasn't until I found out. The only reason why I found out that he was arrested close to my apartments was when Matt had the welfare check on my home, the cops told me. And so then I have the text where I text his mother and said that he wasn't allowed at my house anymore. I had no idea. Trevor is he was so respectful. You would never know. He fooled me. You would never know that he was arrested for cocaine. I had no idea. He didn't look any different. I didn't know.
All right. So you're pretty much clueless when it comes to figuring out if people are on drugs. Is that right?
I guess I didn't know. I mean,
I'll pass the witness.
I have a few questions, Judge. Ms. Munoz, do you agree that you did allow the boys to drink in your apartment on occasion?
No.
So Dean said that he saw his brothers drinking at your apartment. You weren't aware of that?
No, I was not aware of that.
Okay. Do you allow them to vape in your apartment?
No, they are not allowed.
You don't recall your son telling me that he vaped in your apartment?
Derek?
Dawson?
Well, not in front of me. He may have said that he's.
All right, I'm going to instruct Dawson to, if you're questioned, you'll be questioned. You don't speak out otherwise.
Do you recall Derek stating that he vapes in your apartment?
Derek has never done it in front of my face.
Neither of your boys have ever vaped in front of you?
Not in front of me.
Okay. Were you aware they were vaping in your apartment when you're not there?
I was not aware that they were doing that in the apartment.
Okay. Has Dean ever told you that his brothers are vaping and drinking?
No, Dean has never told me any of this.
Okay.
Not one time.
Okay. And do you agree that Dean is required to be in his room after 9 o'clock and not come out?
No, absolutely not.
That's not a requirement?
No, that's his bedtime, but that he's never been told, go to your room. He knows the schedule. He takes a shower and gets ready for bed and all that. He does that, but I don't ever have to say, or I don't ever make him stay in his room. No, he gets up, he does whatever he wants. Like, as far as if he has to go to the bathroom.
Okay, I pass the witness, Your Honor.
Stop it. Anything else?
Just one follow-up question, Your Honor. Ms. Munoz, if all this stuff was going on in the apartment for the very short, less than 45 days or so that you worked part-time, 3 times a week, If any of this was going on, would Dean have told you, hey, Mom, Derek and Dawson are doing this, or I've seen this, or all this stuff is going on, what everybody's saying is going on? Would Dean have told you?
I believe he would have told me. And when I talked to him on the phone a couple times from work in the evening before he goes to bed, he's always sounded fine and happy. And he tells me, you know, what they did for the evening. And I wasn't even gone long before he had to go to bed. But no, I believe that he would have definitely told me.
Okay. And not just for the time periods you're working, because that's a very short time period. This was filed way back in May. So apparently these concerns were going on before that. So the time period before that, at any time, if there's anything going on, do you and Dean have a relationship such that he would have said, hey, Mom, this is what's going on. I see this going on, or I see Derek or Dawson doing this.
Yes, definitely.
He wouldn't be afraid to tell you.
No, I do not believe that he would be afraid to talk to me about anything. He never has been. We're super close.
Okay, I'll pass the witness.
I'm sorry, Judge.
Go ahead.
Just very briefly. So what you're saying is that your son told you absolutely nothing about what was going on in your household, and that everything that he told to Ms. Martinez is just a straight lie.
Yes, I honestly can say that. Dean has never come to me and said, Mom, the boys are drinking. Mom, the boys are doing vaping. I smell funny things. Never, because I would have done something about this.
And so, well, I'll pass the witness.
All right. Ms. Munoz, you stated that Dawson came to live with you because Mr. Miller was being mean after he found out that Dawson was using cocaine?
Yes, sir.
You took his truck away?
Yes, sir.
What do you think would have been an appropriate sanction?
I mean, what I did, I just was with Dawson a lot. I really didn't know what to do. I tried to reach out to the church, tried to get Dawson to talk to a youth pastor. I just spent time with him. I just got him just closer to just asking him questions, finding out why he did that. Why was he turning to that? And he didn't want that. He apologized. He said he really didn't want that life. He wanted to do good in school and finish his senior year, or after, you know, he was going to be a senior. He was a junior, and then I was just there for them. I was just there for Dawson.
And Your Honor, just for clarification, it was marijuana, not cocaine.
I'm sorry, I thought it was cocaine.
No, it was cocaine because that was the child who crashed the truck.
Dawson, not Derek.
It was marijuana.
For one child was marijuana, the other one was cocaine.
Right,
marijuana.
It was Dawson. That was.
We don't have any proof of Derek doing cocaine.
All right, let me ask Mr. and Ms. Miller and Mr. Miller and Ms. Munoz, who deals with the school most of the time with regard to Dean?
I do.
Well, I do is I go through his homework every day and I sign off on his papers also. And I communicate via email with his teacher just to make sure that if there's anything that goes out to Jennifer that I'm copied also.
Okay, all right. I'm going to ask Dawson to get up and leave the room that his mother is in.
Okay.
And Mr. Miller, Ms. Munoz, do you each have a piece of paper and a pen?
Yes,
sir.
I'd like you to write down, without speaking to anyone else, who Dean's teachers are this year and what their subjects are. And while they're doing that, I'm going to ask the attorneys if you're anything, other witnesses.
I'm going to confer for just a second, Your Honor, and we'll see what. I know that the court wants to move things along, so.
All right, Mr. Miller, would you hold your sheet of paper up?
I don't know if you can see it or not, but I put down Brandy Richardson as his homeroom teacher. He's in 5th grade, so they don't bounce around. But I just can't, he's got a secondary Spanish, like second room teacher. But I don't remember her name off the top of my head. I mean, I just deal with Brandy Richardson as homeroom teacher.
Ms. Munoz?
So Ms. Richardson is his homeroom teacher. He has math and science in that class. Ms. Borath is his switch teacher, and he has reading and writing. He has Mr. Santos for music on Mondays, and he has Miss Wiggy Hop on Wednesday, Thursday, Friday for PE, and his other switch is Tuesdays. He has Miss Oliveris for art.
Okay.
I'm sorry, Your Honor. I didn't know we were doing music and PE.
Okay. All right. Argument?
Your Honor, we filed this motion because my client has been very, very concerned about the situation over at Mom's house and the mental and possibly physical. Oh my gosh, I'm so sorry. My computer's about to run out. Hold on. Okay, sorry about that. My client's been very concerned about the mental and physical, possibly physical harm that has been inflicted on this child. That's been echoed by Ms. Martinez. That's why we filed this motion. The testimony, I think, gives enough evidence to this court that Ms. Munoz is absolutely clueless. It's to the point of just, she just is not getting that these are issues going on with her kids. It's gotten to the point of neglect, quite honestly. When you know that something is going on and are just blind to it, and at the same time take an overnight job and leave these kids, including a 10-year-old, in the household, and even knowing, after we filed this motion, that things like this are going on, and all that happened to the child is an interrogation. So I do believe that this case has risen to the burden that my client needs to prove that there's been a significant risk to the mental health and physical well-being of the child. And I think that this court should change the conservatorship on temporary orders over to my client.
Ms. Tapia?
Thank you, Your Honor. Clearly, they have not met their burden. We can all agree that Dean is doing very well in school. As we know, schools are an immediate measure of what's going on with the child and what's reflective of what's going on in the child's life. Everybody has said that Dean is happy. He's happy. He's a very happy child. He's very smart, very cognizant. If all of this were going on, there's no question that he would tell his mother that, hey, there's something going on here. And my client has addressed anytime that there is an issue, it's my client who addresses the issue. My client is the one who counseled and helped Dawson and took it upon herself to continue testing him to make sure that he was doing well. It's my client who is the one who's involved with Dean in school and listed all of his teachers. You asked for all of his teachers, not just some of them. She listed them all. She can probably tell you every single grade he's making, what he did for homework over even the times that she doesn't have him in her possession. She does what she needs to do. I think that what we have here is a 10-year-old child who's trying to make everybody happy. And that's one reason why the code says that they need to be 12 or older, a little bit more mature and a little bit more emotionally mature. But they agreed to take the hair follicle test. Those all came back negative. There's no proof of anything that's going on. There's no, again, if there was something going on, I'm sure Dean wouldn't just tell his father, he would tell his mother too what was going on in the house. And if he was being bullied or saw any parties going on or anything like that. I believe that that it is in Dean's best interest that the orders that are in place remain and that they not be changed, that it is in his best, if there is anything that would be required, possibly there needs to be some counseling going on as to why Dean feels why he has to go and try to please everybody. Maybe he does need some counseling, and there's some family participating counseling that can go on to address any issues with regard to that. But as far as meeting any burden to change conservatorship from joint managing conservator to sole managing conservator and to change the primary residence from my client to Mr. Miller, that burden has not been met. And we asked respectfully that this court deny petitioner's motion and continue that the orders remain in place. The existing orders remain in place, Your Honor.
All right, Ms. Duke, on your motion for me to confer with the child, I don't think that it's optional for me to confer with the child on changing at the temporary orders hearing the previous final order of the court. I've listened to the evidence carefully in this case. I've got to be blunt with both parents and say this is one of the cases I get that I go back and forth in my head who I am aggravated at. Both of you need to communicate a whole lot better over Dawson and Derek and Dean, and especially Dean because he's the youngest. I don't see that there's a joint plan between the two of you to do anything. I'm concerned that Ms. Munoz doesn't appear to have any plan to do anything about Dawson and his drug use, but then he passed a hair follicle test. So maybe that's all that needed to be done was for him to get caught. I don't know. I know that you can typically only catch his chronic users and not occasional users on a hair follicle test. I'm concerned that we've heard a lot from Ms. Munoz about what she doesn't allow. Probably showing my age, there was a Hank Thompson song when I was a kid called Mama Don't Allow. And the gist of it was there was a whole lot of things that Mama don't allow, but the singer and his brothers all did them anyway. And I suspect there's certainly been times when that's what's been going on here. Given that the tests were negative, given that Derek were informed and moved out, I will modify the temporary orders to state that Derek Miller may not return to the residence under temporary orders overnight. And that if he moves back in, that I will change the conservatorship so that the primary conservatorship lies with Mr. Miller, but absent that, I will not change it today. And I want y'all to speak with Ms. Martinez, I gotta say, ma'am, I don't doubt for a bit, I don't doubt at all that Dean expressed his concerns to you and that he feels like he's under a lot of pressure. I'm just not at all certain that a change would alleviate that pressure. I don't know what the pressure is. A lot of it is that he's trying to please two kids or two parents. I'll say also to Ms. Munoz, ma'am, if you look at the temporary, at the standing orders from the court in this county that were served on you whenever this motion was served, part of it says that no parent or anyone involved in the lawsuit and no one of their friends or family members may discuss anything to do with the litigation in front of the child or the children. And you violated that rule. And I'm not happy about that. And it needs to not ever happen again. Yeah, there may be things you need to talk about in front of the child, but with the child that you found out through litigation, but you need to figure out a way to do that without going through an affidavit bullet point by bullet point.
Yes, sir.
Is there anything else I need to rule on right now?
No, Your Honor.
No, Judge.
Okay, all right, we're gonna be in recess until 20 after. And then we'll come back and we'll start the hearing with Mr. Cedillos and Mr. Trevino. If there are documents I need to read, pleadings or anything like that, please send them to me in chat so I can look at them before we get started.
Judge, I didn't hear what time you said.
Let's make it 12:25.
12:25. Your Honor, send you documents in PDF form in chat or email?
Chat.
Will you be excused, Your Honor?
Yes, everyone else is excused.
Thank you, Judge.
Thank you.
And are y'all going to get this reduced to writing and e-file something, or what do you want to do?
Is that how you'd like us to submit the order?
That's fine. If you get it done while I'm still on, you can just come back online and post it in chat.
Okay. Okay. Thank you, Judge.
Okay, we'll be back at 12:20.
Hello? No. Hey, do you want to email me those pictures so I can show them to the judge?
Mr. Trevino, you're not muted.
Oh, sorry. I didn't even know I was on. Hang on a second. hang on. Judge, were you calling our case already?
Yes.
Oh.
1225.
I was still uploading the documents, Judge.
Okay, I will, go ahead.
Okay, let me just get that document to you, Judge.
Okay, I've received a deed of trust and something called Owen for Mr. Cedillos and a warranty deed for Mr.
Yes.
That's right.
There we go.
Oh.
It's because we both have our speakers on. It's off.
And I'm also sending.
Turn it down. Okay.
Wow. I can't get the Zoom to open up.
You can't get what to open up?
The Zoom, it just has a picture of you, but I can't get the full screen on it. Let me see. Okay, there you go. Nice video, but then I don't see any. I just see the attachments. Are you able to see me, Judge?
Yes.
Okay. I sent a warranty deed and bank statement.
Right.
That's what I've sent so far. And I can just cite statutes, right?
I can't hear
on
you.
the family.
What's that?
Can I just cite statutes on the family code? Or do you want me to?
Your audio was breaking up. Please say that again.
Okay. If I'm quoting the family code, you have a copy of the family code with you, right, Judge?
Yes.
Okay, so I don't have to send that. And I had some pictures to show you, but I can't.
We know it's separate. We know it's separate.
What happened there? I've got it all now. Good. I hope you're doing well with the news of COVID. I had my daughter test positive about 3 months ago. Lost the sense of taste and smells. It's scary.
I don't think it's anything. My oldest son has autism. He's special needs, but he threw up yesterday, and we're not allowed to take him back, so we went and all got tested last night. We won't do the instant test. We've got to wait for the results to come back.
It's frustrating. I know. Well, I hope all is well, Judge.
Oh, it'll be fine in the long run.
Okay.
All right. And how many photographs are there?
I think there's 2.
How many?
I think there's 2.
And what are we having temporary hearings over?
Well, Judge, well, it's Mr. Cedillo's motion, but I think the basic issue here is who gets to stay in the house, the interim, until final hearing.
Yeah, that's correct, Your Honor. We have two elderly people. My client is 68, and Mr. Trevino's client is 78 years old. They've been married about 17 years.
That's Mr. Owen. Dennis, you might need to unmute your computer. Mr. Owen?
Yes.
Go ahead. There you go. You're unmuted.
You're good. You're good.
All right. And there's another.
There's a. Okay. All right.
Who is near someone else?
When Miss Wendy and her father Dennis are probably in close proximity, so I asked that only one of you unmute at one time, so you don't get.
Yes. And only one of you have speakers on at one time, because it'll pick up the difference in the speaker. It'll ignore what the computer with the microphone is on. It'll ignore what it's broadcasting out from the speakers. But there's one in the next room. There's a difference. By the time those sound waves travel over, it'll give you feedback. So let me unmute that.
Okay.
All right. Is there another photograph coming?
Not for me. We have one photograph. We have a marriage certificate and a warranty deed.
Okay. Is anybody disputing the marriage?
No.
No.
Okay. All right. So who all do we need to have sworn in?
On my end, Wendy and Dennis Owen. I mean, Wendy Valdez and Dennis Owen.
And on my end, my Cheryl Owen and her daughter Misty Cavazos.
Hold on.
I don't see them.
So is Mr. Trevino,
Yes, Your Honor.
Dennis Owen, Wendy Valdez.
Yes.
All right. And Mr. Cedillos, it's Cheryl.
Cheryl Owen and Misty, her daughter Misty.
M-I-S-T-Y?
M-I-S-T-Y, yes. Cavazos.
Cavazos?
Yes, Your Honor.
And this is the one we talked about, Judge, where I'd like to have Mr. Warren as an interpreter.
Okay, let me ask everyone except, actually, Ms. Valdez, can you just go in and stand next to Mr. Owen for the time being? Okay. And I'm going to ask Cheryl Owen to unmute her computer. Okay, I'm asking you to unmute. Here we are. All right, so.
Get feedback.
Okay, are they at your office, Mr. Cedios?
Can you hear me? No, my speakers.
Okay, we can only have one set of speakers going. If you're in the same, if you can hear with one another. I just said to Mr. Trevino that you get feedback, so it's not just the microphone, but you got to have one speaker too. If it's where they can hear.
You can turn your speaker up. I'll mute mine.
All right. So, Dennis Owen, Wendy Valdez.
It's still, it's a speaker.
One speaker, one microphone per building.
Okay, mine's up.
All right, that sounds better. All right. Dennis Owen, Wendy Valdez, Misty Cavazos, and Cheryl Owen. Would you all, each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, sir.
Mr. Owen?
Yeah.
Okay, I couldn't hear you, Mr. Owen.
Yes, Your Honor.
Okay. All right. And now for Misty Cavazos. Do you swear or affirm that you will, to the best of your ability, accurately repeat to the court and the attorneys and the witnesses the written communications that Cheryl Owen makes to you?
Yes, I will.
All right. Go ahead, Mr. Cedios.
Your Honor, I think I'd like to call Dennis Owen first.
Go ahead.
Mr. Owen, can you hear me okay?
Yes, sir.
Okay. How long were you and Cheryl Owen married?
17 years.
Okay. And where do you live at now?
2997 County Road, 357, Livonia, 78121.
Hang on. I'm sorry. I think Wendy needs to turn off. Go ahead and turn down that other computer.
I don't have one on. Let me just turn it off.
Yeah, just turn it off, please. Okay, no more feedback?
All right, go ahead, Mr. Cedios.
Okay. Mr. Owen, you currently live with your wife, Cheryl Owen, is that correct?
That's right.
How are you two getting along right now?
We don't communicate.
Okay, but nobody's violent towards each other, is that correct? Is that safe to assume?
That's correct. That's correct.
Okay, and you are cordial to each other?
Yes, that's correct.
Okay. Now, in 2004, your wife had a stroke, is that correct?
2014.
I'm sorry, 2014, you're correct. So you had the power of attorney over your wife's finances, is that correct?
Yes, that's right. Yes, sir.
Okay, and in 2004, that home that you live in right now, you and Cheryl took out a loan, is that correct?
I think it was 2008.
Okay. All right, you think it was 2008, okay. And what was the purpose of that loan?
We were going to do some remodeling, and I had a business and it had slowed down, and I was trying to keep my guys afloat.
Okay. And your wife, Miss Owen, does earn some money, is that correct? She has Social Security and a retirement.
Yes, Social Security, that's right, yes.
Does she have a retirement?
No, sir.
Don't say nothing.
Okay, and there has to be no whispering to the witness, so go ahead. I'm sorry, I had muted Miss Owen accidentally.
Pardon?
All right, go ahead, Mr. Steels, re-ask your question.
Mr. Owen, you have control over both bank accounts, over 2 Wells Fargo accounts, is that correct?
That's correct.
And her money from her Social Security goes into one of those accounts. Is that accurate?
That's correct.
And she's been making some payments on some utilities and
Objection.
other essentials of the house. Is that accurate?
Objection. leading.
Sir, I'll overrule for temporary orders on something like that.
Go ahead.
Mr. Owen? Can you hear me?
What was your question?
Yeah, she's been, your wife has been paying for utilities and other essential bills in the house. Is that correct?
No,
She hasn't paid any?
not in the near recent future. No, recent.
Well, since you have control over the account, you've been paying some things out of that account, haven't you?
Oh, yes, sure.
Okay. How big is your house?
1,500 square feet.
Okay, and it accommodates her as far as the accessibility because of her stroke. Is that accurate?
Yes.
Okay. Would you describe for the court her physical disability?
Yes, and my best disability too. Yes.
I'm sorry, I didn't hear it.
Yes, both of our disabilities. Yes.
Would you describe for the court Ms. Owens' disability?
She is. You want me to tell you what her disability is?
Yes.
She's nonverbal, and she's partially paralyzed on her right side.
Okay, so she has trouble climbing stairs or going up steps. Is that fair to say?
Yes.
Okay. Do you have a son that lives close to where you live now?
No, about 10 miles.
Okay, and he has a home.
Yes, he does.
And how big is that home?
Probably 1,200 square feet.
Okay, and how many people live there now?
3.
Okay. At one time in your well, is there also an RV at that house? Your son's house?
I think he owns an RV. Yes.
Okay. So at one time were there more than 3 people living at that house in the recent past?
I don't know.
Okay. And you also have, I think I asked this question, I want to make sure, you have a power of attorney over your wife's finances, is that correct?
Yes, that's right.
Okay, and during these temporary orders, are you willing to give up that power of attorney so she can go ahead and manage her own funds?
Yes.
Okay. And your wife doesn't drive, is that correct?
That's correct.
Okay. Do you get along with Misty Cavazos?
To a degree.
Okay. And she goes and takes groceries to her mom there. Is that fair to say?
Yes.
Okay. I'll pass the witness, Your Honor.
Right. Go ahead, Mr. Trevino.
Mr. Owen, for the record, name is Dennis Owen. Is that correct?
That's right. Yes.
And when was the date of marriage to Cheryl Owen?
It was March 31st, 2003.
In 2003. Okay.
Yes.
And the property that we're talking about was purchased by you, what date?
February 24th, 1998.
So you purchased that house in 1998, and do you, I guess, Your Honor, I'd like to mark exhibit number, or respondents exhibit number 1, the warranty deed, Your Honor. It is in your chat.
Mr. Sidios?
Fernando, did you send it to me? Well, it's a matter of public record, but if it's just a warranty deed, I'll agree that it is. I'll no objection, Your Honor.
All right, shut that phone off. Okay. All right, without objection, we'll call that Respondents Exhibit 1 as admitted into evidence.
And what I'm trying to do here is pull it up here on my computer real quick, Judge. And since I all right, we're right here. Mr. Owen, do you have a copy of the general warranty deed in front of you?
Yes.
Okay, and would you tell me the date that general warranty deed has?
All right, let me just ask the attorneys, is everyone in agreement that the property is was originally under inception of title Mr. Owen's separate property because he was a single man when he entered into the purchase contract for him?
Yes, Your Honor, we agree.
And is it also the homestead of the parties?
It is a homestead of the parties.
Your Honor, I argued separate property, that it has been commingled with the community estate, even though the inception of title rule would still keep it a separate property because he purchased it while he was a single man, and there's the proof, the general warranty deed that has been into evidence supporting the saying. And at that time,
Okay, but again, this is just temporary orders, so
Yes.
yeah, there may be a claim for reimbursement, but for temporary orders, it's the homestead, and the judge has the power to give either one of them exclusive possession of it.
Yes, Your Honor.
Temporary orders. We're all on that same. Okay, so
We're aware of that.
there's no objection. I will admit I think 2005 deed of trust, and we'll go on from here.
It's all the way.
Okay.
May I proceed, Your Honor?
Yes, go ahead, Mr. Trevino.
Mr. Owen, earlier you testified that you have somewhat of a cordial relationship with your wife, with your current wife that's living with you in your home, correct?
Yes.
Okay. But would you say that there's some issues that you have with her living with you that would necessitate for her to leave or for y'all not to live together?
Yes.
And for instance, well, let me go into a little bit of background. Are you currently disabled?
Yes.
And what is your disability?
I have to use a walker.
Okay. And what is the reason why you have to use a walker? Did you have any surgeries or anything?
Yes, I had back surgery in August, I think.
Of this year?
Yes.
Okay, and you haven't completely healed from that, correct?
Oh, that's right. Yeah. No, I have not.
In fact, have you recently been involved in a car accident as well?
Yes.
And it hurt your back more, correctly?
Yes.
Okay. Now, you have to have this walker in order to get anywhere, correct?
Yes.
And has the doctor told you to try to use ramps to move to?
I couldn't understand you.
Yeah.
Do you require ramps to move up and down to your home?
Yes.
And it's difficult for you to do it without that, correct?
Yes.
Have you outfitted your house to be able to move around inside your house with your disability?
Yes.
And can you give me examples of what you've done to your home so that you may move around?
Well, we have ramps in front. We have a walk-in shower, disability shower, handicap shower.
And you require, correct?
For both of us.
Okay. Now, when you say both of us, is Cheryl unable to move around with, or does she need assistance like a cane or a walker of any sort?
No,
She has no problem moving around?
no.
Can she climb stairs?
Yes, probably some bit, yes.
Can she,
I didn't hear the question.
I'm sorry, can she climb stairs was my last question.
Yes,
Can she climb stairs and move around easier than you can?
yes.
Okay. Now, did you at some point get a healthcare provider to assist you in your movement recently?
Yes, I did.
And what time period was that?
That was early September. Early September.
Okay. And was your wife living with you at that time?
No.
So she had moved out?
Yes.
Where did she move to?
Our daughter's house.
And how long was she gone?
5 weeks, I think.
Okay. And the daughter that you're speaking of, is that Misty Owen, the one that's providing the translation for her mother? Is that correct?
Misty Cavazos.
Misty Cavazos, I'm sorry. And does she have her own separate room in Misty Cavazos' house?
It was my understanding.
And how did you understand that?
One of her daughters had gone to college and she had given Cheryl her own space.
Okay. And so there was mention of your son that has a home, correct?
Yes.
And how many people live in that home?
3 people.
And how many bedrooms are in that home?
2 bedroom.
Okay. And so there is no place for you there. Is that correct?
No. And there's stairs going inside into the front.
Okay. Now, once again, with regard to the inability to be able to stay with your wife, what does she do that makes it difficult for you to live with her as well, not as a couple, but in the same home as roommates?
Well, she hoards stuff up in the front room, like the vacuum cleaner and stuff that she wants to take during the divorce. And part of it's okay, but part of it I need to use.
And does she not allow you to use it?
I have to ask, and I get some controversy sometimes.
Okay, but you're not doing the actual vacuuming. You have people to come help you, correct?
Yes, that's right.
And is she amiable with the people that come by to help you? Is she friendly to them?
No, not all of them. No, absolutely no.
Okay. Now, you mentioned that she piles all the stuff. Are you saying? Can you tell me where she puts these items that are community items? Where does she put them?
Well, there's stuff in the front bedroom where she stays, and then there's some stuff in the dining room, and then she has partitioned off areas of the kitchen cabinets that she puts her stuff in.
Okay, and does she give you access to that?
If I needed the dishes and stuff, yes.
What about your vacuum cleaner and your other stuff that she keeps in her room? Are you allowed to go in her room?
No.
Does she go into your room?
Yes.
Okay. And now, one time you were coming home from HEB, do you recall that moment?
Yes.
What happened when you were trying to get in the door?
I was unlocking the door and I dropped all my groceries and the dogs ran out the front door.
And did you have any kind of altercation with Cheryl?
No, not really until I got the groceries picked up. And then I just told her, you don't have to like your neighbors to be neighborly.
She did not help you with with the groceries?
No.
Is she better able to help you?
Yes, she can help.
But she refuses to help you with groceries, correct?
Yes.
Now, what is the age difference between you and Cheryl?
4 years, I think.
And how old are you, sir?
72.
And how old is she?
76. I mean, 66.
Okay. All right. So that's 4 and 7. Hold on. What's the age difference?
4 years.
Okay. Well, +2, right? If she's 76 and you're if she's 66 and you're 72, that's here.
4 years younger than I am.
Okay. Do you need assistance in helping you clean the house and preparing meals and all the other household activities that are required to keep a house? Do you need assistance with that?
Yes.
Does she provide you any assistance with that?
No.
And when you hire people to come in or get people to come in and to help you, does she make them feel at home or does she help them find items to use like the vacuum cleaner, or does she prevent?
No. No.
Does she prevent them from using those items?
Yes.
Okay. So you can't get your household in order because she's interfering. Would that be a correct statement?
Yes.
Now, did you have an incident happen in your home with Misty Owen's husband assaulting somebody?
Yes.
When did that occur?
September 11th, I think.
September 11th. Okay. And what was that argument about? And what was he arrested?
Yes, he was.
Okay. And that is Cheryl's daughter. Is that correct?
Cheryl's daughter's husband.
I'm sorry, I couldn't hear the question.
That's Cheryl Owen's daughter's husband, correct? The one that got arrested?
That's Misty Cavazos' husband.
Sorry, Misty Cavazos' husband, which is Cheryl
Yes.
Owen's daughter. That's Cheryl Owen's daughter, correct?
Yes, that's right. Yes.
And do you recall what his name is?
James
James Owen.
Cavazos.
James Cavazos. And did he assault you?
No, my son.
He assaulted your son in your home?
Yes. And his girlfriend.
And he has been forbidden by law or told by the police officers not to come back. Is that correct?
Yes, that's right.
Does Cheryl Owen come to, does Misty Cavazos come to your home regularly?
Yes, she brings groceries and picks her mom up once in a while, yes.
Now, is she buying groceries for you?
No,
You have to provide for your own groceries, is that correct?
that's right, yes.
Okay. Now, do you share your groceries with Cheryl?
Yes, I could, she's welcome to them.
Okay, but she does not let you use her groceries, isn't that correct?
That's right.
Now, where do you normally keep cleaning supplies?
In the pantry?
And they're no longer there, are they?
No.
Why not?
Cheryl put them in the front bedroom.
And you don't have access to that bedroom, is that correct?
That's right.
Does she prevent you to even using her sugar for your coffee?
We have separate sugar bowls, that, you know.
But she's not very helpful in other words, she doesn't help you to live better at this time, correct?
No, not at all, no.
And you had that property for yourself, living as a single individual more than 5 years prior to you even meeting Cheryl, is that correct?
That's right.
And,
Well, we had met, but we hadn't dated. We'd known each other, but we didn't. 5 years before we dated.
and she didn't move in with you prior to marriage, is that correct?
That's correct. No, she did not.
So she moved into your house and y'all have lived there since the marriage, correct?
Yes.
For the exception of the 6 weeks that she left, correct?
Yes.
Now, did you hear any complaints about her stay with her daughter's house?
No.
Okay. And has she done any other childish things?
I don't know what you.
Has she ever taped things shut?
Oh yeah. She tapes she puts tape on a whole closet like that's going to be her stuff, and you know. We had given her one color tape and me another color tape, and she tapes whole doors shut and stuff that's mocked up.
And you're not supposed to have access to what she taped shut, right?
That's right.
And you haven't put any tapes on anything, right?
Well, I had, yes, some of the stuff that was my family's.
Oh, your family. Oh, you're talking about you mark it with the tape. You don't shut doors with it, correct?
No, that's right. Just marked it. Yes.
Now, you have neighbors across the street from you, correct?
Yes.
And you're friends with them. So if something were to happen to you, if you were to fall, you could call on them and they could come instantly to help you, correct?
Yes.
All right. And you have that we were talking about your son. He lives about 10 miles away. Is that correct?
That's right. Yes.
He would be able to assist you if you were to fall or have anything happen to you, correct?
Yes. I have neighbors that watch out. I've been there for 22 years, so I have neighbors that we're all good friends.
Okay. So you feel safe in your environment with your disability?
Yes. Yes.
And you haven't been released of that disability, have you?
No.
In fact, you recently injured yourself more, correct?
Yes.
And it's hard for you to move around, or is it easy for you to move around?
Well, it's hard to move around.
So very slow paced, aren't you?
Yes. Not good balance.
You don't have good balance?
No. I need a walker or a cane close by. Yes.
Okay. And are you able to drive at this time?
Yes, I can drive.
Okay, but do you need? Well, I mean, your foot's not injured, correct?
That's right.
And what parts of your back are injured that keep you from moving fast or normal?
The lower part of my back's where I had the surgery, and I was hurt in the upper part of my back when we had that car accident.
And you're right now. You receive what do you call it? Social Security, is that correct?
Yes, I do.
And do you know the exact amount you get monthly?
$943.20.
Okay, and that's your only income, correct? I mean, your Social Security is the income that you receive, but does Cheryl also receive Social Security?
Yes, she does.
How much does she receive? If you have knowledge of it.
$13.43. That's after taxes.
Is it 14? Did you say 1423 or?
$13.43.
Okay. So she earns more than you do at this time, correct?
Yes, that's right.
What?
Now, Are you asking this court to,
It-
are you asking?
Hers is 1423.80. Hers is 1423.80.
Oh, okay, so she makes approximately $500 more per month than you do,
Yes, that's right.
and that's a Social Security, correct?
Yes.
Okay. Does your wife, does Cheryl Owen drive?
No, she doesn't.
She's not allowed to because?
She can't drive because of her stroke.
Okay. The doctor said no, correct?
Yes.
But she can move around. She can walk around and
Yes.
easily, correct?
Yes.
Okay. Her stroke, well, you mentioned the partial paralysis on her left side. Is that partial paralysis keep her from moving around and doing things?
No.
Okay, so the way you outfitted your house with the ramp and the railings and the things that you put in your bathroom and the walk-in shower, that was for your disability, isn't it?
Well, partially, both of us.
It helps both of you.
Yes, it helps both of us.
Okay, but she's more able to move around and get into the shower if she needed to than you are, correct?
Yes, yes,
She's more mobile or capable, correct?
yes.
Other than your back injuries, do you suffer from, and you said your lack of balance, do you suffer from anything else?
I have arthritis, and I have one knee that's been operated on.
Your knee was replaced?
Yes,
And how's that going right now?
it does pretty good.
Okay. So you've had multiple surgeries and you need assistance in moving around, and your house is suitable for your needs at this time, correct?
Yes,
And you're saying that your wife is more capable to move around and, go up the stairs and stuff, more so than you.
yes.
Now, talking about I guess the count, I mean, you are power of attorney for your wife at this point, correct?
That's right. Yes.
But you're not asking to keep that power of attorney in any way, shape, or form, correct?
No,
Have you made any kind of expenditures against what would be in her interest, or do you do so in her interest?
mostly in her interest, yes.
Have you been spiteful in any way in spending any of her funds?
No,
So it's mostly for the benefit of her or both of you, correct?
her, a benefit of her, but me also to a degree.
Okay, like paying light bills and stuff, or what?
Yes,
Are those the kind of expenditures that you're talking about that you've done? You haven't done anything evil or deceptive, correct?
no,
Okay.
she wanted to travel. We bought a travel trailer and a truck. We traveled for a while.
Oh, but not
But that's
recently.
what
Not since the divorce, right?
No,
I mean, since the filing of the divorce, rather.
no,
Have you made any expenditures, any kind of unusual expenditures since Cheryl filed for the divorce?
no, none.
None? Okay. Have you made any expenditures out of her account since she filed the divorce?
No,
Okay. So you're fulfilling your duties as I guess having a power of attorney. You are fulfilling your fiduciary duties to her, correct?
yes.
We mentioned earlier that you have people come to assist you. I'm hearing echo. It's not for me.
Okay, I'm hearing echo.
Well, I think I've covered the basic questions, but you've said that the people that come help you, she gets in the way of that, correct?
Yes, yes. She growls at her.
All right, I pass the witness to.
Mr. Cedillos?
Ms. Carroll, when I originally asked you,
All right, now there's all kinds of echo. All right, well, we've got microphones on both. We only have one speaker and one microphone on if they can, within range of each other.
okay. Mr. Owen, when I originally asked you a question about how she got along with you, you said she was cordial?
We don't speak. We don't communicate. We don't fuss and fight.
I didn't hear the answer.
We don't communicate, but we don't fight.
Okay. And the incident with James Cavazos, he's never been aggressive or violent towards you. Is that correct?
Well, just screaming and hollering at me that day.
Okay. Has Misty Cavazos been violent towards you in any way?
No, not physically violent, no.
Do you earn veterans disability also?
Yes.
And how much?
Objection relevant.
Overruled.
Disability, Your Honor. Well, overruled.
It can't be divided, but I think I can take it into account on temporary orders for where they live.
Yeah.
I think.
Mr. Owen?
Just a minute, we're looking for it. Do we need to provide that? Judge said yes, I think so.
Taylor, do we need to get that amount?
Well, do you know in the top of your head?
Not off the top of my head, no. 3438.
$3,438?
Yes.
Okay. And you were in the construction business, is that fair to say?
Yes.
That's irrelevant.
You know how to
overruled.
You were in the construction business, and you know how to outfit your house and other houses if necessary, don't you?
Outfit them for what?
For disability.
Yes.
Okay. And you originally did the house you live in Lavernia for your wife so she could get around. Is that correct?
Yes.
Okay.
I've added stuff since then, since
sorry?
my disability. I've added stuff since my disability, yes. My son put up some more grab bars and stuff.
Okay. I'll pass the witness, Your Honor.
Mr. Trevino?
And just a follow-up question on your wife's disability. When she first had the stroke, she probably was in worse shape than she is now. Is that correct?
Oh, yeah, she could do nothing.
Back then, she couldn't do anything. That's why you built those things, correct?
That's right.
But now, does she require to have those items on a house in order to move around?
No.
So she no longer requires them, but you do, correct?
That's right, yes.
Okay. Pass the witness.
No further questions.
Okay, what other witness?
Misty Cavazos, Your Honor.
All right, go ahead.
Would you state your name, please?
Yeah, I need to ask you to get closer to the microphone. And if necessary, Mr. Cedillos, if you would, you're both muted right now, but if.
Misty Cavazos.
Okay. Cheryl's daughter, is that correct?
We can't have both microphones. So if y'all may have to sit together, you may have to go on there, Mr. Cedillos. Again, if they're within range of each other, you can only have one mic, one speaker, or they will get feedback.
Okay. Your mom came to live with you at one time?
Yeah.
And how long was that?
For approximately 4 weeks.
Okay.
Sorry, I couldn't hear that.
4 weeks. From August 14th till September 11th.
Okay.
All right, Mr. Sidios, do you have speakers going on both places?
Turn it down. Okay. Ms. Cavazos, is your house outfitted for a disabled person?
No, it is not.
Okay. Would you describe for the court your house, the stairs and the steps?
Yes. So when you come in from the carport where we park, there's a
Ma'am, I
step.
can't hear you. You need to speak up, please.
Where's the speaker? There's a step down. You have to walk across and then 2 steps up into the house. My back steps are very steep. So I have to assist my mother walking in and out of the home.
How about inside the home?
Well, inside the home, it is flat. I don't have stairs within the home.
Okay. Is your mom more comfortable at her present house in Lavernia?
She has the freedom to move about in her home in Lavernia. At my home, she's very restricted.
Okay. Have you ever been disrespectful or unkind to Mr. Owen?
No.
Okay. Have you ever seen your husband, James Cavazos, violent towards Mr. Owen?
No.
Okay. Your mom is welcome at your house, is that correct?
Yes, always.
But she's more comfortable at her house in Lavernia.
Yes, and I do not have an extra room for her. I have 5 children. They are all living at home, and I have 2 that are in one room that share a room.
Okay. Your mom's only source of income is the $1,400 that Mr. Owen testified to?
Yes.
Okay. All right, I'll pass the witness, Your Honor.
Go ahead, Mr. Trevino.
On mute.
I'm sorry, Miss. Your last name was Cavazos, you said? Okay. You mentioned earlier that your mom's welcome anytime in your home, and in fact, you mentioned, or it was mentioned that she stayed for a prolonged period of time, correct? And there was no problem with that at the time. She was able to be assisted by y'all and move around and move about inside your home, correct?
Yes.
And did she, when she was there, she had her own room, isn't that correct? She was sleeping in her own room?
She did. My college daughter had to move home because her roommates got COVID.
I'm sorry, I couldn't hear you.
My daughter had to move home from college. Her roommates got COVID. She could not stay there.
Okay. So, but your daughter's able to stay in another room if necessary to accommodate your mother, right? She would do that for grandma?
I already have 2 sharing a room in my house, so.
Okay. But you would agree with Mr. Dennis Owen that your mom is more capable to move around than he is, correct?
No, I do not agree with that at all.
Okay. And what do you base that belief on?
I would really like you to see my mother walk. She has a hard time. She cannot bend over very well to pick things up off the ground. Her balance is bad. She doesn't hear in one of her ears, so that throws her balance off a little bit. She needs assistance when she's walking, especially upstairs. Small steps are hard, even to get into the lawyer's office. The step up to get in is, I have to assist her. There's no rails.
Is she currently using a walker or a cane?
No, she doesn't. She doesn't go very far.
Okay. And she's able to move around though inside a plain 1-story house, correct?
Sure, she can navigate it.
And she's able to grab objects out of the fridge without any problem?
Yes.
She's able to carry groceries by herself?
If the bag is light enough, yes.
Okay. So earlier we mentioned about your husband getting arrested for on an incident that happened at Mr. Owen's home. What prompted that?
I don't know. I wasn't outside.
Okay. And who did he strike?
Troy Owen, the son.
Okay. Has your husband ever been arrested prior to that?
No, absolutely not.
So, but you don't know what that incident was about then?
No. I don't know what started it. No.
Does your husband get along with Mr. Owen?
Yes.
Okay. All right.
I'm assuming Jenny Owen, right?
I'm sorry?
I don't know which Owen you're referring to.
Oh, Dennis Owen.
Yes.
Okay. All right, I'll pass witness.
Go ahead.
Nothing further, Your Honor, of this witness.
Okay, what other witness do you have?
I'm going to call my client, Cheryl Owen.
Who?
Cheryl Owen, Your Honor, my client.
Your client, okay. I heard you say Mark. All right.
You're gonna need her board, or she gonna need her board. She has the board, Your Honor. She's gonna write answers. Miss Owen, are you comfortable in your home right now in Lavernia?
She wrote yes.
All right, and Ms. Cavazos, what I'm going to ask you to do is, and I understand you've probably never been a translator before, but that's basically, I swore you in as a translator as well as a witness. Ideally, once the translator is sworn in, if you're reading the transcript, you'll never know there's a translator there. So just don't say she said yes, just read the words, please. Go ahead, Mr. Cedillos.
Are you able to get around your present house in Lavernia?
Yes.
Are you cordial towards Mr. Owen, your husband?
Yes.
Are you asking this court to let you remain in your house in Lavernia?
Yes.
Okay. Is it fair? You heard your husband's testimony about you being rude to other people. Was that correct?
No.
You're not disrespectful to his caregivers? You're not disrespectful to his caregivers or care providers? Are you disrespectful to his care providers?
Yes.
Is that a yes?
Yes. Are you rude to the people that come over to visit him?
Yes.
Okay. Have you ever been violent towards Mr. Owen? Have you ever been rude, violent or towards Mr. Owen, Dennis Owen?
Yes.
Okay. In what way, ma'am? Did you strike him? Did you strike Mr. Owen?
I don't think I understand.
Did you hit Mr. Owen? Since the filing of the divorce, have you hit Mr. Owen?
Yeah. You have to write it.
Marita?
Yes,
Okay. But you still feel you can get along with Mr. Owen in the house?
yeah. Yes,
Okay. I'll pass the witness, Your Honor.
Mr. Trevino?
I have no further questions of Ms. Cheryl Owen. Mrs. Cheryl.
Anything else, Mr. Cedios?
No, Your Honor, just argument.
All right. Anything else, Mr. Trevino?
I have Miss Wendy
Valdez?
Valdez.
Hello.
All right.
Wendy, how are you related to Mr. Owen?
I'm his stepdaughter.
Okay, so you're not from, Cheryl is not your mother then?
Correct.
All right. Now, have you been, since the divorce has been filed, and maybe prior to that, not too far prior, what have you noticed about the relationship with Mr. Owen and his wife?
It is totally silent in the house. She sits in the living room and watches TV, and he sits in his bedroom basically 24/7, except maybe go outside for a minute. But there is zero communication in the home.
Would you say that they have a good relationship or an amiable relationship at this time?
I would say no, because when he does need help, she doesn't offer help. For example, the day he came home, dropped the groceries, the dogs got out, and she just sat there on the couch and watched.
Did he ask for?
I know we have bought her groceries before, tea and bananas, because she was out and we were out getting groceries, and she refused to eat them because we had got them. We had bought them for her.
Okay. Did you have a healthcare provider helping your father with
Yes, we had a home health care individual come in that was helping him clean and cooking his meals and doing his laundry and providing assistance when my brother and I were at work.
Okay.
And due to,
was she welcomed there by Cheryl?
So we asked her not to come anymore because Cheryl came home, and due to past behavior of Cheryl interacting with those type of people, we did not want to put her through that. So we told her, we were letting her go.
I'm sorry, I don't mean to speak over you. Those type of people, you mean people that are assisting your dad?
We had a lady come over to do a market analysis on the home to get an idea of what the home was worth, with the divorce litigations. And Cheryl actually went to high school with the girl, and she was rude to her, and we couldn't even figure out why. She's rude to the guy who's helping mow the yard. She's rude to the neighbors that just say, "Hi, do you need anything?" I mean, I will speak for myself, but I feel like that Cheryl and I have always had a good relationship, and she's even rude to me now. And I still try to speak to her every time I go in the home and ask her if she needs anything, or if I'm, bringing tacos. Cheryl, do you want a taco? And so I know she's upset with me too.
And because of the,
I can feel it.
Well,
Sure.
What has she done that's out of the ordinary since the divorce was filed?
So since the divorce has been filed, everything that she wants, she has tried to cram into this front bedroom. And I don't understand why. Cleaning supplies, brooms, dust rags, vacuum cleaners, mops. It's just all crammed in this front room. And when we go to try to clean or anything, she gets very upset and doesn't want us to use it. So we've went out and bought things so we can clean the house. Now, she doesn't want you touching any of her stuff. She doesn't want you going in her room. Nothing.
Does she provide any physical assistance to her husband to move around or help cook his meals or anything like that?
No, sir. She cooks for herself only.
And she doesn't offer him any food?
Not that I know of, and I've asked because I bring him food because she doesn't offer him any.
And that's not, would you consider that a workable relationship to live in the same household under those conditions?
You know, it's very awkward for me while I'm there, so I can't imagine with either one of them living there full time with each other, how awkward it could be with just crickets all the time. And, you know, I wouldn't want to live in that situation. If it were me getting a divorce, you know, I wouldn't want to stay there.
You don't have any animosity towards Cheryl, do you?
Absolutely none.
You're just observing what's going on between them, and correct?
Yes, sir. I try to help both of them when I'm there.
Okay. And your father does not have a suitable place to go other than his homestead?
That's correct.
All right. Pass away.
Cindy, right? I'm sorry, Ron. Wendy, can you hear me?
Yes, sir.
You can hear me?
Yes.
Okay, earlier, the first part of your testimony, you said there was total silence between them.
I couldn't understand that.
Wendy, you said that in the first part of your testimony that there was total silence between them.
Yes, when I am there, they do not speak. They do not use any body language, sign language, verbal, nonverbal, anything that I've witnessed while I'm there.
Okay, but have you ever seen Miss Owen be rude or ugly to him?
Yes, sir, I have.
In what way?
The day he came home from back surgery, she did not like the circumstances and told him that he had to leave his home.
Okay, that was before the.
And then I've also seen her, you know, in her own ways, in her own way, since she's had her stroke, you know, be angry with him and point and, you know, show aggression just in a frustrating way towards him several times.
Was that before the divorce though, the surgery?
No, that's been since.
After the divorce was filed in October?
Yes. 2 days ago on Saturday.
Okay, I'll pass the witness, Your Honor.
Just one follow-up question. As to Mrs. Owen, how would you characterize her ability to communicate with others other than the tablet that she uses?
It's hard unless you get to know Cheryl and you're around her. She has her own version of a sign language which she communicates, and you can eventually figure out what she needs or what she wants or what she's trying to tell you.
Okay, so would you say that your father is less or more, I don't want to say handicapped, but more just disabled at this point in order to get around? Who has better ability to get around and do things?
At this point in time in their lives, Cheryl does. With his recent back surgery and his recent car accident, that would make her, better to get around.
Okay.
And he has oxygen and his walker.
Oh, he has an oxygen machine?
Mm-hmm. He's on it in the evenings, and then when his breathing gets bad.
And he needs to roll that around with him?
He did have a temporary one. We sent it back because he's just really homebound now. But he has just a big machine in the bedroom.
Okay. And does your dad have a need to be going in and out of the house a lot?
No, we take care of him, and he can order his groceries online. And, my brother and I talk to him every day. We see him several times a week and on the weekends and stuff.
So you do welfare checks on him at his home, correct?
Absolutely. And the neighbors all let me know, how he's doing, or if they see him out walking about or, sitting on the front porch or something, they'll let me know that they saw him.
So now you mentioned an accident that he was in. He was driving that vehicle, correct? At the time?
That's correct. And it was the other person's fault.
Okay. And did he have any problems there? Like getting out of the car? Or,
He was pretty shook up. He has an MRI tomorrow for his injuries.
okay.
So we're kind of waiting for his MRI, see what the next step is.
But it's really difficult for him to get around without a walker, correct?
He can't really get around far at all without his walker.
All right.
If he goes from the couch to the restroom, it's with a walker or maybe a cane.
Oh, from the couch to the restroom? So even short distances, he can't move around very? Okay. I pass away.
Wendy, you said he can get around with a cane also?
Very extremely short distance, like within the house.
Okay, I'll pass the witness, Your Honor.
All right, that's enough. Any other witnesses?
No, Your Honor.
All right, argument?
Your Honor, this is the, my client has lived in this house for 17 years. This is the, her homestead. This house was outfitted for her to get around since her stroke in 2014. We're asking the court either let her remain in the home or let them both remain in the home with some instruction from the court as far as how they're to conduct themselves. I mean, my client is hard of hearing. There are instances when she's frustrated. She's had a stroke, and I can imagine that because I visited with her on several occasions. I can only imagine that she's frustrated with the situation, strangers coming over, Your Honor. But we ask the court to allow her to remain in the home, and if the court feels that both of them can remain in the home, with some instruction as to how the parties to conduct themselves during the pendency of this divorce.
All right, Mr. Trevino, you have a motion?
Don't know, Your Honor. The motion as to who remains in the residence was brought up by opposing counsel.
So you don't have a motion to exclude her from the residence?
No, I do not, Your Honor.
Is this just a preemptive action, Mr. Cedillos, or?
Well, it was for temporary orders. It was just, we're asking, in our request for temporary orders, we asked for her to be allowed to remain in the home.
Okay. Mr. Trevino?
I did not file temporary orders, Your Honor. He filed the temporary orders, and we're responding. And one of the issues was whether or not she should have the exclusive residence. And I believe the testimony is sufficient to say that no, she should not be the one to stay in the residence. The question of who remains in the residence or whether she should remain in the residence is implicit in his motion. And I believe that that's sufficient and to open up the matter at hand.
Okay, so and what relief are you asking for on behalf of Mr. Owen?
On behalf of Mr. Owen, I asked that her motion be denied and that she be asked to leave the premises because it is a separate property under the inception of title rule. There's no controversy as to whether or not that property was owned before the marriage. In fact, the testimony that he owned it clear 5 years prior. And I understand it's probably more pertinent in terms of separation, dividing the assets, but this is his only separate asset. And if he has to stay somewhere, that should be where he stays. There's also further evidence that she has a place to go, that she's welcome in other homes, and that his incapacity to move restricts him more so than she can. And he has nowhere to go, Judge. There's nowhere for him to go. And so if he was living there before they got married, it makes sense under the code that his separate property is where he should be. And I believe that it's although the house was prepared to help his wife initially when she had a stroke, she has since recovered quite a ways, and she's able to move around a lot better than my client. So I believe that her behavior should exclude her the way she's behaving with her husband. There's nowhere else for him to go, and there was no testimony that would present a safe place for him to go.
Okay. All right, and is there still house payment being made?
All the house payments are being made by Mr. Owen on his own separate account.
Yes, they are being made.
It's not being made out of a joint account. He makes the payments.
And where do the attorneys see this going?
Probably some discovery and maybe eventually mediation so that we can find out what assets and there's been some commingling and but I think mediation might be a way to go.
Okay, and how long do you think that'll take to?
I would, well, just with discovery, I don't know how extensive the discovery is going to be. There's not a whole lot here. That should take maybe 2 months.
2 months.
And then to get into a mediation, I would imagine about 3 months. But I don't think, well, my client would have to sign a contract in an apartment complex if he were asked to be moved out. And the minimum length of time is longer than what's necessary here. And the daughter has expressed that her mom is perfectly welcome at her house. He has nowhere else to go, Judge.
Okay, I've listened to the evidence carefully in this matter. I will not order either party to vacate the residence at this time. I'll order both parties not to interfere with anyone who's with caregivers, appraisers, or real estate agents. I'll order that they're at the residence. This won't be definite enough to hold anyone in contempt, but I'll order that apart from separate property or sole use property, toothbrushes, underwear, clothing, things like that, apart from separate property or sole use property, nothing's going to be hoarded or removed from the house. All right, they're going to have to split their stuff up eventually, but that doesn't mean that if they're both living in the residence that they get to go and make separate piles and say, you know, this is my vacuum cleaner, this is my toaster oven, and you're not allowed to use it. All right, I'll order that Mr. Owen continue to make the house payment and the utility payments. I'll order that Mr. James Cavazos not go onto the property. And I will set this for further proceedings on March the 2nd. That's right at 90 days. And just so that the parties are clear that if they're not going to be able to work this out, that it needs to be resolved quickly and that this is not something that we're going to just do this for 6 months or 2 years. So somebody is going to have to buy the other one out or move out, certainly by late winter, early spring. Okay.
Okay.
All right. So do y'all want an entry date for that? Do you want?
Sure.
An entry date for
the orders.
For these temporary orders?
Oh, well, the movement should choose. He filed.
Yeah, I'll try to circulate that by the end of the week. You know, and then hopefully we can get that to the court next week.
All right. I think that I have. Look here. 1210. So again, if you have this reduced to writing, just e-file it. No one needs to be here, but I'll set this for entry on 1210.
And Judge, if I may interrupt, there is a second divorce filing on this case. It is in CVW 2007-28, same parties. I don't know if we just need to get a non-suit on that case.
Yeah, that was filed afterwards. I guess his was filed prior, but yeah.
I don't care. Not non-suit or consolidation, whichever is easier.
It's okay. We can consolidate it.
All right.
All right. Anything else right now?
Nothing else, Your Honor.
Nothing further, Your Honor.
All right, then everybody who's not on the Peeler case is excused. I'll be back at 2 o'clock on the Peeler case. So I was overly optimistic with one. We'll see y'all at 2 o'clock.
Thank you, Judge.
And Fernando, I'll try to get that to you as soon as possible.
Okay, and I'll respond immediately.
Okay, thank you.
May we be excused, Your Honor?
Thank you.
Yes, everybody who's not on the Peeler case is excused, well, except for Lachey.
Thank you.
Okay.
sounded bad. It's just a sparkling water. Oh, you can't see it. It's not a bear. All right. We have the two motions to exclude. Which one would it make sense to take up first?
We don't have a preference, Your Honor. I'll be arguing both motions for the peelers.
Okay. All right, Meister? Is that Meister?
Yes, Your Honor. That's peelers have filed a motion to exclude William Meister. He's a San Miguel designated expert.
All right, and who's going to be arguing on the other side?
Afternoon, Your Honor. This is Taylor Holcomb for San Miguel.
Okay. All right.
And
Is
Cody,
everyone, go ahead.
sorry, Your Honor. Cody Schneider on behalf of Kiewit Mining Group.
All right, and is everyone ready? Is everyone ready?
Yes, Your
Yes,
Honor.
Your Honor.
Yes, sir.
All right, go ahead, Ms. Whittle.
Good afternoon, Your Honor. San Miguel has retained William Meister to testify at trial as an expert about, number one, San Miguel's mining and reclamation activities. Number two, the Texas Railroad Commission and other state and federal agencies' roles in overseeing San Miguel's reclamation efforts. Number three, what he calls the common practice of placing coal ash in mine backfill. And number four, San Miguel's management of the water level in the mine area A, including ramp 10. Mr. Meister's testimony should be excluded because he's not qualified as an expert on Texas regulatory standards relating to mining and reclamation or solid waste disposal, including mine backfill using coal ash. Number two, his opinions have not been informed by reliable methods and techniques and also lack a reliable foundation because they were provided to him by San Miguel's regulatory counsel. You may recall our motion to compel the deposition testimony of San Miguel's regulatory counsel, who served as a consulting expert for Mr. Meister and essentially provided him his opinions. Number three, Mr. Meister's testimony is not relevant. Whether San Miguel complied with regulatory standards and whether the placement of coal ash in mine backfill is common are irrelevant to the determination of whether San Miguel breached the Peeler lignite mining lease. Mr. Meister's opinions are limited to claims regarding harm to the mining lease premises. He has not offered any opinions related to the Peeler Ranch property outside of the mining lease premises. And he clearly testified that his opinions stop at the mine permit boundary, which is fully encompassed by the lease boundary. Mr. Meister's testimony will be unduly prejudicial because lay jurors will be led to believe that he is an expert on an important issue, when in fact he lacks the requisite expertise and his opinions are unreliable and irrelevant. Mr. Meister prepared a report on behalf of San Miguel that offered three opinions. His first opinion is that San Miguel's reclamation efforts to date, as overseen by the Railroad Commission, have been successful in meeting regulatory requirements and industry standards. His opinion number two is that San Miguel's use of coal combustion residuals or coal ash as mine fill in the reclamation process is not unusual in the mining industry and has not negatively affected reclamation completed to date. His third opinion is that the timing of San Miguel's reclamation has not been unreasonable given the technical and operational challenges that the management of water in Area A has presented. His report included no list of references because he relied on San Miguel's regulatory counsel for his opinions. During his deposition, Mr. Meister testified that he is an expert about mining and land reclamation. He further testified that his professional experience, both working in mines and as a consultant, including helping prepare applications for mining permits, including in Texas, makes him an expert concerning Texas regulatory standards for mine reclamation. He also testified that when he was first retained by San Miguel for this lawsuit, he met with at least two attorneys and a technical specialist at the Jackson Walker Law Firm's office in Austin for the better part of a day, during which they educated him on San Miguel's permit filings, the history of the San Miguel mine, Texas reclamation regulations, and the regulation of solid waste management and coal ash in Texas. San Miguel's counsel arranged for Mr. Meister to meet with the Jackson Walker team because Mr. Meister did not have independent knowledge or expertise on Texas regulatory standards concerning reclamation or solid waste disposal or mine backfill practices in Texas. His opinion number 1 should be excluded because he's not qualified as an expert in Texas regulatory requirements regarding reclamation or on Texas regulations regarding solid waste disposal or mine backfill with coal ash. San Miguel's regulatory counsel explained to him those Texas regulations. He did not have any prior knowledge to his meeting, prior to his meeting with the Jackson Walker attorneys, and cannot be allowed to testify as an expert on something he has no prior experience with. His opinion number 1 should be excluded also because it is not reliable, since it was based on information that was spoon-fed to him by San Miguel's regulatory counsel and was not based on his own experience or training. The testimony of a so-called expert is inadmissible under Rule 702 and 703 when his or her conclusions resulted in significant part from information or data provided by counsel rather than through the witness's own expertise, research, or investigation. Such litigation-driven expertise is inadmissible because information spoon-fed to a purported expert does not rise to the level of rigor of an expert in his field would apply and does not pass muster under Daubert. We have provided extensive case law on this point in our briefing, Your Honor. Mr. Meister's opinions about whether San Miguel's reclamation efforts have complied with Texas regulatory standards were based in significant part on litigation-driven expertise resulting from his education from the Jackson Walker attorney team. Because Mr. Meister parroted what he learned from the Jackson Walker team and was unable to say what he knew before he met with them, his opinions are not reliable and he doesn't qualify as an expert. His opinion number 1 should also be excluded because it's not relevant to whether San Miguel complied with the lignite mining lease. Mr. Meister's testimony is limited to the harm caused on the Peeler Ranch premises within the lease boundary, which fully encompasses the permit boundary. He testified at page 78 of his deposition, which is attached as Exhibit 2 to our motion, quote, "That's pretty much where I draw the line, is at the permit boundary." Because the court has ruled that the Peeler's claims for the lease premises are limited to breach of contract as opposed to negligence, any testimony from Mr. Meister regarding the standard practice in the industry, what regulatory agencies have allowed to occur on the Peeler Ranch, or what is common is not relevant to the express lease terms. As a natural result of the court's ruling, based on relief sought by San Miguel itself, Mr. Meister's testimony with regard to San Miguel's alleged compliance with regulatory or permit requirements within that mine permit boundary is not relevant and thus should be excluded as unhelpful to the jury. It's not fair, Your Honor, for the Peelers to be limited to damages for breach of contract, but then for San Miguel to be able to introduce evidence about their permits, regulatory standards, or industry standards for the lease premises, which have no relevance to the contract terms. And here, Mr. Meister agreed that his opinion testimony is limited to the mine permit boundary, which is fully contained by the lease premises. As the court is aware, the relevant leases in this case were signed in 1953 and 1975, and then subsequently amended, which well predate the current state regulations of coal mining and reclamation, which were effective in 1979 and revised in 1982. As this court held in granting the Peelers' motion for partial summary judgment with regard to coal ash disposal rights, a state or federal permit does not modify lease rights between private parties. Thus, the lease terms, which are the operative obligations to which San Miguel is held, are independent obligations that San Miguel must meet in addition to any federal or state regulatory scheme.
A whole bunch. I lost a whole bunch.
Okay, I'm sorry. I was looking at the motions. What was the last thing you heard, Ms. Cavazos?
As this court, wait a minute. Granting the Peelers' motion for partial summary judgment with regard. I don't know what's going on.
Okay, and we can't hear you right now. It shows that your other machine's is on, not muted. We could hear you at first.
Okay, I'm back on. But I lost a whole bunch.
And the last thing you had is the reference to the summary judgment.
The partial summary judgment with regard.
I can go back, Your Honor. It's not that much.
It stopped at the
Just whenever Ms. Kavakis is ready.
Okay, all right, go ahead.
Okay. As this court has held in granting the peeler's motion for partial summary judgment with regard to coal ash disposal rights, a state or federal permit does not modify lease rights between private parties. Thus, these lease terms, which are the operative obligations to which San Miguel is held, are independent obligations that San Miguel must meet in addition to any state or federal regulatory scheme. Because the surface mining and reclamation regulations were not enacted at the time the leases were executed, nor were they explicitly incorporated into the subsequent lease amendments, Mr. Meister's testimony regarding San Miguel's alleged compliance with regulatory or industry standards is irrelevant to the breach of contract cause of action, which remains for the leased premises. And he admitted at page 79 of his deposition, quote, "I cannot offer a legal interpretation, obviously, with respect to the lease obligations." The court should be aware, however, that Mr. Meister and San Miguel appear to poised to blur the line between San Miguel's obligations under the lease and its obligations under the regulatory scheme. In fact, Mr. Meister stated in his deposition that he did intend to offer an opinion outside of San Miguel's lease obligations as to whether San Miguel has met its reclamation.
Ms. Whittle? Oh, there you are. All right, you're muted, Ms. Whittle.
I don't know what happened there.
All right, we heard whether or not it had met its, and then I think that was all we heard.
Okay. In fact, Mr. Meister stated in his deposition that he did not intend to offer an opinion outside of San Miguel's lease obligations as to whether San Miguel has, that he did intend to offer an opinion as to whether San Miguel has met its reclamation obligations under the Texas SMACRA. And we think this testimony shouldn't be permitted for several reasons. First, Mr. Meister himself testified that his knowledge of the state regulatory scheme for solid waste disposal was based on his conversations with San Miguel's regulatory counsel. And so he would simply be a mouthpiece for San Miguel's legal opinion with no expertise of his own. Second, the court has already ruled on whether the lease terminology controls. It does, and thus comparative testimony from Mr. Meister is not relevant or helpful. Third, the concept of reclamation is a regulatory one, which is not relevant to the lease terms, which calls for restoration of the property to its original state and condition. Because San Miguel's obligation under the lease is to restore the leased premises, Mr. Meister's testimony regarding regulatory reclamation obligations and standards would be unhelpful and would unnecessarily lead to jury confusion. Moreover, to the extent that Mr. Meister's opinions extend to the Peeler Ranch property outside the lignite lease premises, which he explicitly testified they do not, compliance with Texas regulatory standards is not a defense to trespass or negligence. That's black letter law. If Mr. Meister is allowed to testify as to San Miguel's compliance with reclamation regulations within the lease premises, it will be unduly prejudicial because lay jurors would be led to believe he's an expert on an important issue when he is not. Mr. Meister's opinion number 2, that San Miguel's use of coal ash as mine fill is not unusual and has not had a negative impact on reclamation, should also be excluded. His primary basis for concluding that San Miguel's placement of coal ash on the Pila Ranch has not had a negative impact is, quote, that's where they began placing CCR because that's where mining began. And while Mr. Meister maintained that continuing to place coal ash there even after mining ended on the Pila Ranch was necessary to, quote, conform or, quote, complete reclamation of the pits, he admitted that the continued placement of the ash in the pits has in fact delayed reclamation because of accumulated water in those pits. As to his opinion that coal ash placement as mine fill is not unusual, according to federal guidance documents, the Federal Surface Mining Control and Reclamation Act did not contemplate the disposal of solid waste in a coal mine other than waste generated by coal mining operations, meaning the spoil. And that's attached at Exhibit 3 of our response, Your Honor. And while in 1996, the federal government noted in that guidance document that coal ash disposal at a mine site is not precluded so long as such disposal is consistent with the environmental protection standards of SMCRA, Mr. Meister is not in a position to testify on these issues given his lack of expertise on Texas solid waste disposal requirements. And despite his opinion that he's not aware of any material impact of coal ash placement on reclamation, he admitted that coal ash placed in Area A of the mine, which is on the Pila Ranch, may have mixed with soil and groundwater on the Pila Ranch, but that he was not knowledgeable about the extent of the potential contamination. He testified at page 143 of his deposition that, quote, since there is CCR placed in Area A East and spoil and groundwater, they have probably come into contact in that area. The details I'm not exactly sure of. In fact, Mr. Meister conceded that any discussion about the leaching of coal ash constituents into groundwater would be, quote, outside the scope of his expertise. In fact, his nonchalance regarding the dangers posed by coal ash is contradicted by several governmental publications. As the federal guidance that I just referred to notes, quote, the potential for groundwater pollution is singularly the greatest environmental concern of coal ash disposal at mine sites. Upon reviewing this guidance document at his deposition, which he admitted he had not read, he admitted that groundwater pollution was a concern, but he didn't know if it was the greatest environmental concern, although he didn't point to any authority contradicting the federal government's finding. Similarly, when asked about the potential effects of coal ash on drinking water, Mr. Meister again conceded that his focus was on, quote, reclamation issues of things like saline water. But if you get into the details of chemistry or other things, you're getting outside of my area of expertise. In other words, his own testimony indicates he lacks the expertise to discuss potential groundwater pollution or problems relating to the leaching of coal ash contaminants onto the Pila property. And he admits that the placement of coal ash on the Pila Ranch has certainly delayed reclamation for many decades. And to the extent his opinion that the placement of coal ash as mine fill is not unusual, his testimony lacks the underlying qualifications because it's based on a borrowed understanding of Texas solid waste management regulations from the Jackson Walker attorneys. His opinion, and also his opinion that the placement of coal ash as mine fill is not unusual, is again irrelevant to the question of whether ash disposal was done in accordance with the lease terms. The court has ruled that the mineral lease did not allow disposal of coal ash derived from off-premises lignite on the Pila Ranch. We estimate, based on San Miguel's records, that San Miguel caused the disposal of around 18 million tons of coal ash on the Pila Ranch. And San Miguel has admitted that it cannot say which ash was allowed under the lease and which wasn't. So under Texas law, because San Miguel cannot distinguish between the ash, none of it was lawful disposal. Mr. Meister's opinion that reclamation with coal ash is common has no bearing on the breach of lease claims and will only serve to confuse the jury. And that is clearly the intent. At page 18 of the coal company's response to our motion, they state, Mr. Meister's opinions regarding the pervasiveness of the industry of beneficially using coal ash as mine fill will provide the jury with another perspective. By way of comparison, if a person signs a contract stating that he will never drink milk again and is given certain consideration for that agreement, the fact that drinking milk is common in the United States has no bearing on whether that person has complied with his contractual agreement not to drink milk. And any testimony about what is supposedly commonplace has no relevance where the lease simply did not grant the right to dispose of off-lease ash on the Peeler Ranch. Accordingly, the Peelers asked the court to exclude Mr. Meister's opinions contained in Opinion 2 of his report. In Opinion 3 of his report, Mr. Meister states that the timing of San Miguel's reclamation has not been unreasonable, given the technical and operational challenges that the management of water within Area A East has presented. In his deposition, Mr. Meister acknowledged the management of mine water is a foreseeable challenge and that any mine has to have a plan for dealing with mine water. Yet he excuses San Miguel's failure to appropriately manage for many decades what he says is a foreseeable challenge for any mine operation. As the court is familiar by now, Amendment 2 of the mineral lease governs San Miguel's restoration obligations, including commencement of operations to level and restore the surface thereof to the extent which is feasible and reasonably practicable within 6 months after abandoning any excavated area and diligently prosecuting such operations to completion without undue delay. In this case, it is undisputed that the Peeler Ranch was mined out by 2004, and yet San Miguel is nowhere near solving its wastewater management issue on the Peeler Ranch even today, over 15 years later, much less complete restoration of the Peeler property to the Peeler's exclusive use as contemplated by the mineral lease. In fact, the end pit on the Peeler Ranch that filled with water and has caused the management issues Mr. Meister discusses in his report was mined out in 1990, 30 years ago. And San Miguel's estimates it will take another 2 decades to complete Phase 3 bond release on the Peeler Ranch at a minimum, which means the Peeler Ranch will not be restored to the Peelers for their exclusive use for more than 3 decades after mining was completed. That delay is due to the wastewater San Miguel has allowed to accumulate in the end pits and the reclaimed spoil, and which has seeped through the ground in low-lying areas, harming the soil and killing the vegetation. And the wastewater was allowed to accumulate in that area on the Peeler Ranch because San Miguel wanted to keep the end pits open to dispose of ash derived from lignite mined off the Peeler Ranch, which was not allowed under the lease. As part of Opinion 3, Mr. Meister opines that based upon the reclamation San Miguel has completed to date, there is no reason to believe that San Miguel will not meet its future reclamation obligations. This statement, of course, is nothing more than speculation and not supported by the underlying facts, and it is not relevant to whether San Miguel has met its current lease obligations. Nor was Mr. Meister able to explain any reliable methodology as to why he believed either that San Miguel's reclamation efforts thus far were appropriate or that its inability or disinterest in reclaiming the mined out areas of the Peeler Ranch in the last 15 years was a positive indicator that San Miguel would meet its future obligations. The past 2 fuel managers for San Miguel both testified in their tenure at San Miguel, which has been for many years, no reclamation work has been done on the Peeler Ranch. Moreover, in attempting to discuss the reasonableness of San Miguel's efforts to reclaim the area around Pit 10 and the surrounding areas, Mr. Meister points to what he calls, quote, numerous efforts to eliminate the water in Pit 10, admitting that those efforts have only been partially successful. But the efforts that Mr. Meister attempts to attribute to San Miguel include evaporation, which requires no effort on the part of San Miguel at all, as compared to two other related categories, evaporation ponds and enhanced natural evaporation, which he testified have not worked. As Mr. Meister noted in his deposition, the evidence has shown over time that the natural evaporation in the end pits did not work because the engineering design features of pit 10 inhibit evaporation. He testified that, quote, in hindsight, the steep design of pit 10 may have been a foreseeable problem to San Miguel. Importantly, even when Mr. Meister was attempting to give San Miguel the benefit of the doubt, he still admitted, quote, I don't know exactly what went into their thinking. Mr. Meister goes to great pains to excuse San Miguel's poor wastewater management by blaming increased rainfall, mentioning by name several hurricanes or tropical storms between 1998 and 2002 in which there was elevated rainfall. But his own chart demonstrates that there was no extreme rainfall event since at least 2010 to delay reasonable water management efforts, nor does his report mention or take into account any drought conditions over the same 23-year period, which should have accelerated evaporation. So his consideration of meteorology was a one-sided analysis to excuse San Miguel's water management problem and not a fact-based, scientifically neutral endeavor. And I'll show you his chart, Your Honor. Lost my. This is Mr. Meister's analysis. He created a chart that shows there's coal ash placement at ramp 10, which is on the Peeler Ranch from 2004 to 2006. And then here during Kiewit's tenure, 2012, 2014 to 2016. And then he notes that there was a water problem at Pond 8. They put all of that water into ramp 10, which is on the Peeler Ranch. And then he has this big line of normal rainfall, which doesn't account for the drought conditions that actually existed during most of this period of time. And then these extreme rainfall events, it makes it look like it rained the entire year with extreme rainfall events. But of course, it was maybe one day in an entire year period that had a rainfall event. And the last one he noted was 2010. He notes that the seeps were present on the property in 2003, and then further seeps in 2006. And then he gives San Miguel credit for this natural evaporation effort, which has made no difference. And of course, and he admitted the engineering of the pits would not have even allowed for evaporation. Then they created smaller evaporation ponds next to the pits, which also did not work. And he gives them credit for that. He gives them credit for enhanced natural evaporation. They only tried this according to their hydrologist, Eric Matzner, maybe 1 month or 6 weeks, and he's giving them credit for 2 years of addressing this. Once they tried it, they realized that it was blowing the contaminated wastewater onto the nearby ground, which could have killed all of the soil and vegetation, so they stopped. Then he gives them credit for dust control when placing coal ash. They're spraying wastewater on top of the ash pile, meaning they're just concentrating more of those coal ash constituents in the wastewater, which then runs off onto the Peeler Ranch. Here, again, they spent this many years looking at a Class 5 injection well, but not actually implementing it. And then this is the Pond 7 discharge, which we were in the court on our temporary restraining order, and they were discharging massive amounts of wastewater on the Peeler Ranch. And then these are all the studies that San Miguel did looking at the wastewater management issue, and of course never actually implemented any of the recommendations, which are essentially the same as the first recommendations made in 2004 by Eric Matzner and his team. So that's his analysis, Your Honor. This isn't a scientific endeavor, and it seems to place significant emphasis on this natural evaporation effort, which Mr. Meister admits didn't even work. So this is just, it's not a reliable methodology, Your Honor, and we ask the court to exclude it. To protect against the corrupting influence of abusive use of experts available to render an opinion on almost any theory, regardless of its merit, the Texas Supreme Court in Robinson implemented a standard of reliability that each expert's testimony must meet. That standard is simple. The evidence offered by the expert must be grounded in the methods and procedures of science, as opposed to mere subjective belief or unsupported speculation. Because Mr. Meister's testimony is not based on a reliable foundation, it should be excluded. It's apparent from Mr. Meister's report, his deposition testimony, and from the coal company's response that Mr. Meister is not intended as a witness whose scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence, as Texas Rule of Evidence 702 requires. Instead, he's offered as a spokesperson to explain the coal company's arguments and positions to the jury. In particular, the coal companies assert that Mr. Meister's opinion testimony should be admitted because he will provide both, quote, context and an alternative, quote, perspective. This is precisely the abusive use of an expert witness prohibited by the Texas Supreme Court in its Robinson decision. This use of Meister as a spokesperson to provide the jury the coal company's, quote, perspective is the reason that neither he nor the coal companies can specify any particular foundation underlying his opinions. The foundation of his opinions is positions he learned from his interviews with San Miguel's counsel. Robinson and its progeny preclude a party from using an expert as its puppet to assert its own positions and perspective under the guise of scientific, technical, or other specialized knowledge. The court should therefore exclude Mr. Meister's testimony because it cannot be demonstrated to be reliable, and it is intended to be and will be unfairly prejudicial. Thank you, Your Honor.
Good afternoon, Your Honor. Taylor Holcomb for San Miguel. May I proceed? Great. Your Honor, I'll address each of Ms. Whittle's points, but in order to do so, I'd like to start by providing some context. Like any other coal mine in Texas, San Miguel is required to reclaim land that it previously mined. The Texas Railroad Commission governs both mining and reclamation in Texas. And so San Miguel has been and is currently reclaiming land that it mined under the Railroad Commission's watchful eye. Ultimately, for regulatory purposes, it's the Railroad Commission who will sign off on San Miguel's reclamation activities. Now, the peelers have put the quality and timing of San Miguel's reclamation at issue in this case. And the peelers and their experts rely on the Railroad Commission standards in making their claims and otherwise put the timing and quality of reclamation at issue. Here are just a few examples. The peelers in their petition cite to Railroad Commission reclamation rules and claim they've been harmed by San Miguel's alleged violations of those rules and requirements to complete reclamation. The peelers in their petition claim that property San Miguel has already reclaimed shows evidence of subsidence. The peelers expert, Gordon Johnson, opines that San Miguel has failed to adequately reclaim the land. He opined that San Miguel has not reclaimed the peeler lease in a manner consistent with Railroad Commission standards. Another peeler expert, Anthony Brown, claims that the Railroad Commission has noted that there is insufficient reclamation bond coverage in areas that have been mined. And yet another peeler expert, Carl Killian, contends that San Miguel should pay contractual damage payments to the peelers until no earlier than the Railroad Commission approves Phase 3 bond release, which is a reclamation standard. So, Your Honor, in order to address the allegations in the peelers' petition and their contentions through their experts' report, San Miguel was compelled to hire an expert, Bill Meister, to explain to the jury why the peelers' allegations and claims are wrong and to otherwise explain the facts and evidence related to mining and reclamation. He gives the following core opinions. First, San Miguel's reclamation efforts, as overseen by the Texas Railroad Commission, have been successful in meeting regulatory requirements and industry standards. Second, that San Miguel's use of coal ash as mine fill in the reclamation process is not unusual in the mining industry. And third, the timing of San Miguel's reclamation efforts has not been unreasonable. These core opinions, Your Honor, directly rebut claims advanced by the peelers in their petition and through expert testimony, and will provide needed context for the jury on the facts and the evidence. Now, the peelers filed a motion to exclude Meister's opinions, asserting that he's unqualified and that his testimony is unreliable and irrelevant. For purposes of admissibility, it really boils down to whether the expert is qualified to offer opinions and whether those opinions will actually help the jury. On qualifications, Your Honor, Meister has multiple engineering degrees. In the 40 years since graduation, he spent his career in the coal mining industry in various states across the country, including in Texas. He spent the first 20 years of his career working at a mining company and overseeing the entire spectrum of activities associated with a mine's life, including land and mineral acquisition, mine design, permitting, construction, operations, and reclamation. Over the most recent 20 years, Meister has provided consulting services around the world on a variety of mining-related projects, including due diligence investigations related to mine acquisitions and audits of mining operations. And he did the majority of his consulting work at one of the nation's preeminent mining-focused consulting firms. His 40 years of experience working directly at coal mining companies and as a consultant give him broad expertise with respect to mining and reclamation. He's qualified, Your Honor. And with respect to helpfulness, Meister's opinions will help the jury understand the facts and the evidence. Keep in mind that it is the peelers who put these mining and reclamation related issues into play. These are not topics that jurors are equipped to understand on their own. Meister's rebuttal opinions on the quality and timing of reclamation are reliable because they derive from applying his education and extensive experience to his personal observations, including multiple site visits and interviews of mine personnel, and to review of Railroad Commission permitting files and other documents related to mining and reclamation. Meister's testimony is relevant to rebut the peelers' contentions and pleadings and through their experts regarding the quality and timing of San Miguel's reclamation activities. And therefore, it'll help the jury understand the facts and evidence regarding the peelers' claims, as well as San Miguel's defenses. With that overview, I'll shift into the specific arguments raised by Ms. Whittle today. So the peelers, Your Honor, contend that Meister is not qualified to offer any opinions on Texas regulatory standards. And part of that argument is that he was allegedly spoon-fed information by regulatory counsel. So, Your Honor, I'll start by just saying that opposing counsel is making a mountain out of a molehill here. Having independently reviewed much of the Railroad Commission permitting file and having already visited the site to see the site with his own eyes, Meister met with San Miguel's longtime regulatory counsel one time. There's simply nothing wrong with that. Any documents provided to Meister by San Miguel's longtime regulatory counsel were produced to the peelers, and the peelers had the opportunity to depose Meister about those documents. In fact, they did just that. Opposing counsel expresses greatest concern regarding the idea that San Miguel's regulatory counsel provided Meister with information on how the Texas Commission on Environmental Quality regulates solid waste management units. Putting aside that Meister independently reviewed documents regarding that topic, it is the Railroad Commission, not the TCEQ, that issues mining permits and has primary authority over mining and reclamation. Meister's core opinions are not dependent on TCEQ's tangential role in that process, Your Honor. But regardless, the bottom line is that Meister became familiar with the relevant facts of this case by conducting his own independent process. reviewing pertinent documents, developing follow-up questions, conducting his own interviews, requesting more documents, etc. In the normal course, Your Honor, discussions with regulatory counsel were part of this iterative process, specifically regarding what information and documents existed that were relevant to the topics of his report. And while regulatory counsel unsurprisingly served as a conduit for delivery of certain documents, such as Railroad Commission decision documents, Meister based his opinions not on conversations with regulatory counsel, but on his review of the documents. As an example of the breadth of Meister's independent review, his file, which was produced to the peelers, included over 800 documents for a total of over 15,000 pages. And that's what he reviewed and relied on in forming his opinions. Our response brief, Your Honor, at page 8 details Meister's iterative process and how he became familiar with the facts of the case. And instead of rehashing all of that today, I'll just direct your attention there if you'd like to see more of it. And in the end, Your Honor, the peelers are contending that Meister is not qualified to opine on Texas reclamation standards and that he had to rely on regulatory counsel to get up to speed. And that's just simply wrong. Meister has extensive Texas-specific mining and reclamation experience. And his understanding of mine backfill practices in particular is based not on his discussions with regulatory counsel, but on his experience and independent review of pertinent documents. The bottom line is that Meister is qualified to offer opinions on mining and mine reclamation in this case. With respect to Texas specifically, putting aside all of his other national, international experience, Meister has been involved with coal mining operations in Texas since 1978. Meister has experience working on a number of projects in Texas related to the development of lignite mines, like the San Miguel lignite mine. And as Meister testified in his deposition, his work experience includes studies of mining and reclamation operations in Texas, where he reviewed individual mining permits and items related to compliance with those permits. The specifics of all of those projects, again, I don't want to rehash all of them here today, Your Honor. They're included in an affidavit that we attached to our response brief. And that affidavit in more detail includes all the information and all the work he's done in Texas over the course of his 40-year career. Now, Your Honor, as to the law, the peelers cite in their briefs multiple federal district court cases for the proposition that expert testimony is inadmissible if the expert's conclusions resulted in significant part from information or data provided by counsel rather than through the witness's own expertise. But the courts in those federal cases faulted expert witnesses who relied on summaries and materials provided by regulatory counsel without conducting their own review. And that's just not what happened here. As I've already expressed, Meister conducted multiple site visits. He conducted multiple interviews of key mine personnel, and he reviewed permitting and related source documents and then applied his own experience, research and investigation in forming his own opinions. And even had Meister based his opinions in part on attorney-provided summaries, as the peelers call it in their briefs, that would not be grounds for disqualification, Your Honor. In the single Texas case cited by opposing counsel in their briefing, that's the Regent Care Center case, a party challenged an expert's testimony as unreliable because he allegedly relied on summaries provided by trial counsel. The court did not dispute that the witness relied on attorney-provided summaries. And in fact, that the witness had even directed the attorneys to provide the summaries. The San Antonio Court of Appeals rejected the challenge, however, because the record revealed that the expert witness's opinions were based on far more than the attorney-compiled summaries, including his personal review of documents, personal interviews, review of relevant deposition testimony, and application of his professional experience and training. That's certainly the case here too, Your Honor. Now, Your Honor, as part of the peeler's argument that Meister isn't qualified and that he doesn't have a reliable foundation and that he was only spoon-fed information by regulatory counsel, in their reply brief filed yesterday, Your Honor, the peelers contend that Meister and San Miguel refused to show exactly what the foundation for Meister's testimony is, and therefore his opinion's unreliable. They say that neither San Miguel nor Meister pointed to any specific document that he relied on. Your Honor, the law on reliability is that an expert's opinion may not be based on unsupported speculation. And the Texas Supreme Court has said that Rule 702's reliability requirement is satisfied as long as the expert's opinions fit the facts of the case and there's no significant analytical gap between the data and the opinion offered. Meister's opinions are tied to the facts of the case. His opinions are not based on unsupported speculation. Meister's opinions are based on applying his 40 years of experience to his personal observation from multiple site visits and interviews with mine personnel, and to his review of mining and reclamation documents in this case. And with respect to those documents, Your Honor, all 800 plus of those documents were produced to the peelers via Rule 194 disclosure in this case. That's the point of a Rule 194 disclosure, to produce the materials that an expert reviewed and relied upon. The peelers received those documents before his deposition, and the peelers were entitled to ask him questions about those documents, and also about any documents that they thought he should have reviewed but that were not in his file. That's actually what they did during his deposition. During the deposition, Meister discussed the documents he reviewed. For example, in response to questioning from opposing counsel, he specified that he reviewed the operating plan in the mine permit applications. That's page 41 and 42 of his deposition. He reviewed the surface and groundwater hydrology sections of the mine permit application. It's page 42 of his deposition. And he reviewed the hydrologic balance section of the mine permit application. It's pages 42 and 43 of his deposition. Yet in their reply briefing, opposing counsel contends that Meister is unreliable because San Miguel hasn't pointed to one specific document on which any of Meister's opinions rest. And that's just wrong on the face of their reply brief, Your Honor. For example, on page 4 of their reply brief, the peelers contend that in only stating that Meister reviewed mine closure studies prepared by an independent consulting firm, San Miguel has failed to identify a specific document that Meister reviewed. But the deposition site that was included with San Miguel's statement proves that the peelers are mistaken. I'll pull that up for you. As you'll see in the deposition transcript, Your Honor, at page 20, lines 7 through 9, opposing counsel asked Meister during his deposition if he had reviewed a specific study, referring to the Golder mine closure study. Meister said yes. In other words, opposing counsel identified the document for Meister in the deposition. And now in briefing, opposing counsel claims that it isn't clear what documents Meister reviewed. Another example is on pages 4 and 5 of the peelers' reply brief, where the peelers contend that in only stating that Meister reviewed information regarding reclamation studies provided by Jeremiah McKinney, San Miguel has failed to identify a specific document that Meister reviewed. Again, the site included with this statement proves the peelers' contention is misguided. The site is to Jeremiah McKinney's expert report in this case. He's one of San Miguel's other expert witnesses, Your Honor. And you've already denied the peelers' motion to exclude Mr. McKinney from this case. Under Texas Rule of Evidence 703, an expert may base an opinion on facts or data in the case that the expert has been made aware of, reviewed, or personally observed. And in the Southland case, Your Honor, the San Antonio Court of Appeals held that an expert was authorized to rely on facts or data contained in a different report informing his own opinion as to the evidence examined. Now, Your Honor, opposing counsel in the reply brief also contends that Meister and his opinions are unreliable because not only has San Miguel in briefing not pointed to one specific document on which Meister's opinions rest, well, neither has Meister either. And that's wrong on the face of his expert report, where Meister cites the information contained in the Federal Register, complete with Federal Register citations. It's page 7 of his report. He cites website links and titles of materials he reviewed associated with mining end pits. That's pages 11, 12, and 20 of his expert report. He cites to a National Academy of Sciences study, including the specific pages within the study. That's pages 15 to 16 of his report. And I'll note, Your Honor, that same study was cited by the Peelers in their petition. He cites to other studies throughout his report by reference to author name and date. That's pages 15 and 16 of his report, for example. He cites specific Railroad Commission permit orders. That's pages 17 and 25 of his report. He cites reports from other consulting firms with specific page numbers to those reports. That's page 31 of his report. He cites Railroad Commission memos by reference to title, date, and author. It's page 37 of his report. He even included Bates numbers to documents produced in this case in his report. That's pages 25, 29, 30, 31, 34, 35, and 36 of his report. And I'm not going to show you all those, Your Honor, but I do want to show you one. Here we are on page 29 of his report, and I've highlighted for you, Your Honor, all the Bates numbers of documents that Meister cited to throughout his report. Here's page 29. You can see all of those citations highlighted. Let's go to the next page, page 30. In short, Your Honor, the Peelers contend that, quote, Meister will not show his work, end quote. They also contend that San Miguel and Meister, quote, refuse to list even a single specific document or other material forming the basis on which Meister reached his opinions, end quote. But the examples we just discussed from San Miguel's response brief and the citations throughout Meister's report demonstrate that the Peelers are simply wrong. Again, Your Honor, the law on reliability is that an expert's opinion may not be based on unsupported speculation. And the Texas Supreme Court, again, has said that Rule 702 is satisfied as long as the expert's opinion fits the facts of the case and there's no significant analytical gap between the data and the opinion. Meister's opinions are tied to the facts of the case. They are not based on unsupported speculation. They're based on applying his 40 years of experience to his personal observations gleaned from his multiple visits to the site and interviews with mine personnel, and to his review of mining and reclamation documents in this case, all of which were produced to the Peelers, many of which were submitted to or received from the Railroad Commission itself, and which were cited throughout Meister's report. Your Honor, that is a reliable foundation. Now, the Peelers also contended today an argument that Meister's opinions are irrelevant because compliance with a Railroad Commission permit or Railroad Commission standards is irrelevant to whether the lease has been breached. Specifically, the Peelers contend, Your Honor, that the court's ruling that their claims regarding the lease premises are limited to breach of contract makes irrelevant Meister's opinions regarding San Miguel's conformance with regulatory and industry standards because those opinions are allegedly not related to the mining release. Their contention is misplaced for three reasons. First, Your Honor, the Peelers have asked for reconsideration of your ruling. Second, opposing counsel has framed this incorrectly. Meister's opinions regarding regulatory and industry standards need not be directly related to the lease in order to be relevant in this case. His opinions need only be helpful to the jury in understanding the evidence or resolving a disputed fact issue. That's Texas Rule of Evidence 702, and that's the case here. Your Honor, the Peelers experts rely on Railroad Commission regulations the Peelers now claim are irrelevant. As one example, their expert, Gordon Johnson, refers both to regulatory standards and lease provisions in contending that San Miguel did not appropriately handle topsoil in the reclamation process. Meister's testimony and opinions respond and rebut Johnson. Another example, the Peelers expert, Anthony Brown, claims that the Railroad Commission noted that there appears to be insufficient reclamation bond coverage in the areas of disturbance. Meister directly rebuts Brown's claims. Also, the Peelers' live claims in this lawsuit concern whether reclamation efforts have satisfied Railroad Commission requirements. And Meister's core opinions directly rebut these claims. As one example, the Peelers, citing to Railroad Commission reclamation rules, state in their petition that they have been harmed by San Miguel and Steck's violations of the Railroad Commission requirement to complete reclamation efforts on all land disturbed by surface mining activities as contemporaneously as practicable with mining operations. Meister's testimony and opinions directly respond and rebut this. These are just a few examples, Your Honor, and San Miguel's brief at pages 14 to 15 details others. Meister's testimony regarding San Miguel's compliance with applicable Railroad Commission and industry standards on reclamation will assist the jury in understanding the evidence and disputed fact issues related to the Peeler's claims and San Miguel's defenses. And the third point here is, even if Meister's testimony and opinions on San Miguel's conformance with regulatory and industry standards needed to be directly related to the lease in order to be relevant, they are. His opinions and testimony also directly address the factual issues associated with compliance with the mining lease. The Peeler's actions and pleadings, which Meister's opinions address and or rebut, prove as much as follows. The vast majority, Your Honor, of the pre-mine land use of the Peeler Ranch was classified as grazing land under the Railroad Commission definition. But in 1992, Alonzo Peeler sent a letter to San Miguel requesting that, quote, my land currently under lease to San Miguel Lignite Mine be reclaimed to pasture land rather than grazing land, end quote. This change, Your Honor, occurred after execution of the lease. The alternate post-mine pasture land use has reclamation standards distinct from the original grazing land use. And by requesting this change, Mr. Peeler endorsed the Railroad Commission reclamation standards for pasture land as the applicable reclamation criteria. As a result, Mr. Peeler made the Railroad Commission standards not only relevant, but the key metric in the assessment of revegetation success. The Peeler's petition also states that certain contractual payment provisions are triggered until San Miguel restores the mine property or after San Miguel has made every reasonable effort to restore the surface of the land to its original state and condition. Meister's core opinions, Your Honor, which relate to the quality and timing of reclamation, directly relate to these lease requirements. And in their breach of contract claims, the Peelers assert that San Miguel has not performed their reclamation and damage payment obligations under the amended mineral lease, and that San Miguel has, quote, unreasonably delayed reclamation in violation of the lease. In short, the Peelers' breach of contract claims explicitly reference reclamation, making Meister's opinion on reclamation relevant. Now, you heard Ms. Whittle say today that Meister's testimony comparing governing reclamation standards to lease requirements is irrelevant because the concept of reclamation is a regulatory one, whereas the lease calls for restoration, not reclamation. These semantics regarding the difference between reclamation and restoration is a distinction without a difference, Your Honor. The Railroad Commission's own rules use the term restored in the context of reclaiming to pre-mining land uses. And as the Peeler's own expert acknowledges, this is Gordon Johnson here, the objective of the Railroad Commission rules is, quote, to restore the land affected to a condition capable of supporting the uses it could support before mining. The bottom line, Your Honor, is that the Railroad Commission reclamation standards provide insight into San Miguel's reclamation performance under the mining lease, because there is not a significant difference between the objectives of the lease and the Railroad Commission rules. And that's why the Peelers' petition and experts' reports interchange the concepts of restoration and reclamation. For instance, the Peelers' damages expert, Carl Killian, explained that he had used a standard for reclamation that was, quote, consistent with the mineral lease and lease amendments, end quote. Well, Killian's lease-based standard relies on the Railroad Commission bond release status of the reclaimed lands and the Railroad Commission procedures and assessments utilized by Meister. Your Honor, the Railroad Commission standards and the lease requirements do not vary in any material way. And Meister's opinions and testimony directly address the evidence and factual issues associated with compliance with the mining lease. Thus, Meister's opinions on the quality and timing of reclamation based on regulatory and industry standards will assist the jury in understanding evidence and fact issues related to the Peeler's claims in San Miguel's defenses. And Your Honor, to the extent that the Peelers disagree, they can address that on cross-examination, but their disagreement here is not a basis for disqualification. Your Honor, the Peelers also argued today, opposing counsel also argued today that Meister isn't qualified to testify on how using mine fill in the reclamation process, using coal ash as mine fill in the reclamation process is pervasive. He's not qualified to offer that opinion, and that opinion is not relevant. I'd like to address that briefly. What Meister said in his report was that mine filling with ash is, he said this in his deposition, mine filling with ash as part of reclamation is the option that disturbs the least amount of the overall area and is the fastest way to complete reclamation. But in his report, he provides context that every mine has its challenges. And he said that water at the San Miguel mine has delayed reclamation in a small area. And with respect to mine filling with ash not having a negative impact on reclamation, the Peelers have misunderstood his testimony. He's referring to the other areas of the ranch that have been successfully reclaimed after using ash as mine fill. He's personally observed these areas, Your Honor. He doesn't testify about environmental contamination like the Peelers counsel would like him to. That's for a different San Miguel expert. That's Mark Hemingway. And I understand that you'll be hearing the Peelers challenge to his testimony, Your Honor, on Thursday. Meister's opinions on mine filling with ash not being unusual are reliable because they're based on his significant expertise, independent research, and review of technical literature, including literature cited by the Peelers in their pleadings. Here's just some examples. He cited a study from the National Research Council showing the widespread number and locations of active enclosed mines where coal ash had been placed, based on data collected through individual state surveys. That's on page 15 of his report, Your Honor. That study from the National Research Council indicated that there were 9 active mine sites in Texas where coal ash was being placed in the reclamation process. Meister independently confirmed that at least 5 Texas mines either have used or continue to use coal ash specifically as mine backfill. And he would know, Your Honor, because he's personally observed other Texas mines using coal ash as mine fill. He also cited to other technical studies which reported that there have not been any documented scientific evidence produced to conclusively demonstrate an instance where mining permits have failed to protect the public or the environment as a result of using coal ash as mine fill. That's pages 15 to 16 of his report. Now, you heard opposing counsel today try to refute Meister's opinion by reference to other data sources, other federal guidance documents. Putting aside that those other data sources actually prove Meister's point, as we explained in our briefing, the Peelers' disagreements with Meister on the facts should be reserved for cross-examination and are not a basis for disqualification. And briefly, Your Honor, to address opposing counsel's contention that whether or not using coal ash as mine fill in the reclamation process, whether or not that's pervasive in the industry, they say that's irrelevant because it has nothing to do with the lease requirements. Meister's opinions, however, on industry practices need not be directly related to the lease to be relevant to this case. Meister's opinions, again, under Texas Rule of Evidence 702, need only be helpful to the jury in understanding the evidence or resolving a disputed fact issue. And that's the case here. For example, the Peelers in their petition contend that mine filling with coal ash is not typical in Texas. That's paragraph 182 of their petition. Meister rebuts their contention with his experience and research, and that'll provide needed context for the jury on reclamation practices and standards related to coal ash. According to their pleadings, Your Honor, the peelers may be seeking complete removal of ash placed in the mine area. The peelers assert that no regulations address the placement or disposal of coal ash in mines, and that dumping coal ash into mines is, quote, especially dangerous, end quote. Meister's opinions regarding the pervasiveness in the industry of beneficially using coal ash as mine fill will provide the jury with proper perspective. And you heard opposing counsel today take issue with the fact that Meister's opinions provide perspective. Well, of course they provide perspective. The peelers put these issues into play. Meister rebuts and addresses those opinions, and it's helpful to the jury. That's what you call perspective. That's what helps the jury understand a complicated technical issue. And Your Honor, the peelers expert, Anthony Brown, suggests that mining ponds should be lined to prevent subsurface percolation. Again, the context that Meister can provide on using coal ash as mine fill in the reclamation process will help the jury understand the evidence around this fact issue that was raised by the peeler's own expert. Again, Your Honor, the relevant standard under Rule 702 is that expert testimony must help the trier of fact to understand the evidence or determine a fact issue. The Texas Supreme Court held in Robinson that expert testimony is not relevant when the evidence has no relationship to any issues in the case. Through their pleadings and experts, the peelers have made San Miguel's mine fill practices into a disputed issue in this case. Thus, Meister's testimony on the same will assist the jury in understanding the evidence on this disputed issue. And finally, Your Honor, opposing counsel questioned the reliability of Meister's opinion on the timing of San Miguel's reclamation not being unreasonable. I'll remind you that the peelers are the ones who put at issue the timing of reclamation. Meister's experience over the last 40 years enables him to provide important context for the jury, specifically that of the several hundred mines he's been involved with, every single one of them has had to overcome significant challenges. And water management is one of San Miguel's. Based on his experience, he knows that specifically end pits present a unique challenge to reclaim since there is no succeeding pit from which overburden can be removed and be used as backfill. He also conducted independent research to confirm how much additional time transpires before reclamation of an end pit is completed can vary tremendously across the industry, citing 5 specific examples from other mines. And based on his interviews of site personnel, his review of work product from past consulting firms, and his review of relevant documents, Meister then recounted the efforts that San Miguel has undertaken over the years to solve the challenge. And he personally observed some of the equipment that San Miguel used to solve the water management challenges. That's the chart Mrs. Whittle showed you that the peelers take issue with. In the end, Your Honor, Meister's review enabled him to conclude that San Miguel over the years engaged numerous outside experts and invested significant time and money in seeking a reliable, workable solution for lowering the water level in the end pit. In other words, San Miguel has not abandoned that area. And that's an important concept for the regulatory context. And it also rebuts one of the peelers' experts, Gordon Johnson, who downplayed the role of rainwater in filling up that end pit. And by the way, Your Honor, the highlighted references I showed you earlier today in Meister's report, those are all citations to the source material that Meister relied upon in forming his opinion on the reasonableness of the timing of reclamation. Now, the peelers are entitled to disagree with Meister's analysis. You saw Ms. Whittle take issue with the chart that Meister put together, but save that for cross-examination. That's not appropriate to use as a basis for disqualification. And Your Honor, the peelers specifically today characterized as speculative. Meister's statement that based upon the reclamation that San Miguel has completed to date, there's no reason to believe that San Miguel will not meet its future reclamation obligations. But Meister's report in his depot testimony disprove that his opinion is speculative. Here's some examples. Meister has experience with other mines that have dealt with issues similar to what San Miguel is facing in the localized area of this end pit. He's personally observed and seen larger end pits be dewatered. Meister acknowledged that addressing the water management challenges is needed to complete reclamation. And he reviewed deposition testimony from a San Miguel consultant who testified that when the water levels in the end pit drop, any water issues and seeps in the area reduce in size. He also knows, based on his review, that San Miguel's overall reclamation efforts have been successful, with the Railroad Commission having already approved phase 2 bond release on the vast majority of the lease area. In fact, Your Honor, as Meister well knows, the Railroad Commission has approved phase 2, and in some cases, phase 3, the final phase of the reclamation process, on areas in which San Miguel used coal ash as mine fill. San Miguel has had past success in remediating similar saline impacted soils, including achieving advanced phase 2 bond release from the Railroad Commission, demonstrating that soil remediation can result in successful remediation and reclamation. Meister also said that the Railroad Commission, as the permitting authority, will require San Miguel to complete the reclamation, and that reclamation bonds that San Miguel holds will guarantee that reclamation is completed. And so his opinions on his belief that San Miguel will meet its future reclamation obligations are well supported and reliable based on all this information in the record. In short, Your Honor, Meister's opinions are reliable because they're based on his review and analysis of multiple sources, including relevant documents, his multiple site inspections, his interviews of key mine personnel, and his education and experience. Again, the peelers may present their disagreements with Meister's opinions and the facts underlying them in cross-examination, but their disagreements are not a basis to exclude his opinions. Your Honor, as I conclude, I'll just reiterate, Meister's got extensive experience. We produced his entire file. He's reviewed over 800 documents in this case, Your Honor. He's responding and rebutting to mining and reclamation topics raised by the peelers experts. He's qualified. His testimony will help the jury because it's relevant and reliable. I ask that you'll deny the peelers' motion to exclude.
All right. Ms. Whittle?
Your Honor, if I may briefly just
I'm sorry,
add.
Mr. Snyder, I have you down over here, but I'm house and I have my stuff at different levels. Go ahead, sir.
No, Your Honor. And I'll be brief, Your Honor. I just want to point out specifically with respect to the reclamation at the ash pile in the Ramp 10 end pit, that particular opinions is relevant to the peelers' claims against Kiewit Mining Group, KMG. The peelers love to point out this ash pile at Ramp 10 end pit and claim that that's a source of contamination by KMG's activities. They even do so in the motion to exclude Sitten that we're going to discuss later on. But with respect to the peelers' claims, they claim that Kiewit Mining Group is somehow responsible for that alleged contamination because it's purportedly emanating contamination from that ash pile due to KMG's limited amount of ash placement there years ago. So Meister's opinions relating to the timeliness and reasonableness of the reclamation of that area is relevant specifically to the peelers' remaining tort and statutory tort claims against KMG. In addition, the common usage and management of coal ash is relevant to the peelers' claims against KMG. I'm going to share my screen for just a moment, Your Honor, and point out in the peelers' pleadings, they specifically allege that Kiewit created a dangerous condition by failing to exercise reasonable care, handling, treating, storing, transporting, and disposing of coal ash. They go on to talk about, again, how Kiewit should have been aware and were aware of the improper handling and treatment and disposal of coal ash should be released contamination. So again, the peelers are alleging that the certain placement and handling of coal ash is causing issues with contamination. Meister's opinions will rebut that by providing opinions concerning the industry practices and reasonableness of handling that coal ash. And finally, Your Honor, I know there's been discussions with providing context. In my opinion, Meister is going to just provide and paint an accurate picture of what's been going out at the mine. Overall, Meister's reclamation opinions and his opinions around handling the coal ash will help combat this unfounded picture that the peelers have consistently attempted to paint, and no doubtably will try to portray to the jury that the former lignite mining areas are essentially a wasteland of coal ash piles that have been left unattended and are causing systemic contamination throughout the peelers' property. The peelers even allege that, due to these issues, there's long-term, if not perpetual, environmental liability. And Meister's opinions counter that picture and convey that the former lignite mining area has been proceeding through reclamation under the watchful eye of the Texas Railroad Commission, and reasonable steps have been taken towards completing that reclamation and those goals and obligations. So with that, Meister's opinions are clearly relevant because they help the trier of fact understand what's been going on out there at the mine with respect to reclamation and the handling of coal ash, and the reasonableness of such actions, which don't just go towards the breach of lease claims, but go towards the peelers' tort and statutory tort claims, Your Honor. Thank you.
Ms. Whittle? Let me ask, what claims does the peelers have left where they're alleging violation of Railroad Commission rules or regulations?
So, Your Honor, I think it would probably be a good idea to have a status conference on what claims are really left at this point. But the reclamation, all of the pleadings that Mr. Holcomb just cited to you were tort pleadings. None of them were breach of contract. And this court has limited all of the claims within the lease premises to breach of contract. So where we can't bring claims for tortious harm, they shouldn't be able to defend against claims for tortious harm in those areas. So a lot of these reclamation obligations would be limited to just that area, the ones that we relied on as demonstrating negligence. So where you've limited our claims to just breach of contract, those regulations aren't incorporated to the contract. And of course, our experts all provided their opinions prior to this court ruling, and dismissing those claims. So certainly all of the expert testimony that Mr. Holcomb, counsel for San Miguel, referred to was based on our experts supporting both our negligence and our breach of contract claims.
And Your Honor, I just disagree with the characterization. I think that the reclamation and mining related topics that Meister offers opinions on are directly related to the breach of the lease. We cited that in our brief. And for example, it goes to their damages calculation. So it's all sort of intertwined. And so it's not so easy just to pull those apart. Regardless, the peelers have put these issues into play, and that's why it's relevant for Meister to rebut them. But specific to the lease, as we said in our brief, there are specific topics he addresses that relate to reclamation and the lease.
So I can't imagine how Mr. Meister's testimony goes to damages. He didn't disclose any opinions about damages. In fact, his opinions are about regulatory compliance. His testimony is that San Miguel has complied with the reclamation regulations, which has nothing to do with the breach of contract. And whether coal ash disposal is commonplace also has nothing to do with breach of contract. And as to Kiewit's point, Mr. Meister also said he wasn't testifying about contamination. He made very clear that's outside of his area of expertise. So it's not relevant. His testimony isn't relevant to contamination outside of the lease boundary either. He was very clear about the boundary of his opinion, which was the permit.
And to clarify, Your Honor, for opposing counsel, when I said damages, the peelers expert, Carl Killian, uses Railroad Commission reclamation standards as a basis for his damages, and Meister addresses that. That's what I meant, not that Meister offers opinions on a damages model calculation.
Your Honor, all Mr. Killian says is that they should pay those surface damages until the property is restored to the peelers for their exclusive use, which San Miguel has testified will not occur until phase 3 happens. So that's the only way it ties to Mr. Killian, is that the damages, the surface use payments should continue until phase 3 bond release and the restoration of the property to the peelers actually occurs. I don't see how Mr. Meister's opinion would be relevant to that at all. He can't predict when phase 3 bond release is going to occur.
Okay. All right. Let's take about a 10-minute break and then we'll come back and begin the other hearing.
Yes, Your Honor.
K&G's motion to exclude, I think.
Yes, Your Honor.
Okay. All right. Let's call it 3:35 actually.
Thank you, Your Honor.
All right, are we ready to proceed on the motion to exclude Mary Sitton?
He was ready to proceed, Your Honor.
Peelers are ready to proceed, Your Honor.
All right, go ahead, Mr. Schneider.
Thank you, Your Honor. And I'll share my screen for a PowerPoint presentation. All right. All right, so the summary of this argument, Your Honor, really comes down to whether Mrs. Sitton, Mary Sitton's opinions are about contamination or not about contamination. If they are about contamination, they should be excluded because they're irrelevant, as they're not based on an exceedance of a state action level for these contaminants of concern, or because they're unreliable, because Sitton failed to offer specific opinions about Kiewit Mining Group. They were founded on unreliable opinions by the peeler's other experts, or Sitton's opinions are based on aerial photos and maps alone. Further, if Sitton is considered to be offering opinions about contamination or corroborating contamination on the peeler property, that was not properly disclosed in the designations for Sitton or the report. And finally, it would be unfairly prejudicial to allow Sitton's opinions about contamination to move forward because it would hold KMG to an improper standard. Now, Your Honor, if the opinions are not about contamination, they should still be excluded because Sitton's opinions would not be helpful to a jury, because essentially all that Sitton's testimony would be about is visual observations from her photographs or maps, which a jury is more than capable of looking at, reviewing, and evaluating maps and photographs. And just take a step back, as the court is well aware, the background of this case, the mining operation started in the early 1980s. Kiewit Mining Group was the third contract mining operator that came in January of 2011 and ended its time on July 2020. So there is a large gap there for when Kiewit Mining Group wasn't even on the property. Moreover, Kiewit Mining Group was not the permit holder for the mine, was not the mine owner, was not the plant owner, and was never a party to any lease with the peelers. And that's important because, as this court recognized, as a result of all those items, there's a different standard that applies to KMG. As this court noted during a hearing on August 24th, 2020, that if this case does proceed to trial with KMG on it, KMG would have a different standard that applied to it. And that different standard was provided by the San Antonio Court of Appeals decision in Taco Cabana. It established the precedent for the standard that would apply to Kiewit Mining Group. And that standard relates to unreasonable levels of contaminants. And the San Antonio Court of Appeals established the precedent that to be considered an unreasonable level of contaminant and to proceed with a tort action, that contaminant has to exceed a state action level. And I bring this up early on, Your Honor, because in the peeler's response, and this is important to bring out, Your Honor, in the peeler's response, the peelers tell the court that it has already considered and that it already rejected this argument by Kiewit Mining Group and noted the October 20th hearing. As the court will remember, it has never rejected this argument by Kiewit Mining Group, either during that hearing or at any other time. All this court did during that hearing on October 10th was ask whether this is a question of law, whether you have to exceed some regulatory standard to get tort damages. Just asked a question. This was at the very beginning, before even any of the hearings proceeded. Then the court allowed all of the hearings to proceed. And Your Honor, just to take a moment to answer that question, it is a question of law whether there has to be some exceedance of a regulatory standard to get tort damages. It goes toward the elements for the tort and statutory tort claims, but that is what makes it relevant for expert testimony. If you are not testifying to an exceedance of a state action level and an expert is providing an opinion on that, That's not a relevant opinion to provide because it doesn't go towards an element, a required element for the tort or statutory tort claim. But it's important. The court never, ever rejected Taco Cabana's holdings. In subsequent hearings, even as the court will remember, it started asking questions again about what needs to be exceeded and what's required, what type of evaluation, and provided that analogy of a glow-in-the-dark watch having radioactive material on it. And if that breaks and some spill occurs on it, is a property owner entitled to substantial amount of damages for a mere drop of radioactive material. And the court stated during that hearing, and I quote, "I mean, there's got to be some level, it seems to me." And that level is provided by the state action levels when it deals with tort or statutory tort claims. And the reason I'm focusing on that, Your Honor, is because Sitton's opinions about contamination or corroborating opinions analysis about contamination are not based on those state action levels, Your Honor. And the court, with respect to that October 20th hearing that the appealers allege rejected the argument related to state action levels, the actions by the court for its Bowman order show that it didn't reject, inherently looks as if it accepted it. But I'm not putting words in the court's mouth because it didn't state it in its order, but inherently it appears that it accepted that argument instead of rejected it because the court granted Kiewit Mining Group's supplemental motion to exclude Paul Bauman's testimony against KMG. And in reality, Bowman and Sitton's opinions are pretty parallel. They both make assertions about contamination and contamination conclusions without offering any specifics on KMG, KMG's activities, or why KMG would be liable. Both founded their opinions on unreliable opinions by appealers' other experts. Both Bowman and Sitton used unreliable methodology to reach their contamination conclusions, and both use an improper standard to reach these conclusions. The only difference between Bowman and Sitton is that Bowman used surveys, which he actually went out there and at least did readings, and Sitton simply reviewed and generated aerial maps and photos to reach her analysis and conclusions. And the other difference is Bowman's testimony has already been excluded by this court. Now, with respect to Sitton's contamination conclusions that she made in her report, as this court can see from page 4 of Sitton's report, at the bottom, she does say the disposal of coal ash and other waste has caused widespread and significant contamination of groundwater, surface water, and soil within the Peeler Ranch. And she does cite to the Peeler's pleadings in this case. And Kiewit Mining Group pointed this out in its motion to exclude. This was still nonetheless an assertion that Sitton provided in her report. So as conveyed to Kiewit Mining Group and others, this appears to be an opinion about contamination. Then, during her testimony about contamination, she states, when asked specifically about that statement, that her analysis of the photographs and other layered information corroborates that statement, and that her opinion is that the analysis in the photographs and the layered figures corroborate that statement, even if that statement itself is not her opinion or conclusion about contamination. Her opinion is her photographs, her maps allegedly corroborate that there is contamination, widespread and significant contamination on the Peeler Ranch. So it's either she is providing the contamination conclusion in a report, or she's corroborating contamination is widespread on the Peeler Ranch through her photographs and maps. But this court should exclude these contamination conclusions, whether it's the corroborating ones or the ones from the report, because they're irrelevant, because they're not based on the exceeding of state action level. They're unreliable. These opinions were not properly disclosed, and they would be unfairly prejudicial to Kiewit Mining Group. Now, with respect to how Sitton's opinions specifically diving into them. Sitton did not, just like Bowman, Bowman, I apologize, Your Honor, Bowman, did not specifically provide any opinions on Kiewit Mining Group itself, Kiewit Mining Group's acts or omissions, or how Kiewit Mining Group's acts or omissions caused this alleged widespread and significant contamination, and why the other two mining contract operators didn't, or why the other parties didn't, or why the oil and gas operations didn't, or why another litany of other alternative causes didn't cause this alleged widespread and significant contamination, or why her maps and photographs don't corroborate that those other acts and omissions didn't cause that contamination. Notably, Kiewit Mining Group's only mentioned once in the report at all. And moreover, Sitton and the Peelers acknowledge that there's no specific opinions about Kiewit Mining Group, but that's the issue within itself. If these opinions are going to be offered to against Kiewit Mining Group, there has to be some basis, some reliable basis for making these conclusions and offering against them against Kiewit Mining Group. And furthermore, Your Honor, there was no scientific evaluation or investigation or testing performed by Sitton to reach these conclusions, regardless if it's about the contamination or the corroborating evidence. She didn't do any of that. What she did was simply review and generate photos and layered maps. And this comes directly from her report, Your Honor. The conclusions and opinions in this report are based on my analysis of aerial photos of the site, and then review of maps, documents, and ground photos. Then just a general summary of the materials that Sitton reviewed. Again, it's the pleadings to where she pulls that contamination conclusion from. There's some aerial photos during Kiewit Mining Group's tenure that she looked at, some maps of the mining area, some photos of ash piles from an unspecified location. Unspecified peeler images and videos are listed by Sitton. And then the site sampling and site investigation summary by one of Peeler's other experts, Dr. Ross from Glenn Ross Engineering. She rests as a basis in items that she reviewed for her analysis and opinions. Interestingly enough, though, and we'll get to this in a little bit, Sitton did not list any reports by Bowman, Johnson, or Brown with Aqualogic, and didn't list any analytical test results conducted by anybody else. And the reason this is important, it's because photos and maps alone are insufficient to make a conclusion that there's widespread contamination or that these items corroborate widespread contamination, because no one can just review photos and maps alone to make these conclusions that Kiewit Mining Group's acts or omissions caused this alleged contamination. And
was that her specific testimony that Kiewit Mining Group did X, or that she observes some phenomenon that she concludes is the evidence of widespread contamination and she's let somebody else worry about how it happened?
Yes, Your Honor. She never made any opinions about Kiewit Mining Group did X, and therefore it is caused the contamination on the Peelers Ranch. She only makes reference and cites to the Peelers pleadings alleging that the quote unquote disposal of the coal ash and other waste has resulted in widespread and significant contamination. And Kiewit Mining Group was allegedly one of the parties that did this disposal of coal ash and other alleged waste, but so did the other parties allegedly. And she fails to even explain whether or not the other mining contractors did it. She just fails to do that. Essentially, she tries to just put up her hands and leave it to the other experts, or actually take the other experts' opinions and say, well, the other experts gave me this information. I'm going to put this down in my maps, in my layered maps and photos, and then basically say my layered maps and photos corroborate that contamination. And then, as the Peelers point out in their response, Sitton states that her analysis is reasonable and she's qualified to do it, but that's the limit of the support for why she would be able to either conclude there's contamination or allegedly corroborate that there's contamination based off of maps and photos alone. And self-serving statements by an expert that their conclusions are reasonable is simply not sufficient to make it admissible. It's not enough. You have to have more behind it. And interestingly note, with respect to Sitton's photos and maps, she can somehow make conclusions about contamination or corroborating the conclusions about contamination with respect to groundwater, which is underground and not visible from area photos or maps. And this goes into one of the points that Your Honor just asked about. Sitton and the peelers concede that Sitton didn't perform any sampling. She didn't go out there and take any soil samples or water samples. She just relied on that information from the other parties. And that is also important, Your Honor. Her reliance on the peelers' other experts to either for her to conclude there's contamination or that her analysis corroborates the contamination. And that's because, again, the peelers' other experts used a standard that's not applicable to Kiewit Mining Group. The peelers' other experts did not arrive at their conclusions based off an exceedance of state action levels. Instead, the peelers' other experts, to reach these contamination conclusions that Sitton relies upon, used a lower subjective standard created specifically for this litigation based on exceedances of background levels. And in light of this court's ruling on the economics loss rule, and in light of Kiewit Mining Group not being a party to any lease with the peelers, this lower standard simply does not apply to Kiewit Mining Group with respect to the peelers' remaining tort and statutory tort claims. Although the peelers wish to argue, and again, have alleged and asserted that somehow this court has rejected the Taco Cabana and its progeny is not controlling precedent, the fact is Taco Cabana and its progeny is still the controlling precedent and law from the San Antonio Court of Appeals. Now, the peelers try to make assertions that Taco Cabana and its progeny are limited to only underground storage tank situations or properties subject to cleanup orders. Notably, nowhere in these decisions does it state this limitation. Instead, these decisions use broad language, and Taco Cabana even referenced statutes, plural. If it was going to narrow its decision to only the statute dealing with underground storage tanks, it certainly wouldn't have added a plural to its decision. And notably, Your Honor, I want to make this comment that the peelers always seem to reference that the underground storage tank statutes and regulations are no longer in place, and therefore they're just not even relevant. Well, we'll get to this later, but one of the reasons they're no longer in place is because the TERP now takes over and controls what is considered contamination due to undergrad storage tanks. But back to Taco Cabana and its progeny, an important item to note is several of the cases that followed Taco Cabana had factually different circumstances than underground storage tanks or properties subject to Texas cleanup orders. The Ronald Hollins case concerned a leak of contaminants onto an adjacent property. And the Explorer Pipeline Company, I'll use that part of the case because I can't pronounce the other part, concerned a release of 600,000 gallons of gasoline into a creek in Hunt County. Neither one of those cases dealt with underground storage tanks or property subject to Texas cleanup orders. In addition, the peelers allege that Taco Cabana and its progeny somehow abrogate a property owner's right to private cause of action, or that Kiewit Mining Group is alleging that there's an abrogation. Kiewit Mining Group is not alleging that Taco Cabana or its progeny abrogate any right by a property owner to a private cause of action under tort or statutory tort claims. Abrogation deals with an abolishment of a law customer right. Instead, these decisions and controlling precedent relating to state action levels merely provide the threshold that a property must suffer with respect to alleged contamination before a duty is imposed, before a property owner can recover any type of damages. This is analogous to any other type of situation under negligence per se claim. It's not abrogation. It just simply is a modification of the duties and when a property owner can seek to recover for alleged damages due to contamination. Further, the appealers continuously cite to alleged Supreme Court case, Fifth Circuit case, Texas Supreme Court case, and a Houston Court of Appeals case as either rejecting or not or overturning Taco Cabana and its progeny. Similar to the appealers' assertion that this court has rejected Taco Cabana, it was also inaccurate for the appealers to assert that any of these cases rejected or overturned Taco Cabana and its precedents. The Supreme Court case dealt with a CERCLA situation where it was deciding whether CERCLA stripped the Montana State Court of Appeals of its jurisdiction. The Fifth Circuit case is basically even referred to these decisions as the controlling law in Texas and stated these cases involved situations where the state, Texas, had set the minimum levels of damages necessary to maintain a cause of action and trespass, like the appealers have here. In the Forest Oil one, Your Honor, again, the appealers continuously bring up this case from the Texas Supreme Court. It does not concern rejecting Taco Cabana or any of its progeny or its holding or any of that. It simply is relating to whether the Railroad Commission has exclusive or primary jurisdiction over that plaintiff's claims. And Your Honor can read that case a million times, just like we all have, and Your Honor will see that. In this Houston Court of Appeals case, the Houston Unlimited Metal Processing versus Mel Acres, that case, although referenced and cited Taco Cabana and some of its progeny, that case concerned whether ongoing presence of constituents exceeding stakes action levels was necessary in order to maintain a tort claim, not whether the decisions itself should be overturned or not. And regardless, that case and decision was reversed by the Texas Supreme Court anyways. So it's not even persuasive in this situation. Now, with respect to the state action levels themselves, in their response, and this is the second time the appealers have done this, they concede that Texas has set threshold levels for certain constituents of concern at issue. On page 13, they state, as to constituents for which the state has set thresholds, such as toxic metals. They concede right there are state action levels at issue in this case that the state has already established. And the Texas Risk Reduction Program, TURP, provides some of these thresholds for these relevant constituents of concern. And we talked about TURP earlier with respect to the taking over the underground storage tank statutes. They've also taken over and now regulate the industrial waste contamination as well. And as TURP states itself, its regulation and standards address releases of chemicals of concern, as defined by various programs subject to this chapter, including, like I just referenced, the chapter relating to industrial solid waste and municipal hazardous waste. And the adoption preamble for the TURP stated that it was being promulgated to move away from background-based evaluations, similar to what the appealers try to use here, to a risk-based process for determining cleanups. PCL levels is what they call them, protective concentration levels. And this is important because TURP does have a tiered process with respect to determining whether there's contamination and establishing these PCLs for constituents of concern. But TURP also provides, which is very relevant here, Texas specific median default values. And I'll turn to where those are provided. As this court can see on these highlighted items here, each one of these highlighted items are chemicals or constituents of concern the appealers are alleging have contaminated their property. This is from TURP's rules. There are state action levels for these constituents of concern, and the appealers need to show an exceedance of these in order to maintain tort or statutory tort claims for alleged contamination. And the appealers' claims about salts, it's nothing but a red herring. First off, if the court takes just a brief search of the appealers' live pleadings, it'll see a litany of these chemicals or constituents concerned that we just looked at, but it will not find is one reference to salt. Further, the peeler's own expert, Brown, notes there are threshold levels for salts or chlorides. And then another expert in this case, Mark Henningway, noted that one develops a PCL for chlorides in connection with salinity in soil under TERP. And the reason this is important is because, again, Sitton did not base her opinions on state action levels. She was specifically asked about it during her deposition. Are you saying that impacts exceeds state action levels? When she got asked about her definition of contamination, which was very general, she basically just talks about impacts from chemicals or something else. But when asked whether there needed to be an exceedance or whether her opinions were based on an exceedance of a state action level, she basically said no. Now, the peelers try to argue that by following Taco Cabana's precedent and its progeny would somehow be unfairly prejudicial to landowners. First off, it's not unfairly prejudicial just to follow the law. This is the law of the land as established by the San Antonio Court of Appeals. And second, it actually follows more fairly to have a regulatory scheme and state action levels that provide a uniform system for everyone in Texas to be aware of and follow, instead of subjective threshold levels that are just arbitrarily determined after the fact of alleged contamination or for litigation purposes alone, like we have here. And the peelers lodged some argument that a landowner would be at risk or additional risk of statute of limitations running. But the reality is that a contaminant of concern, constituent of concern, has to pass the threshold level under a state action level before harm's considered. And until that point, there's no harm. And until there's harm, the clock for statute of limitations doesn't run. So there's no additional risk of a statute of limitations running for a landowner. Now, going back to these opinions of contamination by Sitton or from her report, or alleged corroborating opinions or analysis relating to contamination. It's important to note that under Sitton's designation, as the court can see, there's no reference to her providing opinions on either conclusions about contamination or providing opinions and evidence that would corroborate contamination or widespread contamination on the Peeler Ranch. But even if this court accepts the Peeler's argument that Sitton's report and opinions is not about Sitton's testimony is not about contamination, well, then her testimony simply will not be helpful to her jury in this case. Sitton's report just provides written visual observations of what she sees from photos and maps. There's no commentary in the report about areas outside the mining lease. The only commentary about anything outside the plants or the mine area is maybe referrals to drainage channels or runoffs. Simply having somebody go up on the witness stand and state that they created a map, layered a map, and then testify about what that map says will not help a jury. A jury is more than capable of reviewing a map, seeing it, and seeing what the map says and making an evaluation based on those maps and layers itself. And I'll pull it up, Your Honor. This is just one of the layered maps that Sitton created. And it's Exhibit D that we provided in our reply for support. And here it is, Your Honor. This is the map. Now, Sitton did create a layered map, but what testimony will be necessary to explain to a jury? I don't know. The extent of contamination, well, if you just click that button right there that says extent of contamination, a jury can figure that out. If you click extent of remediation, a jury can figure that out. Does expert testimony, is it necessary to show where the buffer zone lease is? Is expert testimony necessary to show where the lignite lease boundary is? No. All that Sitton did was take information, document it, and create maps. And these might be helpful and useful for the peelers as demonstratives. They certainly do not need quote unquote expert testimony to explain what these maps say or these photos say. Your Honor, a picture's worth 1,000 words. It speaks for itself. They don't need added expert testimony for it. And if this court allows for Sitton's testimony to be offered against Kiewit Mining Group, it would be unfairly prejudicial because the peelers assert broad and indiscriminate claims about contamination, and that were resulted from disposal of coal ash and alleged other waste. And as this court asked earlier and we discussed, basically Sitton just makes this statement about widespread contamination in a report and then will assert on the witness stand that her maps corroborate this widespread contamination, but she fails to point out whose activities caused them. So they might have been caused by the prior mining operators, but Kiewit Mining Group's the last mining operator that was left standing when this case was filed. So Kiewit Mining Group would have the finger pointed at it. Further, it's clear from the peeler's response that they intend to use Sitton's testimony to establish Kiewit's proportionate share of liability. So it's clear that they're going to try to use Sitton's maps and her testimony to establish causation without any type of reliable basis or any type of methodology or any type of evaluation of how Kiewit Mining Group's acts or omissions caused that alleged contamination. Further, it would be unfairly prejudicial to allow Sitton's opinions because either her opinions herself are based on an improper standard, or she relied on improper standards from the peeler's other experts relating to a lower subjective standard with respect to contaminants of concern, constituents of concern, instead of an exceedance of a state action level, which is required by the controlling precedent of the San Antonio Court of Appeals for the court or for the peelers to maintain an action for tort or statutory tort claims against Kiewit Mining Group. And as a result, Texas Rule of Evidence 403 requires that Sitton's testimony be excluded, or there at least be some type of limiting instruction, Your Honor. Your Honor, that concludes, and if you have any additional questions, I'd be happy to answer it for the court.
Okay, not right now. Mr. Holcomb, anything else I know you didn't join in this, so nothing from your.
Yeah, Jennifer Friel here.
Friel, sir. Okay.
You hear me?
Yes.
No, we did not join in this one. We do have a pending motion for summary judgment on this state action levels issue. So won't be the last time you hear about it, but we chose to address it more fulsomely in a motion for summary judgment.
All right. Ms. Whittle?
Yes, Your Honor. Mr. Schneider didn't explain who Ms. Sitton is or what she does, so I'd like to do that first. The peelers have designated Mary Sitton, a certified mapping scientist, as an expert witness to provide historical aerial analysis of the San Miguel power plant and mine, as well as the affected peeler property, consistent with her recognized expertise in her field. She is expected to testify regarding historical development of the mine and the power plant based on available records on mine and power plant operations, historical aerial photographs, and geospatial data analysis. Kiewit alone has filed the motion to exclude Ms. Sitton, and Kiewit does not challenge Ms. Sitton's qualifications as a whole or her methodology with regard to her aerial analysis and creation of the layered maps, which are central to her opinions and the key purpose of her testimony. As I'll explain, Mr. Schneider's sort of dismissal of her expertise and what she did, claiming that the jury can do such a thing, is definitely without merit. Kiewit's motion is premised on two major arguments. First, Kiewit argues that Ms. Sitton should not be permitted to provide opinions about contamination on the peeler property to the extent those opinions are specific to Kiewit. But Ms. Sitton's testimony is highly relevant to Kiewit's liability because she is able to describe what the site looked like prior to Kiewit's tenure and how the site changed throughout Kiewit's tenure. Second, Kiewit argues that Ms. Sitton's opinion regarding contamination are unreliable or unhelpful in that her definition of contamination does not require exceedance of state or federal regulatory thresholds. As this court recognized at the hearing on the motion to exclude Paul Bowman, Kiewit is arguing a question of law as to the elements of the appealer's claims, not whether Ms. Sitton's expert opinion is admissible. Also, Kiewit is wrong on the law. In addition, Kiewit is wrong about Ms. Sitton's opinions. She is not opining on contamination. What she opined when asked in her deposition was, well, I think what I found corroborates the allegations, but she isn't testifying about contamination. They are the ones who asked her about it, and that wasn't what she was disclosed to testify about. Ms. Sitton is the president and an imagery analyst at Environmental Research, Inc., a geospatial company located in Linden, Virginia. She holds a certification as a certified mapping scientist from the American Society of Photogrammetry and Remote Sensing, along with 2 Bachelor of Science degrees in geology and business management for Radford University. She has approximately 36 years of experience in aerial photographic research, acquisition, and analysis, including years as an independent consultant for the Federal Environmental Protection Agency's Environmental Photographic Interpretation Center, or EPIC. She specializes in historical aerial analysis to support remedial investigations of hazardous waste sites. My first experience with Ms. Sitton was about 12 years ago when she served as an expert in a CERCLA case in which I was the lead attorney defending the United States liability for contamination at a former World War II Army airfield site. And her testimony was critical because she could show what was present on the site during the time of the United States tenure versus what was present on the site during the time of the subsequent owner's tenure, and show which tanks were located, where other infrastructure was located. She could show staining on the ground. She has a wealth of experience in this field and has provided deposition or trial testimony in over 10 cases over the last 4 years, testifying on behalf of a variety of clients, from insurance companies, a refinery, a landfill, and on multiple occasions, the United States of America. She has testified as an expert in state and federal court at trial on approximately 12 occasions, including both jury trials and bench trials, and has never had her opinions disqualified by a court. As the federal judge in El Paso Natural Gas Company versus United States, which was at 390 F Sup 3rd 1025, recently held, Ms. Sitton's testimony about the aerial photographs I find Ms. Sitton's testimony about the aerial photographs to be more credible than the other expert. She has significantly more aerial photography training and expertise than he does, and she obtained aerial photographs from public sources and reviewed them through a stereoscope. That is precisely what Ms. Sitton did in this case as well. Ms. Sitton's report contains an aerial photographic analysis of the Pila Ranch and the San Miguel plant and mine, based on a review of publicly available maps, as well as documents and ground photos pertaining to the relevant area, documenting changes between 1960 and 2018. In her report, Ms. Sitton explains the scientific process for importing the aerial photographs into the Geographic Information System software, which also includes digitizing relevant feature boundaries to create the digitized photographs and maps used in her report. She then analyzes the maps using a stereoscope that allows her to see in 3 dimensions, very highly detailed. She can zoom in on tanks, cattle, she can measure trenches and estimate volumes of piles. This isn't something a jury can do just by looking at an aerial photograph. As Ms. Sitton explained, these methods are commonly used in her field to assist in the investigation of environmental sites, and is relied upon by federal and state governments as well as private entities to assess environmental site conditions, identify contaminated or disturbed areas, or documenting historical activity at a site. She provides a detailed analysis in the form of a narrative timeline as well as the attached photographs and maps. Her narrative analysis is helpful to explain to the jury the changes that have occurred to the site over time. identifying features like construction, runoff areas, location of ponds, the presence of mounded material, potential or likely seepage areas, etc., which are visible in the layered versions of the maps using the stereoscope. None of her actual opinions or methodology are challenged by Kiewit, although based on Kiewit's testimony or argument today, it appears he didn't understand what she did. Instead, Kiewit complains about a line in the narrative of Ms. Sitton's report in which she states, the disposal of coal ash and other waste has caused widespread and significant contamination of groundwater, surface water, and soil within the Peeler Ranch. Kiewit argues that Ms. Sitton applied an arbitrary definition for contamination because Kiewit believes the peelers must be required to demonstrate the exceedance of a, quote, state action level to prevail at trial. But Ms. Sitton testified at her deposition that the sentence about which Kiewit complains was from the peelers' petition and not part of her analysis. Moreover, to the extent that Ms. Sitton's testimony corroborates the presence of contamination, her testimony is based on her sound methodology as well as her background and experience. Second, Kiewit complains that even if Ms. Sitton were permitted to testify about the presence of contamination generally, which she is not offered to do, she should not be permitted to present opinions specific to Kiewit, arguing again that a different standard of care should apply to Kiewit because it cannot be held liable without evidence of contamination exceeding an unspecified state action level. This, of course, is completely contrary to the argument that Mr. Schneider made earlier this afternoon on Meister, where he stated that any evidence relating to the breach of contract claim is still also helpful and relevant to our tort claims against Kiewit. Not only is Kiewit incorrect on the applicable law, it also appears to misunderstand the import of Ms. Sitton's testimony. Her opinions discuss the historical changes to the site over time and are not directed to any one entity. But her opinions about features present at the site prior to Kiewit's taking over as operator in January 2011 and during Kiewit's tenure, including the appearance of a coal ash piled on the Peeler Ranch at Pit 10 after Kiewit created a land bridge in the pit to facilitate the disposal, are relevant to Kiewit's proportionate share of liability. This court should decline to exclude Ms. Sitton's opinions related to how those features changed over time, which the jury may then use to render its findings. And I'd just like to share with you her maps so you can see how they look. Here, Your Honor, this first I'd like to show you, this is the language that Kiewit is objecting to. There's one sentence in her report where she says, she cites from the petition here, and then she says, the following is my analysis of aerial photographs, ground photographs, and maps spanning the period from 1960 to 2018. So she very clearly is not testifying, is not offering an opinion about contamination. Instead, she's basing an opinion that is based on her own sound methodology. And here, Your Honor, she explained this further. Ms. Creel asked her repeatedly if that was her opinion. She said, no, that sentence came from that document. My opinion is that the analysis and the photographs and the layered figures that I created corroborates that statement. So your opinion is that this statement here is corroborated by your analysis. That's what you plan to testify about? Answer, well, I intend to testify that the features and activities that I see in the aerial photographs and about the figures I put together. Question, well, you just told me that you think the figure corroborates the statement that's pulled directly from the pleading. So I need to know if that's what you're going to tell the jury. Are you going to tell the jury that this statement is corroborated by your work? Answer, no. I think I'm going to tell them what I see on the aerial photographs and the figures that I created. So Mr. Schneider did not show you her complete testimony where she repeatedly said, no, that's not what she's testifying about. So here, Your Honor, you can see this is historical aerial photograph from 1960, and it didn't fully load, but this shows what the site looked like on the Peeler Ranch prior to any activity by San Miguel. Then this aerial photograph shows as they were building the plant. This is 1979. And these are photographs to show what the site looked like prior to any activity. Here you can see the haul road is being built, and she can zoom in and in 3D see all kinds of very specific details about the site. So in 1983, she starts her analysis of what's happened over the site. You can see this is area A. Here's the plant. She's identified all the features of the plant. It's very hard to see at this scale, but using her equipment, you can see very high detailed images. You can see that mining began in area A, and this is the pit progression. And this is important because, for example, San Miguel's corporate representative testified at first that mining had not started on the Peeler Ranch until after 1983. Well, that's obviously not true. And that's one of those, one of the types of things, ways in which Ms. Sitton's testimony is used in these kinds of cases. Often you will have one potentially liable party say, oh, well, they had mining activity prior to our joining, are operating the site, and so they're really responsible. And being able to look at what the site looked like at a specific point in time can help a court or a jury delineate proportionate share of liability based on features that are present during that operator's tenure. So here, this is what the site looked like prior to Kiewit's tenure. So Ms. Sitton's opinions are clearly relevant to Kiewit's liability because she can say what was here prior to Kiewit arriving. And this is pit 10, Your Honor. And over Kiewit's tenure, they built a land bridge, and then San Miguel pumped water from one side to the other of the pit, and Kiewit filled part of the land bridge, part of the pumped area of the pit with ash. And that ash is what is now exposed and mixed with water and precipitation and runoff. And Anthony Brown will testify about the mechanisms by which that ash and contaminated wastewater have caused harm to the ranch outside the permit boundary, which is, and the lease boundary, which is what Kiewit's liability would be about. So this shows in 2012, they're beginning to build the land bridge. You can see that they have completed mining in area A, west this area, and they're working in this area A east. Then she shows what happens in 2014. And there are other photographs as well over time. I'm just showing you some of them so you can see how her opinions would be relevant to Kiewit, because they show what the site looked like before Kiewit arrived and then after Kiewit left the site. So here in 2016 was the last year when Kiewit was placing ash on the Peeler Ranch, and then also placing ash in this area of Area A, which also has mixed with coal ash and mixed with wastewater and caused harm to the Peeler Ranch. And then this is a photograph of what the site looked like in 2018. And she can measure these piles, she can estimate the volume. There's all kinds of useful information that she has been able to find from her analysis of these aerial photographs. Now, this is what Mr. Schneider was sharing with you. She has also created a layered image based on various documents. So for example, these are the peeler payment areas, the only areas for which San Miguel is making payments to the peelers on now. And this is based on a map that Dave Burris, the San Miguel fuels manager, provided to the peelers. She also shows the rights of way. So these are the rights of way that San Miguel claims it needs in order to operate the mine and the plant. And these rights of way exist even without the lease. So San Miguel can continue to have access. And this is obviously important to San Miguel's breach of contract claim against the peelers because these rights of way exist with or without the lease. She also has information about peeler ownership based on all of the deed records. And this is obviously very relevant to the case. She was able to locate the sampling waypoints, groundwater monitoring wells. She identifies the ponds. These are all very, very relevant and important features. These are the oil and gas wells. And she located this based on her expertise. This is not something a jury could just figure out or someone could just draw without her level of expertise and review of documents. This shows where the ash disposal has occurred on the site. So this is the area where Kiewit has disposed of ash. And I think you're likely to hear San Miguel argue, and I believe they have argued in the motions to exclude, that this area of disposal, tract 1, and this area of disposal, tract 5, is not what has caused the harm to the ranch. It's these areas of disposal, which Kiewit did, and which remain open and mixed with water. This shows the permit boundary, so you can see where the permit ends. And then it also shows the lease boundary, so that when we're talking about, you know, what claims remain, these are the within the lease boundary versus within the permit boundary. This is very helpful for all of that. This also shows the mine boundary. So the way she has created this map is very useful, very helpful, and based on her experience. This is also a map that Mr. Schneider has pointed to. This is more of a demonstrative map. This is one where she created it based on Mr. Brown and Mr. Johnson's view of where the contamination is and where the remediation is. But she created the map using her expertise with their input. So again, Ms. Sitton was adamant that, number one, the sentence regarding contamination at the Peeler Ranch was based on the allegations in the petition. And number two, her testimony was based on what she saw on the aerial photographs and the figures she created based on the data available to her. And of course, Kiewit's fixation on Ms. Sitton's statement quoting the Peeler petition is curious, considering that the experts on both sides of this litigation have confirmed the presence of contamination on the Peeler Ranch. That isn't really a question. So the dispute is really about how extensive that contamination is and what to do about it. So Ms. Sitton's statement should not be considered controversial. In any case, Ms. Sitton has the training and background to identify potential sources of contamination and can rely on the opinions of others. As Ms. Sitton explained in her deposition at page 73, her work requires her to research and acquire the aerial photographs and analyze those photographs, and I document what I'm seeing. As for identifying potential sources of contamination, she stressed that her work is not speculative, as Kiewit suggests, but rather based on her training and experience. She testified at pages 15 to 16 of her deposition that based on my background and training, not only at ERI, but prior to that, I've been trained to analyze features and activities that are potential contamination sources at a variety of different sites, landfills, industrial facilities, and refineries. And so that includes a lot of different things. It can be releases to the river, it can be staining, it can be disposal of debris or other materials, impoundments, releases from tanks and drums. Ms. Sitton repeatedly explained in her deposition that while she did not perform any water or soil sampling herself, she relied upon and incorporated into her layered images the sampling information provided by Aqualogic, another expert firm retained by the peelers. So to the extent her testimony that her analysis corroborates the statement regarding potential sources of contamination, Ms. Sitton explained that her testimony would be to explain the photographs and the figures she created based on the available information. And that's well within her expertise and consistent with the types of opinions she has given in federal circuit cases in which she has discussed the location of infrastructure, mining operations, or progression of ground conditions over time as they relate to contamination. Courts consistently rely on Ms. Sitton's testimony to determine liability for contamination based on the nexus of infrastructure present during certain periods of time with the present evidence of contamination. And I'll just share some of these opinions with you, Your Honor. Sorry. That was not. Okay. Not letting me share what I'm trying to share. Hold on one second. Okay, here, Your Honor. Okay, here, Your Honor, is the Raytheon aircraft decision. In this case, the plaintiffs, Raytheon Aircraft Company, tried to move to exclude Ms. Sitton, and the court described that what Ms. Sitton did. She analyzed and interpreted aerial photographs of the site and concludes, based on that analysis and interpretation, that the timing of contamination can be determined. And she opines that the contamination occurred during Beach's operations at the site. He declined to exclude her, and in his final opinion, he ruled that the United States was not liable for any of the contamination at the site. And he relied on Ms. Sitton's opinions. He said, this conclusion, as explained below, is further supported by the location of the source areas of TCE contamination, as well as numerous plausible mechanisms of release at those source areas, all of which are consistent with the location and operation of Beach's vapor degreasers. So he considered where the contamination was located and then whose operations most likely caused that contamination based on her analysis of the aerial photographs. The El Paso court, likewise, this is a 2019 case, held that her work about her expert opinion and analysis of the photographs identified where trenches were and that they were not present prior to 1954. And so therefore the court was able to delineate liability at the site based on what was present at the site. And this is where he says that her testimony is more credible because of her significant experience and training. Sorry, Your Honor, having. So clearly, Ms. Sitton is an expert in her field and should be permitted to testify, particularly when Kiewit has not articulated a basis for her exclusion. Again, Kiewit incorrectly argues that the peelers must demonstrate an exceedance of an unspecified state action level caused by Kiewit, and that somehow this is a basis of exclusion for Ms. Sitton. I think it is worth pointing out that in all the CERCLA and RCRA cases where courts have found Ms. Sitton's testimony to be very helpful and reliable, those cases did concern regulatory limits. So her expert testimony connecting her historical aerial analysis with present-day contamination in multiple federal CERCLA cases around the country demonstrates she possesses the required expertise to testify even when regulatory action levels are the applicable standard for liability. So even though that isn't the standard in this case, her particular expertise is relied upon in regulatory cases all the time, and in many cases carries the day. We have demonstrated in our briefing that Kiewit is incorrect as a matter of law, but most importantly for this motion, Kiewit's argument is of little relevance with regard to Ms. Sitton's testimony, which concerns the historical development of the mine and plant areas. Kiewit's position, which essentially argues that there can be no tort liability in the absence of negligence per se, fails for numerous reasons. Some constituents, such as salt, in the form of total dissolved solids containing inorganic salts of calcium, magnesium, potassium, sodium, bicarbonate, chloride, fluoride, and sulfates, do not pose a severe enough risk to human health or the environment such that any regulatory agency in the state of Texas has set a safety threshold. And yet, the presence of these compounds plainly can injure property. As the court has already heard in this case, salts emanating from coal ash unquestionably have caused significant damage to the Peeler Ranch. And this damage is no less real because the state has not elected to set safety thresholds for those chemical constituents. This isn't a situation where there are thresholds that we have failed to meet. Instead, there are no thresholds, which is exactly the situation as the Fifth Circuit case that we cite in our briefing. As to constituents, which the state has set a regulatory threshold for human health, such as toxic heavy metals, antimony, arsenic, barium, beryllium, boron, cadmium, chromium, cobalt, lead, lithium, mercury, molybdenum, selenium, and thallium, elevated levels that fall under the designated state action level for human health may still reduce the value of the property, and that reduction in value is compensable in tort. Moreover, in this case, the toxic heavy metals emanating from coal ash are bioaccumulative, so the state thresholds are explicitly inapplicable, and I'll show you that language, Your Honor. And notwithstanding Mr. Schneider's argument today, Kiewit's premise has been rejected by the United States Supreme Court, the Fifth Circuit, the Texas Supreme Court, and the Houston Court of Appeals, all of which have held that private landowners have separate common law rights that are not dependent on the standards of regulatory compliance. The law is clear. In Texas, a private property owner may recover in tort for the introduction of waste contamination that has caused property damage or diminished the property's value, regardless of state regulatory safety thresholds, especially where no such regulatory threshold exists for the chemicals of concern, which they don't here. Consider, for example, a products liability case about a defective vehicle restraint system, for example, the lack of a head restraint. The way the government standards work, the vehicle has to be designed to be at a minimum of what the government requires. The restraint may comply with the minimum standards, but a jury may still find it's designed to be defective and the manufacturer to be negligent. A plaintiff can still maintain a case for negligence even if those minimum standards were met. And another example, just because someone is driving the speed limit doesn't mean he isn't responsible for running over a kid on a bike. Put simply, the common law duty not to harm private property with waste contamination has not been abrogated by statute or regulation in Texas. And despite many pages of briefing dedicated to this argument, Kiewit has not been able to point to any such statute or regulation. Kiewit's erroneous position regarding the relevance of regulatory pollution thresholds to private liability relies on inopposite cases that considered a narrow, limited situation. Liability of the prior landowner for pollution from underground storage tanks at sites that were already subject to Texas cleanup orders. The theories of liability were negligence per se and trespass based on a duty to remove chemical constituents, both of which clearly implicated the regulatory thresholds explicitly set out by the state. But these cases have nothing to do with Kiewit's polluting activities on the Peeler Ranch. And post-forest oil, they have no lasting relevance, especially since the regulatory program they relied on as abrogating the common law no longer exists. As the Forest Oil Court held, a statute's express terms or necessary implications must indicate clearly the legislator's intent to abrogate common law rights. The forest oil holding is consistent with longstanding law that compliance with a regulation does not absolve a defendant of tort liability. Contrary to Kiewit's contention, the Taco Cabana and Yarborough courts did not broadly hold that a plaintiff may never prevail against a defendant for contamination of the plaintiff's property with ongoing presence of constituents exceeding state action levels, but instead determined that in the context of the Texas Water Commission's regulation of an underground storage tanks, the state's comprehensive regulation program was relevant to establishing reasonableness of contamination levels and the prior landowner's cleanup duty. There is no regulatory action level under any state program for the main constituents of concern, salts, that are the limiting factor in remediating the impacted property back to appropriate grazing land for cattle. Nor is there any regulatory action level for any bioaccumulative metals that have also harmed the Peeler Ranch by leaching from coal ash and wastewater. In fact, Kiewit has pointed to no actual regulatory threshold or even a specific regulatory program that it contends controls. What Mr. Schneider showed you today was a TERP table for soil limits that are with respect to human health. The Peelers have not alleged that there are human health problems as a result of the contamination on their property. Neither Taco Cabana nor Yarborough apply here, particularly to the question of whether Ms. Sitton's testimony should be excluded. Finally, Kiewit's position would unfairly prejudice landowners. A landowner whose property was subjected to repeated releases of contaminants would be forced to wait until the harmful chemicals accumulated enough to exceed state action levels before he could assert trespass or negligence claims, which potentially would occur only after some or all of the resulting causes of action were barred by the statute of limitations. Similarly, an alleged polluter could inflict significant harm, but entirely escape liability by ceasing pollution just before the harm crossed the state action level. Requiring an accumulation of property contamination over time could place landowners such as the Peelers in a no-win situation if their claims are unripe when contamination begins, but allegedly past the statute of limitations by the time the contamination meets a regulatory threshold, which in this case is unspecified and non-existent. In fact, Kiewit is attempting to do just that, arguing the Peelers are simultaneously both too early and too late to bring their claims. They filed a motion for summary judgment on statute of limitations grounds that this court will hear in the new year. Accordingly, not only does Kiewit's threshold position have no support in tort law, it would inflict a patently unjust outcome on landowners such as the Peelers, whose land has been subjected to gradually accumulating pollution. Not only that, but Kiewit's position requiring the exceedance of a state action level would be contrary to the applicable law for risk-based regulatory causes of action. CERCLA and RCRA and their state counterparts either specifically do not have statutes of limitations or go so far as to preempt any state statutes of limitations. The Fifth Circuit in Burlington Northern versus Pool Chemical at 419 F 3rd 355 noted that CERCLA was amended to preempt state statutes of limitations because many state systems were inadequate to deal with the delayed discovery of the effect of a release of a toxic substance. And the United States Supreme Court in CTS Corp. Versus Waldberger at 573 US 1 held that CERCLA's discovery rule preempted any contrary state statutes of limitations. CERCLA or RCRA cases are commonly brought at sites with decades of pollution-causing activity, often with multiple operators or owners of the affected property over time. Unlike those instances, private landowners, such as the Peelers, are not protected from a statute of limitations defense in the manner that the state or federal governments could be, and therefore their lawsuits must be brought in a timely manner even before the contamination has exceeded a risk-based regulatory action level to the extent one exists. It would be patently unfair to apply those risk-based regulatory thresholds, which were meant to apply in circumstances without statutes of limitations, to a common law tort case where limitations do constrain a plaintiff's ability to seek relief. With respect to Kiewit's request for a jury instruction telling the jury not to consider Ms. Sitton's testimony against Kiewit, the court should deny the request. Ms. Sitton's testimony will assist the jury in understanding the historical timeline of events based on aerial analysis of photographs over time. In fact, Ms. Sitton was specifically asked this question regarding Kiewit's specific opinions at her deposition and testified, "I don't think I specifically called out who did what where. I just identified what was occurring over the site at the site over time. And I did not specifically say what operator. I didn't call that out, no." But other deponents, specifically Kiewit's corporate representative and expert, Simon Zulu, will testify that Kiewit built a land bridge at Pit 10 and disposed of coal ash at Pit 10 and Pit 8. Pit 10 is on the Peeler land and Pit 8 is on San Miguel land. And Peeler expert Anthony Brown will testify that the disposal of coal ash in those areas has caused contamination of the Peeler Ranch outside the lease boundary. So an instruction limiting the jury from considering Mary Sitton's testimony will deprive the Peelers of a link in the chain to demonstrate that it is more likely than not that Kiewit's conduct proximately caused harm to the Peeler Ranch. Ms. Sitton's testimony will assist the jury in understanding how the Peeler property changed over time and will help identify features like mounded material, depressions, water features, seepages, excavations, etc., through her training and expertise and how those features changed during Kiewit's tenure. So we asked the court to reject any argument that her testimony should be specifically excluded as to Kiewit. And just as a last thing, Your Honor, I'd like to share with you the actual TERP documents that note that there are no state thresholds for the constituents at issue. So here, Your Honor, these are the actual TERP tables, which are on the TCEQ website. And here, all of the compounds that are considered salts have an asterisk on them. When you go to the table, there's no threshold and there's an asterisk. And then you come to this table and find the asterisk, what the asterisk means. And it says these compounds, and it lists them, including the calcium, chloride, sulfates, sodium, potassium, those are the salts at issue in this case, are not necessarily of concern from a human health standpoint. Therefore, calculation of human health-based values is not required. However, aesthetics and ecological criteria would still apply. In other words, there's no state regulatory threshold. Instead, an operator under a cleanup order from TCEQ would have to develop a cleanup standard for those based on a site-specific analysis, which is what our experts did, following the exact same methodology that San Miguel's expert did for the program they're instituting around the power plant. And here, Your Honor, for the metals that are at issue, this document, which is conducting ecological risk assessment guidance from TCEQ, also on its website shows that Mr. Schneider's table that he presented to you for the human health risks is also not relevant to this site. As TCEQ has found with TERP, for all the chemicals of concern listed in table 5.1, which lists all of the metals, bioaccumulative metals at issue in this case, as well as those retained through benchmark screening processes, are subject to further evaluation, assuming they are detected at concentrations greater than background. And again, they have to be present above background concentrations. So our experts, the peeler experts, have evaluated what contaminants are present above background levels. And those are the ones that would have to be cleaned up under the TCQ guidance. And so there are no actual state regulatory thresholds. This whole argument is based on something that simply doesn't exist. So thank you, Your Honor, that's all.
And let me ask this to clarify. I think I understand the answer, but Ms. Sitton did not go through and analyze aerial photographs and say that, oh, I can tell that because the grass is a different hue in this area than in another area, that there's been contamination in one of these areas?
No, Your Honor.
She produced a map where it said contamination, where it's demonstrative of other experts' work?
Yes, Your Honor. Her opinion is not based on that. She created it based on other experts.
Okay. All right, Mr. Schneider, or maybe Ms. Friel?
Your Honor, we have nothing to add.
Okay.
Your Honor.
See you on Thursday?
If I may briefly.
Oh, yes, I'm sorry.
No, yes, Your Honor. I'll be brief since it's close to 5. But with respect to the comment or question that you just had, Your Honor, that's correct. Sitton did not look at these aerial photos and say this change here is evidence of contamination, and this is evidence of Kiewit Mining Group's actions or missions that resulted in contamination. Nevertheless, as shown in her deposition testimony and as being asserted here today by the peelers, it will nevertheless be used as alleged evidence of Kiewit Mining Group's liability. The peelers are talking out of both sides of their mouth here. In one instance saying Sitton is not going to be providing opinions about one specific party or entity, but then claiming that her expert testimony can be used to establish liability, particularly Kiewit Mining Group's liability, because of how the site has changed during Kiewit Mining Group's tenure. But first off, nothing in her report mentions that she's going to offer any testimony about Kiewit Mining Group's liability or how Kiewit Mining Group caused these changes, or these changes were caused on Kiewit Mining Group's watch. And there's nothing within her designations saying that she's going to offer this kind of testimony. And although Sitton's maps may be able to show these changes at times on the Peeler Ranch, such maps and photos cannot say what caused these changes or whether these changes were caused by Kiewit Mining Group, one of the other mining contractors' actions that are now just emanating to the point of that year, or whether it's one of the other parties or one of even the peelers themselves' own actions. Sitton cannot provide those opinions, but apparently she's going to provide opinions that her photos and maps corroborate that analysis and conclusion that there's contamination caused by Kiewit Mining Group and the other defendants and counter defendants in this case, Your Honor. And with respect to Sitton's analysis essentially consisted of reviewing photos and maps to generate these maps and layers. And I don't mean to dismiss the actual generation of these maps. I'm sure a lot of work went into the generation of these maps and these layers, and these will make probably good demonstratives for the peelers. But expert testimony is not necessary for Sitton to explain how she created these maps or what's shown in these maps. And the use of equipment to zoom in does not qualify somebody to provide expert opinions. An attorney, while looking at these maps, can zoom in and show these photos. I thought Ms. Whittle did a fantastic job today of showing these maps and explaining where the haul road was, or the ponds were, or the location, or even what the site itself looked like before Kiewit was there, or what the site looked like after Kiewit was there. With respect to just the one map she showed earlier when Kiewit, before it got on there, this is the map she showed. It doesn't take any expertise to zoom in and show what these are. She has a pond here that she put in. I'm positive she put in a lot of work to do this. But an attorney will be able to do this just as well as a demonstrative. It will not take expert analysis or testimony to perform that task during trial. And with respect to the contamination conclusions by Ms. Cnty, if a party can't rely on statements within an expert's report to being part of their opinions, how is a party able to understand that's their opinion or not? It's in their report, and that they're saying, particularly a statement like there is widespread and significant contamination. And regardless, it's splitting hairs here, even if she didn't really mean what she said in her report, but instead meant to say that her maps corroborate that. It's nevertheless, she can't testify to that as an expert. She can't testify that on all the reasons that we listed earlier, because it wouldn't be reliable. It'd be unfairly prejudicial. And with respect to the cases that Ms. Whittleman—
Did she state in her deposition that she was not testifying to that as an expert? That is that quote that she put into her report from the petition?
The quote that she put in her report from it, what she said, Your Honor, was that was not her opinion. But we weren't able to know that until her deposition. And then during her deposition, although she walked back from that comment, she then stated, no, that might not be my opinion. My opinion is my analysis, my photos, my map corroborate that statement. That's splitting hairs, Your Honor. Basically saying, oh, my statement, that's not my statement, so that's not my opinion. But my opinion is my maps corroborate that there are widespread and significant contamination. Simply put, Ms. Cnty did not perform the requisite type of investigation, evaluation, or the type of reliable type of items to be able to offer that corroborative opinion, and certainly not to the widespread alleged contamination being the result of Kiewit Mining Group's activities. And again, Your Honor, with respect to the cases from the U.S. Supreme Court, Fifth Circuit, the Court of Appeal, Fifth Circuit Court of Appeals, Houston Court of Appeals, and the Texas Supreme Court, we have gone over those, and I've shown the court those cases before in the language of those decisions. I summarize them in my PowerPoint. I invite the court to review those decisions and those holdings, and Kiewit Mining Group is confident that the court will read those cases properly as not having those holdings that the peelers are trying to inject into them about rejecting Taco Cabana, just like the peelers tried to inject into the court's question during the October 20th hearing, a simple question of whether it was a question of law, whether it was required to have an exceedance of a state action level to necessarily maintain a tort or statutory tort claim. The peelers read in the court's rejection of that argument, and by simply asking a question, they are likewise reading in what they want to read into those decisions as well. And those holdings do not contradict the controlling precedent of the San Antonio Court of Appeals from Taco Cabana and its progeny, Your Honor. And for those reasons, this court should exclude Cnty's testimony from being offered against Kiewit Mining Group, Your Honor. Thank you.
Okay, and what do we have up on Thursday?
Your Honor, we have two motions to exclude. One is it's Kiewit's motion to exclude Dr. Lauren Ross, which is essentially a reiteration of all of these same arguments. And then we have moved to exclude San Miguel's expert, Mark Hemingway.
That's correct, Your Honor.
Are there any testifying experts that have not had a motion to exclude or limit their testimony filed against them?
Yes.
Okay.
There were
just one.
I think there were two.
Okay. All right. Well, we'll see you all Thursday, and I just posted a link. So if people who are going to be trying this want to be able to practice saying all of the chemical names in front of the jury, click on that link, and a Harvard grad named Tom Lehrer can tutor you on that. All right.
Thank you, Your Honor.
The host right now, Ms. Riley, is, but I'm going to leave. Everyone is excused.
Thank you, Your Honor.
Have a nice evening.
Bye, Lachey. See you tomorrow. I'm waving to you, but I didn't have my screen up. Take care.